Muslims, parties are Muslims. These are all the things, my lord. I will request only issuing of notice for the present, my lord. So that there may be chances of settlement.
All right. Learned AGA is directed to accept notice to respondents 1 to 5. Issue emergent notice to respond number 6. Yes. Next.
Petition. Notice in 2010 under 136 sumoto proceedings.
So moto.
Yes, my lord. I am brother of the same survey number. In respect of my brother, the order is passed in 2007, which I have produced it in another. The lordship would find in on 15/7/2016, the order is passed, holding that the grant is proper and legal. After about the lapse of 8 years, my lord, in spite of about 20 reminders appearing before the authority, no order is passed.
Now, this second inquiry is on same set of facts.
One property, two names. My and my brother name was there, my lord. My brother's order is already passed. As far as I am concerned, the no order is passed for the last about 8 years.
And under the same grant list.
My father was granted 4 acres, my lord. I got 2 acres, my brother got 2 acres.
Now 2 acres, there is a quietus. They have held that grant is.
Back on 2016.
Now, original grant is to your father.
Yes, my lord.
Yes, madam.
Secure instruction.
Why you want to secure? You want to secure instruction?
Yes, my lord, because
It's a mandamus. Let him examine it. See, 4 acres is granted to original grantee.
yes,
What's his name?
My
Father's name?
brother's name is.
Yeah, your father's name. Your father's name.
Munshama.
now
Then
2016
after his demise, you succeeded to 2 acres there.
He executed a will, 2 acres to me and 2 acres to my brother.
So in an inquiry against your brother, they hold that this grant is genuine. Where is that order?
Page number 35. I produced the certified copy for lordships. Page 35.
Fine.
Barkodri. What is this, madam?
ಅಲ್ಲ 2016 ಇಂದ ಏನಾಗಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ ಅವ್ರಿಗೂ
ಏನಿಲ್ಲ, I am
ಗೊತ್ತಿಲ್ಲ
appealing for
That's
the
why.
authority, nothing else.
ಏನಾಗಿದೆ ಅಂತ
ಏನಲ್ಲ ಏನಾಗತ್ತೆ
ಆರ್ಡರ್ ಗೆ ಪಾಸ್ ಆಗಿದ್ರೆ ಆಕ್ಸೆಪ್ಟ್
ಆಯ್ತು ನೀವು being spoken to ಹಾಕೊಳ್ಳಿ. Barkodri. Caption petition is filed. Seeking a mandamus against second respondent / deputy commissioner to drop the proceedings initiated under 136(3) of Land Revenue Act by taking cognizance of the order passed by the second respondent deputy commissioner in number so and so, dated so and so, wide annexure H. Next, the counsel for petitioner, order sheet Leonard AG is directed to accept notice. The short point that needs consideration is as to whether second respondent deputy commissioner is required to drop the proceedings initiated against petitioner under 136(3), having passed in order in number so and so, dated 15/7/2016. Next, ma'am. Subject matter of the land is survey number 46/3, capital P1. This land was granted to one Munishamappa, who is the father of the petitioner herein, while the grant order dated 5/4/1946. Original grantee Munishamappa bequeathed this land to the petitioner and his brothers to an extent of 2 acres each. Deputy Commissioner, second respondent Deputy Commissioner initiated inquiry against the present petitioner as well as against his brother to examine the genuineness of the grant. Deputy Commissioner, while annexure H on inquiry has found that the grant made in favor of petitioner's father is genuine. The operative portion would be relevant, and therefore this court deems it fit to extract the operative portion in the said order. The same reads as it done. On examining the order passed by second respondent deputy commissioner, evidence that annexure H, the genuineness of grant of petitioner made in favor of petitioner's father is duly inquired by second respondent deputy commissioner, and the deputy commissioner, after due inquiry, has found that the grant made in favor of petitioner's father is genuine. If the grant made in favor of petitioner's father is duly inquired, in petitioner brothers proceedings initiated under 136(3), the present proceedings questioning the very grant, wherein the very grant is subjected to inquiry, cannot be kept pending. Petitioner has the legal right to seek dropping of the proceedings in the light of inquiry concluded by Special Deputy Commissioner. Equally, second respondent is obligated to give a closure to the present proceedings in the light of order passed in number so and so dated 15/7/2016, evidenced at NHRH. Therefore, this is a fit case where a mandamus lies. For the foregoing reasons, this court passes the following order. Writ petition is allowed. The second respondent, Deputy Commissioner, shall take cognizance of the order passed in number so and so, evidenced at NHRH, and shall accordingly proceed to pass appropriate orders by taking note of the observation made by this court supra. Next, this exercise shall be accomplished by second respondent Deputy Commissioner within a period of 4 weeks from the date of receipt of order. Yes, next. Yes, sir. Mandamus. Yes, madam.
Directing the respondent for place the application submitted by the petitioner at Annexure C. Application is Annexure C.
Application under what provision? 50, 53, 50. Yes, madam.
Already covered similar matter was disabled for passed an order.
Yes, madam.
ಋತುಜಾಲ.
ಏನಾಯ್ತು?
Similar error matter order. Deputy number.
You don't have the file? File ilva? Shall I post it on Tuesday? Only seeking mandamus. It's only
Actually, they have sent, sorry, my lord, they have sent that their application came to be rejected.
Rejected.
Forgotten to take that
You're already,
order.
all right, we'll have it on Tuesday then.
Yes, ma'am.
Work order. Learned AG on instruction submits that petitioner's application is considered and same is rejected. She needs a short accommodation to place it on record. The rejection order passed by the committee. At her request, release this matter in preliminary on Tuesday. Work order. AG is directed to accept notice to respondents. Next. 5. Yes, ma'am.
My lord, in this case, my lord, I called to Tahsildar, my lord. He'll come with the records on Tuesday, my lord. Tuesday, it may be kindly apt on Tuesday, my lord.
This matter, already they have seek 3.
Hold on, Durust, my lord. there.
Madam, it's a 2024 matter.
I produce a document before your lordship where.
I'll hear you.
ADLR
We'll hear you on Tuesday. Madam, we'll hear you on Tuesday.
This document.
What is the
where
document?
ADLR has already direct by its intimation letter but dated 29/8/24. ADLR has already directed the Tahsildar.
No.
Sketch ಮಾಡಿ ಕೊಟ್ಟು, but subsequently after filing of the case.
Oh, the previous days matters.
Yes, ma'am.
Same matter, Allah.
Yes,
Pass
ma'am.
orders on
Yes,
Tuesday.
ma'am.
Tuesday.
ADLR already written a letter
Okay,
to
no,
the
no.
Tahsildar, my lord. He'll
Okay.
come with the records, my lord.
All right. At the request of learned AGA, by way of final indulgence, this order is, this matter is ordered to be relisted on Tuesday in preliminary. Yes. Tuesday. Yes, Uday.
It was decreed expanded. Sequently, finally, for all the parents. Both preliminary decree as well as final decree was assigned before the son of the court, and the son of the court was pleased to set aside both the decrees and was pleased to remand the matter to the parent. In the meantime, my lord, despite there was a stay, any record came to be related to the names of respondent before and paid. Pursuant to the judgment of the son of the court.
Second is to the
Petitioner has
Advocate.
been petitioned to restore the increase in the name of the petitioner. That applications are not being considered by the.
Why it is remanded by this court? Prelim decree is set aside.
Decree has been set aside, my lord. It's a ex parte decree, my lord. It has been set aside and remanded back to the trial court to reconsider the matter. Therefore, now they are.
The relationships
change of
are in
terms.
dispute.
Let it be.
Here the purchasers, petitioners are the purchasers, purchasers in the year 1995.
When the suit is filed,
Year 2007, 12.
95 sale, and suit is filed in 2012. Entire extent? There are other properties,
No, my lord, only one property. They have,
the only one property.
Only one property, madam.
All right, take notice, we'll see. Purporting. Learned AG is directed to accept notice to respondents 1 to 3. Issue emergency notice to respondents 4 to 6.
Please.
Yes. Mandamus. Grant, based on grant,
Property is dealt through family settlement.
families.
It stands in.
It's a patta land. It's a patta land, yes.
ಹೋಗಿದ್ರಂತೆ ಸ್ವಾಮಿ ಹೋಗಿದ್ರೆ ಅಲ್ಲಿ ಯಾರು ಇರ್ಲಿಲ್ಲ ಅದಕ್ಕೆ ಅವ್ರು ವಾಪಸ್ ಬಂದ್ರು ನೋಟಿಸ್ ಕೊಟ್ಬಿಟ್ಟು ಹೋಗಿದ್ರು. Let the date may be fixed. Let them appear as and when they receive notice.
You were not there when the authorities had gone.
You were there.
You were there.
That is
Work
what I-
Respect of two survey numbers.
2 survey numbers.
Next is J and J one.
You want 4D based on what? 4D is based on what?
Entire extent is, belongs to the family of the petitioner. Manoj. And some of the extent has come to the state of petitioner.
Partition.
Through family settlement.
Through family settlement.
Ah. So other portions are held by other co-owners.
RTC stands in my name.
Stands in your name, along with other co-owners.
So much. RTC, in RTC it has been shown. Manoj.
Separate RTC is issued to you.
It has been shown separate.
Yeah, ಹೋಗಿದ್ದಾರೆ ಸ್ವಾಮಿ ಮಾಡ್ಲಿಕ್ಕೆ ಹೋಗಿದ್ದಾರೆ. Let them one more opportunity.
Work out.
J
Learn-
and J one.
Ah,
Applications is at page 48 and 49.
G and J1, work out. Learned AG is directed to accept notice
1 to 5.
are the 1 to 5. Are the counsel for petitioner and learned AG. Facts leading to the case are as under. Subject matter of the land is survey number 164, capital B measuring 1 acre 21 guntas. And survey number 165, capital B measuring 33 guntas. Both situated at Gullagatti, Madavali Taluk, Mandya district. Petitioner asserts that the petition lands are ancestral properties of petitioner family. Petitioners claim that one Linge Gowda transferred the petition property lands with other properties in favor of his daughter-in-law, namely Subbamma, through family settlement executed in 1956. Petitioner further contends that after demise of Shivalingayya, eldest son of Subbamma, ಯಾರಿಗೀಗ ಫ್ಯಾಮಿಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಯಾರ ಪರವಾಗಿ ಆಗಿದೆ ನೀವು?
Manoj, Shivlingaya is the eldest son of Subama.
ಆ?
Thereafter, Subama, with consent of other members of the family, she has given it to the petitioner.
How?
Parrot.
How she has transferred?
ವ್ಯವಸ್ಥಾ ಪತ್ರ ಅಂತ ಅಷ್ಟೇ MR ಅಲ್ಲಿ entry ಇದೆ. You produce the MR.
They said Subbamma with the consent of other owners,
Manoj, to Subama. Manoj,
ಫ್ಯಾಕ್ಸ್ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಬರ್ದಿದ್ದೀರಾ ನೋಡಿ, ಅದು ಎಲ್ಲಿ ಬರ್ದಿದ್ದೀರಾ, ಏನ್ ಬರೀತಿರೋದು?
Manoj, Shivlingaya.
ಫ್ಯಾಮಿಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ಶುಭಮ್ಮಗ್ ಹೋಯ್ತು, ಪ್ರಾಪರ್ಟಿ ಡಿವಾಲ್ಡ್ ಆನ್ ಶಿವಲಿಂಗಯ್ಯ ಅಂತ ಬರೀತೀರಾ ಹೇಗೆ?
Manoj, Shivlingaya is the eldest son of Subama. Thereafter,
ಬರ್ಕೊಡ್ರಿ.
Shivlingaya.
Next paragraph.
Nagam.
Petitioner further asserts that after demise of Subbamma, the property devolved on her eldest son Shivalingayya. And Shivalingayya has accordingly transferred the property to his wife Lingamma alias Nagamma. He said Nagamma, with consent of her family members, has transferred the property to petitioner hearing. Though petitioner's name is repeated in RTC, petitioner intends to secure a 4D and accordingly representation is submitted.
Online.
An online representation is submitted by petitioner. Evidence that annexure J and J1. Next, petitioner is aggrieved by the inaction of respondents in not conducting a survey and effecting 4D. Learned AGA on instruction submits that those survey authorities visited the land to effect 4D, since the interested parties failed to participate in a survey, the survey was not concluded. Learned AGA would further point out that in the event petitioners participate in the survey, the authorities are willing to effect 4D by considering the representation submitted by petitioner. Recording the submission made by Learned AGA, this court passes the following order. Writ petition is allowed. Respondents are hereby directed to effect 4D and Durasti by considering the online applications dated 14/12/2023 and 28/7/2024. Next, petitioner shall ಯಾರು ಮಾಡಬೇಕು 4D?
ADL.
ಯಾರು? Fifth respondent shall conduct survey by notifying the petitioners in advance the date. This exercise shall be accomplished within a period of 3 months from the date of receipt of order copy. Next. Yes.
Interim order granted at the lecture or at page 133. But the proceedings initiated, my lord, the land was granted by my lord, His Highness, my lord, Mysore Maharaj. My lord, the entire proceedings was concluded. Several lit petitions have been filed. And the Tahsildar has recommended my case for, my lord, grant of Sagolchi. And all these proceedings, my lord, now the Tahsildar, my lord, 136(3), your lordship, I kindly see, my lord, the aggrieved party. He has no jurisdiction on one hand, another is Pankaj Officio. On these two grounds, my lord, he cannot entertain deputy commissioner, my lord.
It's Aramane Kavalu land, my lord. I'll
Seek
get the
instruction.
instruction.
Come with your seat. Learned AGA is directed to accept notice to respondents 1 to 4. Yes.
But the interim matter is on 17th, my lord. That's the reason I sought for stay of
My
the.
lord, there
Delhi.
He cannot, my lord, entertain with great respect, my lord. Even
136(3) proceedings has been initiated before the DC,
No,
my lord. Let them
yeah.
participate before the DC.
but
and-
136(3) is not permissible, my lord, with great respect for an Tahsildar.
That power is not available to
No,
Tahsildar.
available to him. And
So
Pankaj
what is Tahsildar doing now, right now?
What's Tahsildar, my lord, he has now, my lord, filed a petition and obtained an interim order against the order passed by the deputy commissioner for, my lord, change of the entries in favor of the petitioner. Now he has preferred, my lord, he has no locus standi at all.
My lord,
And my lord,
Where is preferred?
my lord, before the DC, that is the impugned order, my lord. That is page 130,
no,
On what ground?
Notice there.
132, 133, page number 133.
What order is challenged? Mutation he has challenged.
He has challenged the order passed by your lordship, my lord. Himself, my lord, himself in the your lordship 115 is the order passed by him. That is a Pankaj Officio.
No.
115 is the order of the Tahsildar. And thereafterwards, Assistant Commissioner passed an order at page
125.
125.
125.
Again, it's this again he has preferred, my lord, the
No, no.
136(3).
Before AC.
Page 115 only, these are the proceedings conducted by Tahsildar.
Tahsildar,
Under what provision these proceedings are conducted?
as per the direction of this honorable court, my lord, that is a page 111. I can understand, my lord, any private party approach before the deputy commissioner and 136(3). Aggrieved party antle is 136(3) nalli. There is, my lord, his lordship also, my lord, deprecated the practice of the revenue authorities at para 3 of the, my lord, the order.
And your names were appearing earlier,
Please, my lord.
based on a grant made by the.
The grant made by my lord Maharaja of 1969.
Now deputy commissioner is directed to restore the
Has
names.
entertained and my lord granted stay. revenue entries. This order, my lord, has to be stayed by your lordships, my
No, no,
lord.
correct. Deputy Commissioner has restored.
Deputy Commissioner, my earlier proceedings has restored on the basis of the Tahsildar order under page 115. 115 is the order of the, my lord, Tahsildar.
Ah.
Sir, now he has become an appellant before the Deputy Commissioner.
No, no, he orders to mutate your name and then he challenges it
The
before,
challenge is, my lord,
before whom?
before Deputy Commissioner by the Tahsildar.
Here what happened?
That is the
Earlier,
reason,
it
if
was
not, I
fine,
would
my
not
lord.
have approached your lordship.
Earlier, the mutation entry was in the name of government, my lord. That was challenged by the endorsement.
That is covered by a batch of petitions.
Batch of
That is
cases.
covered. That is covered. Sunil Dutt Sahib.
Your lordship is right.
Lordship has already dealt with that case.
All conclude ಆಗಿದೆ sir.
We have challenged AC's order, my
Page
lord, before the
66.
deputy commissioner under 136(3), my lord, there is a provision.
You authority have no right to challenge it.
No, here, my lord, what
You can-
happened? It's a government land, my lord, therefore we are challenging.
No, no, but he's.
It's a government land. Our
Uh,
contention is it's a government land.
Then let Deputy Commissioner hold an inquiry. You can't
Yes,
prefer.
my lord. Therefore, my lord, here what happened, my lord? Tahsildar have changed the entry.
Agreed
It has
party
been
in the
challenged by
authority.
the petitioner
one.
before the AC. AC has confirmed, AC has reverted the matter.
Now you,
Therefore, we are challenging before the DC, my lord.
what is it you have challenged now?
It's a government land, the AC has not properly concluded the matter. Therefore, we have challenged the same AC's order under 136 to the
Let me examine,
assistant commissioner has
whether-
passed the order.
let
Therefore,
us-
we have challenged before the
Please
DC.
show me that you as authority under mutation.
Kindly,
proceedings.
136(3), my lord, kindly see me.
Huh?
136(3), the deputy commissioner may on his own motion or on application of the party. Party means Tahsildar has referred the matter to file a application before the.
Arif, don't mix up. There is a grant in their favor
There is a grant
and
in.
you simply deleted the name of all the grantees. And you restored
the
the
name.
artist in the name of the state.
Please,
That issue is already dealt by this court,
Right.
confirmed by division bench. You restore the name. If there has to be, what inquiry, what notice is
name
ordered?
has not been restored, my lord. Name has not been restored. Government land, government name is in, still today, government name is in the RTC, my lord.
And what is it you're now, the initiation of proceedings
lord.
is questioned by you?
Please, my lord, I have initiated
LS
and
of
before
the-
the assistant commissioner, as per the orders of the High Court,
No. What is it you're challenging now?
my lord, that's the DC interim order, my lord.
And the entire proceedings.
And
Deputy
the entire
Commissioner-
proceedings before the deputy commissioner, it is
Till
not
today,
maintainable.
Government name is showing in the
What is the interim order granted now?
my lord.
Interim order is, what is the interim order?
Entry matter is maintain the entry in the name of government. What is standing in the name of government?
In the name of
No, no.
petitioner.
ಆ ತರ ಅಲ್ಲ.
Yes, sir, Nagaraj sir, ಬುಧವಾರ ಹಾಕೋತೀನಿ ನೋಡೋಣ.
Please, my lord.
ಯಾಕಂದ್ರೆ ಮಂಗಳವಾರ ಕೇಸ್ ಇದೆ ಸರ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ
ಏನ್
your lordship may kindly see as your lordships has
But they
observed.
may pass orders on that day. sir.
Justice Yadav,
Pass order on,
That's the reason you are
Proceedings ಇದೆ ಬಂದ್ ಅಪಿಯರ್ ಆಗಿ ಅಂತ ನೋಟಿಸ್ ಕೊಟ್ಟಿದೀವಿ.
you appear there, we'll have it on Wednesday.
ಅಲ್ಲ
Appear ಆಗಿದ್ದೀವಿ already.
ಅಪಿಯರ್ ಆಗಿದ್ದೀವಿ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಂಟ್ರಿ ಮಾಡಿ ಇದರಲ್ಲಿ.
You inform the deputy commissioner that the matter is listed on Wednesday.
Please,
And you also inform,
please,
communicate,
please.
work out.
ನಾವು
ಅಲ್ಲ jurisdiction ಇಲ್ಲ ಅಂದ್ರೆ
ಅದು ನೀವು
ಬೇಡ,
ನಮ್ಗೆ stay
I would
ತಗೊಂಡು
not have my lord.
ಇವತ್ತು ಸಿವಿಲ್ ಡೇ ಅದಕ್ಕೆ ಬೇಡ ನಮ್ ಡೋಂಟ್ ಟ್ರಬಲ್ ಮೀ ಟುಡೇ.
ಕಾರಣ ಏನಂತ ಹೇಳಿದ್ರೆ ಪಂಕಜ್
ಇವತ್ತು civil day ನಾಗರಾಜ್ ಅವರೇ.
has no locus and
That day I will hear you. I will hear you on that day.
as your lordships observed rightly, my lord,
Noted.
Justice Yadav has passed an order, page 66, page 66.
I'll examine it on
Right.
Wednesday. We'll pass orders on it. Let him seek instructions.
Like let this
Leonard.
interim order ಮೇಲೆ kept in abeyance ಅಂತ ಹೇಳಿ ಮಾಡಿ.
ಏನು ಆಗಲ್ರಿ, ಒಂದ್ ದಿವಸದಲ್ಲಿ ಏನು ಆಗಲ್ಲ.
ಅಪಿಯರೆನ್ಸ್ ಅಷ್ಟೇ ಸ್ವಾಮಿ.
ಅದು ಫೈನಲ್ ಆರ್ಡರ್ ಮಾಡೋಣ.
ಏನ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ತಲ್ಲ
Get
appearance
ready.
ಅಷ್ಟೇ. ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಅಪಿಯರೆನ್ಸ್ ಆಗ್ಬಾರ್ದು ಅಂತ ಹೇಳಿ.
Leonard AGA, he directed to accept notice to respondents. Release this matter preliminary on Wednesday. ಬುಧವಾರ.
Well,
9.
Hearing for the petitioner, my lords.
Yes. Darshana.
Only pass for my lords. Peninsular lordship, my lords, connected matters all already been allowed, my lords.
ಶೋಕಾಸ್ ನೋಟಿಸ್ ಅಂತ ಟ್ರೀಟ್
So,
ಮಾಡಿ.
eviction notice could issue
Huh?
ಮಾಡಿದ್ದಾರೆ.
This court has already passed orders treating
So
the
treat,
eviction.
Yes, ma'am.
to treat eviction notice as a show cause.
ಶೋಕಾಸ್.
Nagaraj, ಆಗಿದೆಯಲ್ಲ. What is your right? Possessory right?
My lords,
Whether you have filed an application,
yes, my lords, I have filed an application, my lords.
is
Accordingly,
pending
Annexure B,
consideration.
my lord, grant certificate is also issued. Grant certificate is also issued, my lords. Annexure B, my lords, page number 14.
Grant certificate is,
Yes, my lords.
madam, ಈ ಕೇಸಲ್ಲಿ ನನ್ನ ಹತ್ರ ಇದಲ್ಲ.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಅದಕ್ಕೋಸ್ಕರ ದೇ ಹ್ಯಾವ್ ನೋ ರೈಟ್ಸ್ ಓವರ್ ದಿ ಬಿಕಾಸ್ ಇಟ್ಸ್ ಎ ಬಿಗ್ ಖರಾಬ್ ಅದಕ್ಕೋಸ್ಕರ ಎವಿಕ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ದೇ ಆರ್ ಅನಾಥರೈಸ್ಡ್ಲಿ ದೇರ್
ಇಲ್ಲ, there is a grant.
contention is that we
Whether
have
there is a grant, whether there is a grant.
that
Annexure
Page-
B, my lords,
Right.
page number 14.
Page 42.
14, my lords, 14, 1 4.
Grant ಇದೆ ಅಲ್ರಿ, what is the 2018 grant, madam?
grant my lord I have been told that that grant is under suspicious
No, 2018 to suspicious, 1960, 70 grants are doubtful, accepted.
eviction notice ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅಂದ್ರೆ food ಖರಾಬ್ land it cannot be given ಅಂತ.
Who
Now
has
they have
granted you
called
initially?
it food ಖರಾಬ್ land.
And now this inquiry is contemplated under what provision now?
It's 192 ಏನಲ್ಲಿ ನಾವು
No,
ಕೊಟ್ಟಿದ್ದೀವಿ.
you can't initiate eviction. You have to,
4 ಅಲ್ಲಿ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
or not?
104 ಅಲ್ಲಿ 104 ಅಲ್ಲಿ ತಹಸೀಲ್ದಾರ್ has got power to issue notice if they have
Now,
occupied
whether the
garment.
grant is genuine or not, under what provision you can hold inquiry,
ಇಲ್ಲಿಗೆ ಕೃಷಿಗೆ ಯೋಗ್ಯ ಅಲ್ಲ ಆಗಿರೋ food
ಆಗಲ್ಲ,
ಖರಾಬ್
ಆಗಲ್ಲ.
ಆಗಿದೆ land.
rightly or wrongly, there is a grant.
Yes,
Rightly or wrongly, there is a grant. Who is the competent authority who can hold an inquiry? Deputy Commissioner?
Deputy Commissioner 34 section notice ಕೊಟ್ಟಿವಿ. It is the ತಹಸೀಲ್ದಾರ್ who has issued notice under
ಈ
104.
grant genuine ಇದೆಯಲ್ಲ ಅಂತ, under what provision and who is going to hold an inquiry?
ಇಲ್ಲಿ ಗ್ರಾಂಟ್ ಜಿನಿನ್ ಹೇಳ್ತಿಲ್ಲ ಫುಡ್ ಖರಾಬ್ ಅಂತ ಇಲ್ಲ ಫುಡ್ ಖರಾಬ್ ಲ್ಯಾಂಡ್ ಯಾವ ಆಕ್ಯುಪೈ
Madam, there is a grant, somebody has to hold an inquiry. You tell me Deputy Commissioner or Assistant
ಇಟ್
Commissioner?
ಈಸ್ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್
Let him hold an inquiry. How he can initiate eviction?
ಬಿಕಾಸ್ ದೇ ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಂಡರ್ 104
No, that has to go. That eviction notice has to go. But he can hold an inquiry.
ಎಸ್ ಐ ಕ್ಯಾನ್
Court karam cannot be, that can't be subject matter of a grant. You can't grant. But you hold an inquiry, notify and hold an inquiry. Work order.
ಅವ್ರು ಹೇಳ್ತಿರೋದು ಅನಾಥರೈಸ್ಡ್ಲಿ ದೇ ಹ್ಯಾವ್ ಎನ್ಕ್ರೋಚ್ಡ್ ವಿ ಹ್ಯಾವ್ ನಾಟ್ ಡಿಸ್ಟರ್ಬ್ ದೇರ್ ಗ್ರಾಂಟ್ ಲ್ಯಾಂಡ್ ದೇ ಆರ್ ಇನ್ ಎಕ್ಸೆಸ್ ಲ್ಯಾಂಡ್ ದಟ್ ಈಸ್ ವಾಟ್ ದಿ ನೋಟಿಸ್ ಸೇಸ್ ಮೈ ಲಾರ್ಡ್ ನೋಟಿಸ್ ಚಿಕ್ಕಮಗಳೂರು ತಾಲೂಕು ಹೊಸತಾರೆ ಹೋಬಳಿ 46 13 ಪಾಯಿಂಟ್ ಖರಾಬು ಜಮೀನನ್ನು ಅನಧಿಕೃತವಾಗಿ ಒತ್ತುವರಿ
All right, what is the extent of land granted to you? 16 guntas, correct?
18, my lords.
18 guntas.
ಅವ್ರು 13 ಎಕರೆ 19 ಗುಂಟೆನಲ್ಲಿ ದೇ ಆರ್ ಅನಾಥರೈಸ್ಡ್ಲಿ ದೇರ್ ಮೇಲೆ
All right, what is granted is 18 guntas,
Yes.
correct?
we are not questioning that my lord they are there unauthorizedly there occupying the lands of
In
B
excess,
Kharab land
in
in an
excess.
extent of yes my lord
But B Kharab, they are entitled to, if it is attached to the granted land, are they not entitled to
That's what
enjoy
I'm-
that
food
B Kharab?
ಖರಾಬ್ ಅಂತ ಇರೋದ್ರಿಂದ ಕೊಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ
Ah?
unauthorizedly they are there it has not been granted to them ಒತ್ತುವರಿ ಮಾಡ್ಕೊಂಡು ಬಂದಿದ್ದಾರೆ ಅವರು
All right, that you can hold it. Work order. Petitioner. Where is the impugned order?
Annexure A, my lords, page
Petitioner
number
is
12.
selling the impugned eviction notice issued by second respondent Tahsildar under section 104,
not for
book kodri, Giri. Under section 104 of Karnataka Land Revenue Act. Petitioner assailing the impugned eviction notice is before this court. Next. Other counsel for petitioner. Learned AG appearing for respondents. Petitioner is assailing the impugned eviction notice on the ground that the authorities have, on the ground that authorities have granted the petition land and therefore respondents on the premises that there is an encroachment could not have issued an impugned eviction notice. Petitioner asserts valid title and possessory rights by placing reliance on the order, the grant order, which is evidenced at Annexure A. Next, learned AGA, however, counters petitioner's claim and on instruction submits that the impugned eviction notice does not pertain to the petition land. Should point out that petitioner is granted 18 guntas of land in survey number
46.
46. However, respondent authorities have issued the eviction notice as petitioner has illegally encroached over B Kharab land,
Food Kara,
Port Kharab,
Food Kara.
B Kharab, Port Kharab land. Next. On examining the records, this court is of the view that the impugned eviction notice is virtually in the nature of a final order. Authorities, before they pass any precipitative orders, are required to hold an inquiry and after affording an opportunity against the person, are required to pass orders in the manner known to law. The eviction eviction notice is not preceded by any inquiry. Petitioner is asserting that he is in possession pursuant to grant. First up, however, authorities have issued eviction notice on the premises that petitioner is asserting possessive rights in excess of what was granted to him. Next, if these significant details are looked into, this court is of the view that that petitioner deserves an opportunity to counter the impugned eviction notice issued by second respondent Tahsildar. The impugned eviction notice shall be treated as a show cause notice. Petitioner is reserved with liberty to file his objections / explanation to the eviction notice. Next, for the foregoing reason, this court passes the following order. The impugned eviction notice shall be treated as a show cause notice. Petitioner shall offer his explanation within a period of 6 weeks from the date of receipt of order copy. On receipt of objections, if tendered by petitioner, second respondent Tahsildar shall conduct a proper inquiry and after verifying all the records shall proceed to pass appropriate orders. Next, till then, second respondent shall not take any precipitative action pending inquiry.
Debate may conclude the proceedings at time may conclude.
So it's in your hand.
Fix our reply ಹಾಕಿದ್ಮೇಲೆ ನಾವು
ಬರ್ಕೊಳ್ಳಿ. R2 shall accomplish the inquiry within a period of 8 weeks from the date of receipt of objection.
objection.
If a petition in this case,
Yes.
petitioner my lords has challenged the order where his grant is my lords is set aside. Is covered by the decision of my lords, my lords. In a similar set of facts, my lords had passed.
Is it in regard to trees or
Please, please.
only trees?
ಅಲ್ಲಲ್ಲ ಇಲ್ಲಿ ಇದು ಹೇಮಾವತಿ ಪ್ರಾಜೆಕ್ಟ್ಗೆ
ಗೊತ್ತು ಅದ trees ಏನೋ ಇದು fraudulent grant ಅಂತ.
ಅಲ್ಲಲ್ಲ they have not said anything. They have just without notice they have cancelled my grant. Fraudulent. They say it's a fraudulent grant, basically.
It's
ಅನುಬಂಧ.
fraudulent grant.
It's a fraudulent grant.
Will reconsider.
ನಾಗರಾಜ್ ಬರ್ಕೊಡ್ರಿ.
One to eight.
Petitioner is aggrieved by the impugned order dated 25/8/2022 passed by respondent number 4 / special land acquisition officer as per NGRL. What impugned order, fourth respondent has cancelled the grant made in favor of petitioner. Next, by the counsel for petitioner, learned AGA for respondents 1 to 8. Facts are as under. Petitioner claims to be an agriculturist. Petitioner asserts that respondents acquired the land bearing survey number 1/4, 1/3, and 1/4. Totally measuring 2 acres 36 guntas in Shano Boganahalli village. Third respondent deputy commissioner having reserved the land measuring 156 acres, petitioner having lost lands in Hemavati Reservoir project is granted a land in survey number 1 to an extent of 4 acres. Next. Fourth respondent / special land acquisition officer has passed the impugned order on the premises that petitioners were not eligible to secure grant and the grant is secured by fraudulent means. Next, this issue is squarely covered by the judgment rendered by coordinate bench in WP 27976 of 2023. The coordinate bench, while setting aside a similar cancellation of grant as held as under para 5 to 7 is relevant and same is extracted, which reads as well. Next, in the present case on hand, the grant made in favor of petitioner is unilaterally cancelled by fourth respondent without notifying the petitioner. The impugned order is not preceded by a proper inquiry and the same is passed in violation of principles of natural justice. Petitioner's right in immovable property are taken away without holding a proper inquiry. Therefore, the impugned order cancelling the grant is not sustainable. For the foregoing reasons, this court passes the following order. Writ petition is allowed. Impugned order dated so and so, dated as per Annex L, is hereby quashed and set aside. Rest all the same day. 3 to 5.
May I make one request, my lords? In addition to this, my lord, now they have issued a notice to conduct survey in my property. Let there be a direction not to precipitate until my application is considered. my lords.
ಸರ್ವೆ ಮಾಡ್ಲಿದ್ರೇನೆ ನಮಗೆ ಗೊತ್ತಾಗದು
ಗೊತ್ತಾಗೋದು. ಆಗ್ಲಿ.
ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಕಷ್ಟ.
Next.
Not certain for the petitioner, recognizing not the service of the petitioner's late husband, that he was the ex-military personnel, a land came to be granted. After following all procedures, satisfying that I am an army person, not the grant certificate came to be issued on 1/6/1972 in respect of survey number 26 of Raghavana Osur village. Not thereafter what happened, the special officer not revisited the order. Not the land was granted to 5 beneficiaries, including the petitioner. Later, not he revisited the order on 26/5/93, telling that the land which is granted in survey number 26 is unfit for cultivation. It's not feasible for cultivation. Therefore, I am granting the land in survey number 25, and fresh grant certificate has been issued to the other beneficiaries. So far as me is concerned, no fresh grant certificate is issued, not subsisting in survey number 25. The land is available in survey number 25. Not till date, RTC continues in my name in survey number 26, but the land is not fit for cultivation. My grievance is, Nangu where survey number 25, wherever the land is fit for cultivation.
All right. Similarly placed grantees, they are accommodated.
Yes.
Take instruction, madam. Leonard AGA is directed to accept notice to respondents 1 to 3, release this matter in preliminary hearing on.
Not could it be listed in preliminary hearing only?
I said in preliminary only.
Because army priority,
Order 3 weeks time.
next week alone day,
ಇಲ್ಲ ಹೋಗ್ಲಿ ಅವ್ರು
on 10-15.
Let us seek instructions. 14. Next. ಎಷ್ಟು ಇದೆ ನಿನ್ನೆದಾ ಆಲ್ರೆಡಿ ಆಲ್ರೆಡಿ
Serial number 12, my lord. I have filed my wakalat. The office has not been notified in the list.
I will hear him today. You have to read it, sir. 2005, I can't grant you adjournment. ಯಾಕೆ ಗೊತ್ತಾಯ್ತು ನಿಮ್ಗೆ ಗೊತ್ತಾಗಾಯ್ತು ಫೈಲ್ ತಗೊಂಡ್ ಬಂದಿದ್ದೀರಲ್ಲ
File illa, sir. File has not been given to me. I have filed
No,
no
no.
objection wakalat for respond number 1.
The lawyers can't go on injuncting the court from deciding the cases. 2005, if you have taken a brief, you should be ready. Yes, sir, what is the matter? No, I'm going to hear it, sir. We are done with this. I'll hear you. You don't bank on his shoulders. No, I'm not granting him time. Let him make notes. We'll see. You argue, sir. And this is heard in part, sir.
ಬಸವರಾಜ್ appear
Date given matter ಇದೆ. ಅಲ್ಲ ವಕಾಲತ್ ಹಾಕ್ಬೇಕಾದ್ರೆ next date ನೋಡ್ಲಿಲ್ವಾ? net ಅಲ್ಲಿ ಗೊತ್ತಾಗಲ್ವಾ?
It has been mentioned.
net ಅಲ್ಲಿ ಗೊತ್ತಾಗತ್ತೆ.
ಅಲ್ಲ ನೆಟ್ಟಲ್ಲಿ ಅದರಿಂದಾನೇ ಇವತ್ತು ನಾನು ಅಪಿಯರ್ ಆಗಿದ್ದು. ನನ್ನ ಹೆಸರುನು ತೋರಿಸಿಲ್ಲ ಆ ಕಾಜ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ.
Sir,
I
date is
filed ವಕಾಲತ yesterday.
Yes, sir. Yes, sir.
This is the
Who are you?
defendant's appeal.
What is the suit for?
The plaintiff and defendants are the neighbors. The suit is for initially he filed a suit for injunction,
Yes.
restraining the defendant from interfering with his possession. And later, my lord, he has amended the plaint.
Initially, it was an injunction suit.
Initially, my lord, it is only an injunction suit. May I request your lordship to come to page 6.
What was your defense?
My lord, my defense is I am the owner of the property. This, my lord, this is only the initially, my lord, his suit is for bare injunction not to interfere with his possession.
Then
Then
cannot,
he filed an amendment application describing the Schedule B. And Schedule B property, I am trying to interfere with his possession, is his contention.
Correct.
Then, my lord, the prayer, it is a very difficult to understand what is his pleading and the prayer is. My lord, in the entire plaint, he says only schedule property. And in the amendment, without disclosing what is the right on respect of the B schedule property, he amended Schedule B. Please come to the prayer itself, my lord. Schedule A ನಲ್ಲಿ last may kindly see ಬರೀ A, B ಅಂತ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ, ಬೇರೆ ಎಂತದೂ ಇಲ್ಲ. Injunction for the entire Schedule A, that is measuring 48 feet into 97 feet.
Schedule B is notified in the plaint.
ಅಲ್ಲ ಕರೆಕ್ಟ್ ಹೇಗೆ ಬಂತು Schedule B ಅಂತ ಹೇಳ್ಬೇಕಲ್ಲ. Last may kindly see Schedule B is unidentified.
That you can't, don't take off by directly attacking Schedule B. First to narrate the facts and then. we'll
ಅಲ್ಲ
attack.
ಒಂದು ನೋಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಆಮೇಲೆ ಮುಂದೆ ಹೋಗಿ ಹೇಳ್ತಾ ಹೋದಂಗೆ ಗೊತ್ತಾಗತ್ತೆ ಅಂತ ಅಷ್ಟಕ್ಕಾಗಿ ಮತ್ತೇನಿಲ್ಲ. ಈ schedule-
What's the flaw in the schedule, sir?
Not
According
the-
to what is the flaw? I was not able to.
The prayer is firstly, initially his prayer is for injunction. And the
ಆಯ್ತು,
prayer amended
ಹ್ಮ್.
is to declare that the plaintiff is the owner of B schedule property and to put the plaintiff into possession of the B schedule property.
Yes, sir.
So this B schedule property, where it exactly comes is a very difficult question because page 7, please see the schedule.
Clearly, west by remaining property.
West by remaining property of the plaintiff, A schedule property and Butro.
ಕೊಟ್ಟಿದ್ದಾರೆ, A schedule.
A schedule, no, that cannot be because his rate, his pleading is, his title itself is 48 into 97.
All right, yes, I will examine. Next,
Next.
now both are
No.
asserting title.
Yes,
What are the title, respective title deeds?
But now his contention is, please see, there are.
Are you related?
Huh?
Krishmurthy, sir?
ಇಲ್ಲ sir.
Whether plaintiff and
No,
defendant.
no,
sir,
they are
They are
neighbors.
not related.
Not-
Both of
not
them are
related at all.
independently purchased purchasers.
Now, what is the
But
plaintiff's
the-
title? Flow of title.
But the flow of title is this plaintiff claims that his one Mr. Kalappa was the. Firstly, my lord, he says Kalappa got the property, that is, there was no measurement. On 10/10/1952, he got it from the court auction. That is the original owner's content. His contention is original owner got the property under the court auction on 10/10/1952. And this, well, there are 4 items. And this Kalappa sold the 4 items of the property under Exhibit P19 on 2/1/1954
Yes.
to one Mr. Ayyappa Reddy. There is no measurement for this, only boundary is there. Then this Ayyappa Reddy Malad sold in favor of one S. Munishwamappa. That is 3 items. There also Malad, that is there is no measurement. Now they are considered item number 2. But the learned judge says both the plaintiff and defendants are not able to prove their title, I mean the boundaries and other things. And ultimately he gives a finding, there is a plaintiff purchased in the year 1961. The one sale deed says it is 1961 and your sale deed is of 1971. Therefore, I am relying upon old sale deed and I am granting the decree. If we go through the judgment and decree, it is very difficult to understand what is that learned judge wanted to say in the judgment. He has narrated the all sale deeds, boundaries he has mentioned.
Initially, the way he takes off, the reasoning rendered by the trial court, the way that take off seems like he is against plaintiff.
Yes.
First
Yes,
2-3
ultimately,
paragraphs.
he comes and says, the plaintiff has proved, I am granting the decree. There is another thing, last may kindly say, even according to him, 1971, he has put up the construction, ground floor. And leaving 8 feet on the eastern side to put up the compound. Till date, it has not been.
Where are the sketch? How the properties are located? Where is the topography?
To be
You prepare ಆಗ್ಬೇಕಾದ್ರೆ based on this schedule, ನೀವು ಒಂದು ready ಮಾಡ್ಕೊಂಡು ಬರ್ಬೇಕಲ್ಲ.
ಮಾಡಿದ್ದೀನಿ.
Dot point ಇದು, title documents ಇದೆ. Both title.
That is what I am saying. It is very difficult to understand what the case of the plaintiff. ಯಾಕೆಂದ್ರೆ last may kindly say, in the year 1956, the first time measurement was mentioned.
Lordship, kind permission. And prepare the synopsis for the honorable court on the Tuesday itself. It may.
First I'll try to read. ನಾನೇ ಓದ್ಕೋತೀನಿ.
Lordship,
ಒಂದು ನೀವು ಅಸಿಸ್ಟ್ ಮಾಡಬಹುದು ಇಲ್ಲ ನಾನೇ ಓದ್ತೀನಿ.
I would like.
ಅಲ್ಲ ಓದಿದ ಕಷ್ಟ ಸ್ವಲ್ಪ ಅರ್ಥ ಆಗೋದು.
I would like to assist this honorable court.
They have engaged a senior counsel. Let me see. On facts, at least on facts. ನೋಡೋಣ. Yes, sir.
ನಾನು ಅದನ್ನ ಹೇಳ್ಬಿಡ್ತೀನಿ. ಒಂದು ಎರಡನೇ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳ್ಬಿಡ್ಲಾ?
ಹೇಳ್ಬಿಡಿ.
One Kalappa has got the property, 4 items of the property under the court auction. That is in the year 1952. 4 items. There is no boundaries for, there is no measurement in respect of that property. Nothing has been produced. And he has sold 4 items in favor of one T. Ayyappa Reddy under Exhibit P19. Even there also there is no measurement. And that Ayyappa Reddy sold 3 items. Out of 3 items he sold. That we are concerned about item number 2. That is Kata number 30, old number 70. We are concerned only about item number 2. There also there is no measurement. And then the Ayyappa Reddy sold it to Muniswamappa. This Muniswamappa, he sold it in favor of one Puttananjamma, mentioning the measurement. First time.
Instructing counsel ಒಂದು ಚಾರ್ಟ್ ಮಾಡಿದ್ರೆ ಆಗಿರೋದು. ಚಾರ್ಟ್ ಮಾಡಿದ್ರೆ ವರ್ಟಿಕಲ್ ಚಾರ್ಟ್ ಯಾರ್ದು
ನಾನೇ ಮಾಡ್ಕೊಂಡಿದ್ದೇನೆ.
ಇಲ್ಲ ನಾನು ಬರ್ಕೋತೀನಿ, ಇಲ್ಲ ಬರ್ಕೋಬೇಕಿದೆ. ಬರೀ ಹಿಂಗ್ ಹೇಳ್ತಾ ಹೋದ್ರೆ ಪ್ರಿಂಟ್ ಆಗಲ್ಲ ಅದು.
ಅದು ಕರೆಕ್ಟ್. Measurement.
Wait a minute.
Corresponding to the exhibits, I'll prepare. Lordship, kindly grant me 3 days time.
No, I'm not even granting you a pass-over. ಆಗಲ್ಲ ಸರ್. This is not done. ನೀವು ಯಾಕೆ ಅಲ್ಲಕ್ಕೂ ನೀವು ಡಿಸೈಡ್ ಮಾಡಕ್ ಕೊಡಲ್ಲ ನೀವು ಲಾಯರ್ಸ್.
No, my
2005, who is accountable?
This honorable court
It's not the court today.
Please, this honorable court directed to.
Sir, cause list ಅಲ್ಲಿ ಪಾರ್ಟ್ ಹೆಡ್ ಅಂತ ತಗೊಂಡಿದೀವಿ.
Please.
ನೋಡ್ಲಿಲ್ವಾ cause list ನೋಡ್ಲಿಲ್ವಾ?
Please, my lord. That's why, my lord.
Today I'm hearing, sir, how we can inject? And you will be heard tomorrow, not after 3 days. ನಾಳೆ ಪ್ರಿಪೇರ್ ಆಗಿ ಬರ್ಬೇಕು ತಾವು.
Please, please.
In 1971, there was a survey. City survey was conducted.
Sir, one day property there, plaintiff is also asserting title, defendant is also asserting title. Your title is through whom?
My
And whether they are related, both are related.
Not, that is why
Common one vendor,
initially, my lord, this was agriculture land. They have formed, this is
Huh?
without any layout and all these things, it has been formed. And they have sold the properties. That is the reason why all these boundary disputes. And the initially up to 2000, up to 1956 or 58, no measurement,
no sir,
only
first,
sold.
no, no,
We have
forget-
also same, my lord, we
are
purchased.
you, are you owner of adjoining land or the same
Yes,
property?
adjoining land.
You are not laying your
No,
hands, I mean,
Schedule D,
you are
my
not
lord, Schedule
asserting
B
title on.
Schedule B property is the part of my property.
All right, correct. Now plaintiff is asserting title over property bearing number 43.
Yes,
And old number is 104/43, correct?
correct.
You are not disputing his title over this land.
No, my lord, what, no, the question is this, I am saying, my lord, I am,
Your purchase, what is the survey number in your?
my lord, my is one, sir, this site number 48, my lord.
Your purchase the
But
site.
my site number is 44.
Oh, now you are referring as a site.
Site, yes.
Your site is part of which survey number?
That is not traceable. Theirs also not traceable.
All right, we'll forget about your defense. Whether plaintiff is able to substantiate his title
That is
based
not,
on his title.
that is what I am saying. That is the
Not in
reason
order.
why,
We'll not examine your title document
what-
because
that's
there is
the
no counterclaim.
that is why I have, that's why I have said refer the plaintiff's title only.
Now,
ಕಾಳಪ್ಪನಿಂದ purchase ಮಾಡಿದ್ದು, that is what I am.
measurement but boundaries ಇದೆಯಲ್ಲ. Boundaries are the leading description then.
No, my lord, the boundary prevail over the measurement, that is in respect of a
And,
small extent.
Definite
But
survey
it
number.
is a larger extent, boundary will not prevail over
It's
the.
a larger extent.
ಹೌದಲ್ಲ 48 ಅಡಿ by 90 ಅಡಿ 97 ಅಡಿ. But here the dispute is in respect of 8 feet into 97 feet.
What is the total extent of survey number 43?
43 ಅಲ್ಲ 43 site number.
ಇದು site number, ಇದು site
Site
number.
number ಕೊಟ್ಕೊಂಡಿದ್ದಾರೆ. 40 ಅವ್ರ ನಂಬರು 30 ನ್ಯೂ ನಂಬರು ಖಾತಾ ನಂಬರು ಓಲ್ಡ್ ನಂಬರ್ 17 ಬರ್ಕೊಂಡಿದ್ದಾರೆ. ಅವ್ರದ್ದು 43, ನಮ್ದು 44.
ನಿಮ್ದು 44.
Yes. ಅಲ್ಲ ನಾನು ಒಂದು ಶಲೈ ಹಾಕಿದ್ದೀನಿ. For better understanding, shall I may request your lordship to see ಒಂದು ಮೆಮೊ ಹಾಕಿ ಒಂದು ಫೋಟೋ ಹಾಕಿದ್ದಾರೆ 19/8/24 ಒಂದು ಐಡಿಯಾ ಸಿಗತ್ತೆ. 19/8/24ಗೆ ಹಾಕ್ಲಿಲ್ವ? ಯಾಕೆ ಹಾಕ್ಲಿಲ್ಲ? ಅಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ ಇದೆ ಅಲ್ಲ ಹಾಕಿದಾರೋ ಇಲ್ಲೋ ಗೊತ್ತು.
ಯಾವುದು?
ಇಲ್ಲ ಫೋಟೋ ಲೇಟ್ ಇದನ್ನು ನೋಡಿ ಒಂದು ಐಡಿಯಾ ಅಷ್ಟೇ, ಮತ್ತೆ ನಾಟ್ ಫಾರ್ ಎನಿ ಅದರ್ ಪರ್ಪಸ್. ನಮ್ ಕಾಪಿ ಕೊಡಿ. ಇದು ನೋಡಿ ಗೊತ್ತಾಗುತ್ತೆ, ತಮ್ಗೆ ಗೊತ್ತಾಗುತ್ತೆ. ಈ ಇದರಲ್ಲಿ ಈ ಕಾರ್ ನಿಂತಿದೆಯಲ್ಲ ಅದರಲ್ಲಿ ಫಸ್ಟ್ ಫೋಟೋದಲ್ಲಿ ಅದು ಇವ್ರದ್ದು ಪ್ರಾಪರ್ಟಿ, ಅಂದ್ರೆ ದಿ ಅಪರೆಂಟ್ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಪ್ರಾಪರ್ಟಿ. ಕಾರ್ ನಿಂತು ವೀಕೆಂಡ್ ಸೈಟ್, ಬ್ಯಾಕ್ ಸೈಡ್ ಅವ್ರ ಬ್ರದರ್ಸ್ ಇದು. In between these two houses, there is 8 feet gap. Between these two houses, there is a 8 feet gap. But in the year 1971, there was a city survey conducted. City survey, they have put the stones. Please see the stone. 8 stone ittu, bakidella tegidare, only 1 stone is remaining. And this is the city survey also says same thing, and commissioner was appointed. Commissioner also says stone is very old and other stones are not, it has been removed. That's what he has stated. Idralli, last may kindly see the gap between the plaintiff's house and this stone, your lordship can see the better photo is at next page ನಲ್ಲಿ ನೋಡಿ ತಾವು ಎರಡನೇ page ಗೊತ್ತಾಗುತ್ತೆ ಡಿಫರೆನ್ಸ್ ಅಬೌಟ್ 3 feet ಇದೆ ನೆಕ್ಸ್ಟ್ ಲಾಸ್ಟ್ ಫೋಟೋದಲ್ಲಿ. ಆ 3 feet ಬಿಟ್ಟು ಬಿಯಾಂಡ್ ಅಲ್ಲ ಅವರ್ ಪ್ರಾಪರ್ಟಿ. ಬಟ್ ಫುಲ್ ಇದಿತ್ತು ಬಟ್
Now, this Schedule B property is where these vehicles are found, open space.
ದಟ್ ಅವ್ರೇನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಶೆಡ್ಯೂಲ್ ಬಿ ಅವ್ರ ಮನೆಗೂ ನಮ್ಮ ಈ ಮನೆ ಇನ್ ಬಿಟ್ವೀನ್ ಜಾಗ 8 feet ನಮ್ದು ಅಂತಾರೆ.
ಅವ್ರದ್ದು ಎಲ್ಲಿದೆ? Schedule A ಎಲ್ಲಿದೆ?
ಶೆಡ್ಯೂಲ್ ಇದರಿಂದ ವೆಸ್ಟರ್ನ್ ಸೈಡ್ ಕಲ್ಲಿಂದ ಲೆಫ್ಟ್ ಸೈಡ್ ವೆಸ್ಟರ್ನ್ ಸೈಡ್.
That building, on the left side building.
ಬಿಲ್ಡಿಂಗ್ ಎಸ್ ಫುಲ್ ಬಿಲ್ಡಿಂಗ್. ನೋಡಿ ಚೆನ್ನಾಗಿ ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡೋಣ. ಅಫ್ಕೋರ್ಸ್ ಇದ್ರ ಪ್ರಕಾರ ಅಲ್ಲ ಹೇಳೋದು ಏನಂದ್ರೆ ಐ ಹ್ಯಾವ್ ಗಾನ್ ಥ್ರೂ ಇಟ್ ಟ್ವೈಸ್. I could not understand what they wanted to convey, and even include, I mean, that is what learned judge also said. It is highly difficult to understand the case of the both the parties. But survey report says, survey is conducted in 1971, there is a boundary stone. But the commissioner says, I have visited this place, there is a boundary stone in existence, and there is a gap between the two houses. In fact, I told my friend also, this is not never ending business. Therefore, both of you share it equally. So that then I don't know, it is not possible. This is the only solution for this. Otherwise, your lordship has to spend a lot of money for, I mean, time for this 8 feet ಗೆ 90 feet ಗೆ ನೀವು 2 ದಿನ ಖರ್ಚು ಮಾಡಿ.
ಈಗ ಡಿಸ್ಪ್ಯೂಟ್ ಇರೋದು ಯಾವ್ದು ಇದು? Open space.
ಅದೇ ಈ ವೇಕೆಂಟ್ ಸ್ಪೇಸ್ ಇನ್ ಬಿಟ್ವೀನ್
ಮಧ್ಯದಲ್ಲಿ ಇರೋದು
ಅಷ್ಟೇ
space.
ಅಷ್ಟೇ ಡಿಸ್ಪ್ಯೂಟ್. ಇಷ್ಟು ಬಿಟ್ರೆ ಏನು ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ.
Not this open space.
ಇಲ್ಲ ಓಪನ್ ಸ್ಪೇಸ್ ನಮ್ಮದು, ದಟ್ ದೇ ಆರ್ ನಾಟ್ ಡಿಸ್ಪ್ಯೂಟಿಂಗ್.
They are not disputing.
8 feet ಮಾತ್ರ.
8 feet by 97.
8 feet by 97 ಅಂತಾರೆ. The property what he has purchased is only 48 feet into 80 feet only. How 97 feet has come, nobody knows.
How the property is measured then description ಅಲ್ಲಿ?
ಯಾವ್ದು ಪ್ಲೇಂಟ್ ಶೆಡ್ಯೂಲ್ ನಲ್ಲ
ಮೆಜರ್ಮೆಂಟ್ ಕೊಡ್ಲಿಲ್ಲ ಅವರು. ಕೊಟ್ಟಿದಾರಲ್ಲ?
ಕೊಟ್ಟಿದ್ದಾರೆ.
No, what is the total measurement of your property?
ಅವ್ರು ಹೇಳಿದ ಪಾರ್ಟಿ
ಸೇಲ್ ಡೀಟೇಲ್ ಇದೆಯಾ? ಪ್ಯಾಸೇಜ್ ಇದೆಯಾ ಅಂತ?
ಇಲ್ಲ.
ನಿಮ್ ಸೇಲ್ ಡೀಟೇಲ್ ಪ್ಯಾಸೇಜ್ ತೋರಿಸಿದಾರ?
Passage is shown, the total measurement has been shown. I have put up the construction leaving behind the 8 feet by 97 feet.
Is there argument?
That is our case.
ನಿಮ್ ಬಿಲ್ಡಿಂಗ್ ಪ್ಲಾನ್ ಅಲ್ಲಿ ಇದೆಯಾ ಅಷ್ಟು ಬಿಟ್ಟಿದ್ದು?
Plan ಅಲ್ಲಿ ಇದೆ. Plan is also produced before before the trial court, which has been.
Let us see your plan. ಅಲ್ಲೇ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ.
ಇಲ್ಲ ಪ್ಲಾನ್ ನಲ್ಲಿ ಇಲ್ಲ. ಅವ್ರೊಂದು ಸ್ಕೆಚ್ ಹಾಕಿದ್ದಾರೆ, ಸ್ಕೆಚ್ ನಲ್ಲಿ ಇದೆ ಅಷ್ಟೇ ಹೊರತು ಪ್ಲಾನ್ ನಲ್ಲಿ.
No. Now it has to be gathered from the plan because they have constructed a building.
Building ಇದೆ.
A building ಅಲ್ಲಿ what is the setback measurement that can be gathered from the building plan?
ಇದು ಸ್ಕೆಚ್ ಇದು.
Exhibit P13 ತೋಡ್ರಿ, Exhibit P13 ತೋಡ್ರಿ.
ಪ್ಲಾನೇ ತಗೊಳ್ಳಿಲ್ಲ, ಪ್ಲಾನ್ ಇದು ಸ್ಕೆಚ್ ಹಾಕಿದ್ದಾರೆ ಅಷ್ಟೇ ಒಂದು.
Let us see the building measurement.
ಅಲ್ಲ ಇದ್ರ ಬಿಲ್ಡಿಂಗ್ ಮೆಜರ್ಮೆಂಟ್ ಇದು ಅಥೆಂಟಿಕೇಟೆಡ್ ಸ್ಕೆಚ್, ಇದು ಅವರೇ ಬರೆದು ಹಾಕಿದ ಸ್ಕೆಚ್ ಇದು Exhibit P14. ಅದಕ್ಕಿಂತ ತಾವು ಇದನ್ನ ನೋಡಿ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ ಯಾವುದು ಸಿಟಿ ಸರ್ವೆ ಮಾಡಿದ್ದಾರೆ. ಸಿಟಿ ಸರ್ವೆ ಲಾಸ್ಟ್ ಮೇ ಕೈಂಡ್ಲಿ ಸಿ ಸಮ್ ಐಡಿಯಾಸ್ ವಿಲ್ ಗೆಟ್ ಇಟ್. ಇದರಲ್ಲೂ ಕಷ್ಟ, ಬಟ್ ಎನಿವೇ ಯು ಕ್ಯಾನ್ ಗೆಟ್ ಸಮ್ ಐಡಿಯಾ.
ಆಯ್ತು, ನಿಮ್ ಸೇಲ್ ಡೀಟೇಲ್ ಮೆಜರ್ಮೆಂಟ್ ಇರ್ಬೋದಲ್ಲ?
ನಮ್ದು ಅದಕ್ಕೆ ಆಯ್ತು ನಾನು ಪೇಜ್ ಲಾಸ್ಟ್ ಮೇ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಎಕ್ಸಿಬಿಟ್.
ಒಂದ್ ನಿಮಿಷ, ಫಸ್ಟ್ ಲೆಟ್ ಅಸ್ ಸಿ Exhibit P13.
But the city survey was conducted in the year 1971. City survey
ಅದು ನೋಡೋಣ.
ಮಗಳಿಗೆ ಮಾಡಿದ್ದಾರೆ. ನಮ್ದು ಎಷ್ಟು?
eastern side open space.
Open space.
ಇದು built up area measurement ಎಷ್ಟಿದೆ ನೋಡ್ಬೇಕು.
Their property is situated eastern side of the plaintiff's property.
Correct.
East of the plaintiff property is my property. Western is, theirs is western
Correct.
side. So my brother, my lord, the lordship has seen the construction, Kali side, back side.
Now let us see survey sketch ಎಲ್ಲಿದೆ sir.
Survey sketch exhibit D5 may kindly be seen. ಅದರಲ್ಲಿ
D5 D series.
D series ನಲ್ಲಿ exhibit D2 ಮತ್ತೆ D5 ಎರಡು ನೋಡಿ ಗೊತ್ತಾಗುತ್ತೆ. ಕರೆಕ್ಟ್ ಆಗುತ್ತಾ? ವಿಚಿಟ್ ಕಡಿಮೆ ಅಂತಿದ್ದಲ್ಲಿ ಯಾವ ಸೈಟ್ ಅದು ಯಾವುದು ಎಕ್ಸಿಬಿಟ್
ನಮ್ಮ ಕಡೆ
ಅವರು ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ ಬಟ್ ಎಷ್ಟು
13C is exhibit P21.
ಏನ್ ಗೊತ್ತಾಗುತ್ತೆ ಸರ್ ಇದು?
ಇದು ಎಕ್ಸಿಬಿಟ್ ಅದರಲ್ಲಿ ಏನ್ ಗೊತ್ತಾ, ಇದು
D5.
ಎಕ್ಸಿಬಿಟ್ ವಿಚ್ ಡಾಕ್ಯುಮೆಂಟ್ ಯು ಆರ್ ಸೀನ್ ಎಕ್ಸಿಬಿಟ್
Is that the D5?
D5 ನಲ್ಲಿ ದಿಸ್ ಈಸ್ ಮರಾಡ್ 884 is our site city survey number.
No, show me which you are relying.
This document exhibit D5.
D5
D5 D series
ಕೊಡ್ರಿ ಅವ್ರಿಗೆ, ಅಲ್ಲಿ ಬೇರೆ ಇದೆ.
ಅಲ್ಲ ಇದು ಸರ್ಟಿಫಿಕೇಟ್ ಏನು ಅವ್ರು ಯಾರೋ ಎಲ್ಲ ಬರೀ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ತಗೊಂಡ್ರೆ ನಾನು ಪ್ರಾಬ್ಲಮ್ ಮಾಡ್ತಾ ಇದ್ದೆ, ಪ್ರಾಬ್ಲಮ್ ಆಗ್ಬಿಟ್ಟು ಬಟ್ ಐ ಟೋಲ್ಡ್ ಹಿಮ್ ಅನ್ನೆಸೆಸರಿ ಯು ಆರ್ ಪುಟ್ಟಿಂಗ್ ಮೀ ಆಲ್ಸೋ ಇನ್ ಟ್ರಬಲ್ ಅಂತ. ಇದೆ ಸೇಮ್ ಇದೆ ಡಾಕ್ಯುಮೆಂಟ್. ಇಲ್ಲಿ ಮೇಲೆ 884 ಅಂತಿದೆ. ಈ 884 ಪ್ರಾಪರ್ಟೀಸ್ ಬಿಲಾಂಗ್ಸ್ ಟು ದಿ ಡಿಪೆಂಡೆಂಟ್ಸ್. ಆಮೇಲೆ 888 ಬಿಲಾಂಗ್ಸ್ ಟು ದಿ ಪ್ಲೈಂಟಿಫ್. 888 ಇದರಲ್ಲೇ ಇದೆ, ಇದನ್ನು ಕೊಡಿ. D2 ಇದರಲ್ಲಿ D2 ಇಲ್ಲಿದೆ. D2 ಲಾಸ್ಟ್ ಮೇ ಕೈಂಡ್ಲಿ ಸಿ ದಿ ಮೆಜರ್ಮೆಂಟ್ ಹಿಯರ್ 97 ಫೀಟೇ ಬರೋದಿಲ್ಲ ಅವರು. 888 ಅದನ್ನು ನೋಡ್ತಾ ಹೋಗಿ.
D1 to D5.
ನಾನು my lord, I have made all permutation of combination. ಎಲ್ಲ ನೋಟ್ ಮಾಡಿ ಇಲ್ಲ ಈವನ್ ಶೆಡ್ಯೂಲ್ ಸಮೇತ ಹಾಕೊಂಡು ಮೆಜರ್ಮೆಂಟ್ ಹಾಕಿ ಎಲ್ಲ ಮಾಡ್ತೇನೆ. somehow I could not comprehend what is their measurement is. This is a city survey. Anyway, some authority has taken notice, the sale deed and prepared this sketch.
The survey order has been challenged before the authorities.
ಓಡುದು ಅಂತ ಹೆಂಗೆ ಹೇಳ್ತೀರಿ? ಹೆಂಗೆ ಹೇಳ್ತೀರಿ? 94 ಬರುತ್ತೆ. 94 ಬರುತ್ತಿಲ್ಲ. 97, 94 ಬರುತ್ತೆ.
What are the measurements in your cell deed?
Madam.
East, west,
ನಮ್ದ
ನಿಮ್ cell deed ಅಲ್ಲಿ?
ನಮ್ದ್ರಲ್ಲಿ
What's the width of the property?
my sale rate 48 feet.
30 ಅಲ್ಲ 40 feet ಇರಬೇಕು.
ಅಲ್ಲ ಅವ್ರದ್ದು ಈಸ್ಟ್ ವೆಸ್ಟ್ ಅವ್ರದ್ದು
ನಿಮ್ದು ಕೇಳ್ತಾ ಇದೆ.
ನಮ್ದ
ನಿಮ್ದು ಈಸ್ಟ್ ವೆಸ್ಟ್ 40, ನಾರ್ತ್ ಸೌತ್ 80.
ನಮ್ದು ಈಸ್ಟ್ ಅದು ಎರಡು ನಮೂನೆ ಇದೆ. ಈಸ್ಟ್ ವೆಸ್ಟ್ 36 feet ಆನ್ ದ ನಾರ್ದರ್ನ್ ಸೈಡ್, ಸದರ್ನ್ ಸೈಡ್ 50 feet ಅಂತಿದೆ. But there afterwards, there was some alienation has taken place. Now the based on this, the survey was conducted. Please see, my lord, the two documents. I'll explain to your lordship now. Hmm? 36 feet in the north, 15 south, and 130. ಅದಾದ್ಮೇಲೆ ಅವ್ರ ಮಗಳು ಒಂದು 30 ಕೊಟ್ಟರು. ನಮ್ದ್ರಲ್ಲಿ ಲಾರ್ಡ್ಶಿಪ್ ಕ್ಯಾನ್ ಸಿ ದಿ ಮೆಜರ್ಮೆಂಟ್ ಫಸ್ಟ್ ಇನ್ ಪಾಯಿಂಟ್ ಆಫ್ ಟೈಮ್. ನಮ್ದ್ರಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ D10 ಇಂದ ಶುರು ಆಗುತ್ತೆ. ಸರಿ ಇಲ್ಲ ಅಂತ
ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಇದೆಯಲ್ಲ ಸರ್?
ಅಲ್ಲ
ಕೃಷ್ಣಮೂರ್ತಿ ಸರ್,
Yes.
this is the commissioner's report.
Yeah, commissioner has been examined.
Commissioner report ಇದೆ. Now before that, your lordship may kindly, I'll take your lordship to the commissioner report also. Please come to exhibit D2 and D5, my lord. This is the prepared in the year 1971.
What is that?
This is survey, city survey conducted, because my lord did earlier, all these things were,
You can't make out anything from.
I will explain to your lordship.
Of course.
888 is there. Exhibit D2 may kindly be seen. Because based on the document and possession, this city survey was conducted. Because the total measurement itself was not there in the earlier sale dates. That's why. That is the problem, my lord. It's D2 nalli, lordship may kindly see, east west, this is his property, 888
ಯಾರ್ದು?
is the plaintiff's. Because your lordship may kindly see the next page ನಲ್ಲಿದೆ ಅವ್ರ ಹೆಸರು. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ನಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಚೆನ್ನಪ್ಪ ಕನ್ಫರ್ಮ್ಡ್, ಅವ್ರ ಆಸ್ತಿ ನಂಬರ್ 888 ಅಂತ. your lordship got it. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ನಲ್ಲೇ ಇದೆ.
ಫಸ್ಟ್ ನೀವು ಮದರ್ ಡೀಡ್ ಅಲ್ಲಿ, ನಿಮ್ ಮದರ್ ಡೀಡ್ ಅಲ್ಲಿ ಈಸ್ಟ್ ವೆಸ್ಟ್ ಬಿಡ್ತ್ ಎಷ್ಟಿದೆ ಹೇಳ್ಬಿಡಿ.
ನಮ್ದ್ರಲ್ಲ, ನಮ್ದ್ರಲ್ಲಿ ಫಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ನಲ್ಲಿ ಇಟ್ ಇಸ್ ಕನ್ಸಿಸ್ಟಿಂಗ್ ಆಫ್ 2 documents. One is measuring 40 feet into 80 feet, and then 40 feet into 60 feet, totally, my lord, on the east to west, northern side 36 feet. On the east to west, on northern side 36 feet.
Northern side is 30,
Sir, 36 feet.
36,
36
correct.
feet.
On southern side,
On the southern side, east to west, 50 feet. 50 feet,
50 feet.
50 feet. North to south, 130 feet.
ಇಲ್ಲ ಅದು there is no dispute.
ಅಲ್ಲ ಅಲ್ಲ ಅದರಲ್ಲಿ ಅವ್ರದ್ದು 80 feet ಮಾತ್ರ ಇದೆ, 130
ಅಲ್ಲ.
feet.
See here,
ಓನ್ಲಿ ಈಸ್ಟ್ ವೆಸ್ಟ್ ಕರೆಕ್ಟ್ ನಂಗೆ ಅರ್ಥ
east west
ಅದು correct,
measurement
ಅದೇ
we have to
important
examine.
ಈಗ.
We have to examine.
ಅದೇ ಅಷ್ಟೇ.
Yes.
This is the document in exhibit D11 is the dated
Alright, let me-
31/1936
Let
document.
me note down your measurements.
Huh?
Let me note down your measurements.
ಮೈಂಡ್ ಇದರಲ್ಲಿ ಅವ್ರಿಗೆ ಪರ್ಚೇಸ್ ಸೇಲ್ ಮಾಡಿದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾ ಅಂದ್ರೆ ಐ ಆಮ್ ಸೆಲ್ಲಿಂಗ್ ದಿಸ್ ಪ್ರಾಪರ್ಟಿ ಮೆಜರ್ಮೆಂಟ್ ಐ ಆಮ್ ನಾಟ್ ಗಿವಿಂಗ್ ಎನಿ ಕನ್ಫರ್ಮೇಶನ್ ದಟ್ ಈಸ್ ಯುವರ್ ಹೆಡ್ ಏಕ್ ಅಂತ ಬರೆದ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಸೇಲ್ ಡೀಡ್ನಲ್ಲೇ ಬರೆದಿದ್ದಾರೆ ಅವ್ರ ಸೇಲ್ ಡೀಡ್ನಲ್ಲಿ. ದಟ್ ಈಸ್ ವೈ ಬೇಸ್ಡ್ ಆನ್ ಆಲ್ ದೀಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಸಿಟಿ ಸರ್ವೆ ವಾಸ್ ಕಂಡಕ್ಟೆಡ್. ಸಿಟಿ ಸರ್ವೆನಲ್ಲಿ
We'll go by your measurements. First, we'll also examine your measurements.
ಅಲ್ಲ ಫಸ್ಟ್ ಐ ವಿಲ್ ಟೇಕ್ ದೇರ್ ಮೆಜರ್ಮೆಂಟ್, ದೆನ್ ಐ ವಿಲ್ ಕಮ್ ಟು ಮೈ ಮೆಜರ್ಮೆಂಟ್, ಹೌ ಇಟ್ ವಿಲ್ ನಾಟ್ ಟ್ಯಾಲಿ ಅಂತ ನಾನು ತೋರಿಸ್ಬಿಡ್ತೇನೆ. ಹಂಗೆ ಮಾಡಿದ್ರೆ ಐ ಥಿಂಕ್ ದಟ್ ವಿಲ್ ಬಿ ಈಸಿ. That's why please, because he is the plaintiff, he has to establish his right. Now according to the what Munisha, I will come from Munishama point because their measurement is there. Earlier said it, there is no measurement at all. Measurement ಇಲ್ಲ, only boundary ಹಾಕಿದೆ. ಆ ಬೌಂಡ್ರಿನೂ ಯಾವ ಬೌಂಡ್ರಿಗೂ ಟ್ಯಾಲಿ ಆಗೋದು. I have exhausted my time. I think I spent more than 6-7 hours. I could not make out. But from Munishamappa, that is from exhibit P21, first time the measurement was mentioned. Exhibit P21, first time they have measurement was mentioned, and the property number is given as Khata number 30, old number 70.
What is P21?
P21 is the sale deed, under which one Puttananjamma purchased. From Puttananjamma, it was sold. Ultimately, he has purchased it. Okay, because the why I am saying this 21 is, there we can find the measurement.
Measurements,
In this, my lord, the measurement he has mentioned is east west 48 feet on the southern side. My lord, in this, my lord, there are two properties. That is the reason I am saying this. In the exhibit P21 consists of two properties. ಅದರಲ್ಲಿ east to west southern side 48 feet ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. North to south 80 feet. ಇನ್ನೊಂದು ಪ್ರಾಪರ್ಟಿ we are not concerned because that was sold by Puttananjamma in favor of one Muniswami Gowda. So, my lord, we are concerned about one item, that is 48 into north to south 80 feet. This Puttananjamma, again, my lord, she sold in favor of one Manjappa. That is on 23/6/1958.
exhibit
That is exhibit P22.
this sold it in favor of,
In favor of one Manjappa.
by whom?
Before that, exhibit P21, you may kindly see 1 minute. Because there is a disclaimer. The vendor has said, I am mentioning the measurement. This is not the correct measurement. If anything is there, anybody claims that is your headache. That is what he has stated. He has made it very
In
clear.
P21.
Exhibit P21. Because earlier sale date, there was no measurement. P21 thing.
Yes, sir.
And exhibit P21, my lord, I will read only last, shall I read this, my lord, one. ಇದರಲ್ಲಿ ಇದನ್ನೆಲ್ಲ ಕೊಟ್ಬಿಟ್ಟು ಲಾಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ ಬರೀತಾರೆ ಎಕ್ಸಿಬಿಟ್ P21 ನಲ್ಲಿ. ಈ ಮಧ್ಯೆ ಅಂದ್ರೆ ಇದನ್ನು ಕೊಟ್ಬಿಟ್ಟು ಲಾಸ್ಟಿಗೆ ಈ ಮಧ್ಯೆ ಇರುವ ಮೇಲ್ಕಂಡ ಚೆಕ್ಕುಬಂದಿಗಳ ಕೊಟ್ಟ ಖಾಲಿ ನಿವೇಶನ ಪೂರಾ ಸ್ವತ್ತನ್ನು ನಿಮಗೆ ಶುದ್ಧ ಕ್ರಯಕ್ಕೆ ಕೊಟ್ಟು ನಿಮ್ಮ ಸುಪರ್ದಿ ಪಡಿಸಿರುತ್ತೇನೆ. ಮೇಲ್ಕಂಡ ನಿವೇಶನವು ದಕ್ಷಿಣದ ಕಡೆಯಲ್ಲಿ ಪೂರ್ವ ಪಶ್ಚಿಮ 48 ಅಡಿ, ಉತ್ತರ ದಕ್ಷಿಣ 80 ಅಡಿಗಳು. ಇದಕ್ಕೆ ಲಗತ್ತಾಗಿ ಉತ್ತರ ಭಾಗದಲ್ಲಿ ಪೂರ್ವ ಪಶ್ಚಿಮ 18 ಅಡಿ, ಉತ್ತರ ದಕ್ಷಿಣ 30 ಅಡಿ. ಅದು ದಿಸ್ ಇಸ್ ನಾಟ್ ಬಿಕಾಸ್ ಇಟ್ ಸೋಲ್ಡ್ ಇಟ್ ಟು ಸಂಬಡಿ ಎಲ್ಸ್. ಮೇಲೆ ಅಳತೆ ಉಳ್ಳದ್ದಾಗಿರುತ್ತದೆ. ಎರಡನೇ ಕಾಗದ 13ನೇ ಪಂಕ್ತಿಯಲ್ಲಿ ಮಧ್ಯೆ ನಾವು ಕ್ರಯದ ನಿವೇಶನಕ್ಕೆ ಮೇಲ್ಕಂಡ ಅಳತೆಯನ್ನು ನಮೂದು ಮಾಡಿರುತ್ತೇವೆ. ನಾವು ಬಳಸಿಕೊಂಡಿರುವ ಕ್ರಯಪತ್ರದಲ್ಲಿ ಅಳತೆ ನಮೂದಿರುವುದಿಲ್ಲ. ಮೇಲ್ಕಂಡಂತೆ ಈ ಪತ್ರದಲ್ಲಿ ನಾವು ಹಾಕಿರುವ ಅಳತೆಯಲ್ಲಿ ಹೆಚ್ಚೇ ಇರಲಿ ಅಥವಾ ಕಡಿಮೆ ಇರಲಿ ನಿಮಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದೇ ಹೊರತು ಈ ಅಳತೆಯ ವಿಷಯದಲ್ಲಿ ನಮ್ಮ ಜವಾಬ್ದಾರಿ ಏನೂ ಇರುವುದಿಲ್ಲ. ದಿ ರೀಸನ್ ಇಸ್ there was no measurement mentioned in earlier sale dates. This was executed by this document, my lord, exhibit P21. On Munishwamappa to Puttananjamma. So this, my lord, this Munishwamappa, this Puttananjamma,
Sir, ಅದಕ್ಕೆ ಟೈಟಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ. Will examine what is the evidence of commissioner on spot inspection. Let us read it and then we'll take up.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಿದಾರಲ್ಲ. Actually, government authorities have gone there, taken the copies of the documents from all the parties, measured the properties, then they have given the boundary. This is a very relevant document. The reason is earlier there was no measurement at all. Based on the document, this measurement was given based on measurement in the document and possession. That's why I requested your lordship to see exhibit P D2 and D5. This will clear most of the issues. ಟೈಟಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಒಬ್ಬೊಬ್ಬರ ಹೆಸರು ಒಂದೊಂದ್ ಕಡೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಈಸ್ಟಿಗೆ ಬೇರೆ ಮುನಿಸ್ವಾಮಪ್ಪ ಅಂತ ಬರೆದ್ರು, ಇನ್ನೊಂದ್ ಕಡೆ ನರಸಿಂಹಮೂರ್ತಿ ಅಂತ ಬರೆದಿದ್ದಾರೆ. ತಾವು ಕೋರ್ಟ್ ಕಮಿಷನ್ ರಿಪೋರ್ಟ್ ನೋಡ್ತಾ ಇದ್ದೀರಾ? ನಮ್ಗೆ ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಕೈಲಿ, ಈಗ ಸರ್ವೆ ರಿಪೋರ್ಟ್ ಕೋರ್ಟ್ ಕಮಿಷನ್ ರಿಪೋರ್ಟ್ ಎರಡು ತಗೊಂಡ್ರೆ ನಮ್ಗೊಂದು ರಫ್ ಐಡಿಯಾ ಸಿಗತ್ತೆ. ಅಷ್ಟಾಗಿ ಹೇಳಿದ್ದೆ. ಈ ಸರ್ವೆ ರಿಪೋರ್ಟ್
I want to see the sketch furnished by report by the commissioner. Where is the report?
Report is exhibit is
CW1 to CW4.
Yes, ma'am.
MFA ದಲ್ಲಿ ಆಗಿದೆ.
CW 1 to CW 4 ಅಂತಿದೆ. ಅದು ಸರ್ವೆ ಸ್ಕೆಚ್ ಎರಡು ತಾವು ನೋಡ್ಕೊಂಡು ಕಂಪೇರ್ ಮಾಡ್ಬಿಟ್ರೆ ಗೊತ್ತಾಗೋಗುತ್ತೆ.
And this spot inspection was the instance of the High Court in an MFA.
ಹೌದೌದು ಅದೇ ಕರೆಕ್ಟ್ MFA ನಲ್ಲಿ. That was marked before that is not in dispute. ಇದರಲ್ಲಿ ನಾನು ಯಾಕೆ ಹೇಳ್ತಾ ಇದ್ದೇನೆ ಅಂದ್ರೆ ಫಸ್ಟ್ 71 ಇದು ಸ್ಕೆಚ್ ತಾವು ಇದನ್ನ ನೋಡಿಬಿಟ್ರೆ ಒಂದು ಐಡಿಯಾ ಸಿಗತ್ತೆ ಅಂತ ಅಷ್ಟಕ್ಕಾಗಿ ಹೇಳ್ತೀನಿ.
ನನಗೆ ಅದು ಐಡಿಯಾನೇ ಸಿಗ್ತಾ ಇಲ್ಲ, ನಿಮ್ಗೆ ಸಿಗ್ತಾ ಇದೆ, ನನಗೆ ಏನು ಸಿಗ್ತಾ ಇಲ್ಲ.
ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತೇನೆ ತೋರಿಸ್ಬಿಡ್ತೇನೆ ಅಂತ.
ತೋರಿಸ್ಬಿಡಿ.
ಎಕ್ಸಿಬಿಟ್ D2 ತೆಗಿರಿ ತಾವು ಒಂದು ಸ್ವಲ್ಪ. D2 ಅದನ್ನ ಸ್ಕೆಚ್ ಇಟ್ಕೊಂಡು ತಾವು ಇದನ್ನು ಇಟ್ಕೊಂಡಿದ್ರೆ ನಾನು ತೋರಿಸ್ಬಿಡ್ತೇನೆ. ಅದು ಯಾಕೆ ಅಂದ್ರೆ ಇದರಲ್ಲಿ ಒನ್ ಕೆನಾಟ್ ಫೈಂಡ್ ಔಟ್ ದಿ
Exhibit D2. Yes, sir. D2
ಎಕ್ಸಿಬಿಟ್ D2 ನೋಡಿದ್ರೆ ಅದರಲ್ಲಿ 888 ಇದೆಯಲ್ಲ ನಂಬರ್ ಮೇಲೆ ಫಸ್ಟ್.
Correct.
888 ಬಿಲಾಂಗ್ಸ್ ಟು ದಿ ಪ್ಲೇಂಟಿಫ್.
Correct.
ಬಿಕಾಸ್ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ನಲ್ಲಿ ಅವ್ರ ಹೆಸರು ಬರೆದಿದ್ದಾರೆ 888 ಅಂತ ಅದನ್ನ ಸಿಟಿ ಸರ್ವೆ ನಲ್ಲಿ ಮಾರ್ಕ್ ಆಗಿದೆ ಅವ್ರು ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ ನಂಬರ್. ಸಿಟಿ ಸರ್ವೆ ನಂಬರ್ ಇಸ್ 888. ಇದರಲ್ಲಿ 888 ನಲ್ಲಿ ಸ್ಕೆಚ್ ಯು ಲಾಸ್ಟ್ ಮೇ ಕೈಂಡ್ಲಿ ಸೀನ್ ದಿಸ್ ಸ್ಕೆಚ್. ಅದರಲ್ಲಿ based on the document, title document, he has given this 12 feet, 12.50 meters, southern side. 12 point. ಅಂದ್ರೆ 12.50 ಅಂದ್ರೆ 41.01 ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಆಗುತ್ತೆ. 12.50 ಅಂದ್ರೆ 41.01 feet.
Right.
On the southern side. On the northern side, 14.70 meter. ಅಂದ್ರೆ 48.23 feet ಆಗುತ್ತೆ. And the east west, north to south, 28.72 meter ಅಂತ ಬರೆದಿದ್ದಾರೆ. ಅದು that comes to about 93.04 feet ಆಗುತ್ತೆ. This is the measurement of his property identified by the surveyor. Then our property may kindly be seen. That is at exhibit D5.
ನಿಮ್ದು D5.
ಹೌದು, D4 ನಮ್ಮ ಹೆಸರಿದೆ. D4 ನಲ್ಲಿ ಫಾರಂ ನಲ್ಲಿ ನಮ್ಮ ಹೆಸರು ಬರೆದಿದ್ದಾರೆ. D5 ನಲ್ಲಿ ಸ್ಕೆಚ್. D4 ಸಂಜೀವಪ್ಪ ಅಂತಿದೆ ತಾವು ನೋಡಿ ಗೊತ್ತೇ. ನಂಬರ್ 884. D4 ಸಿಟಿ ಸರ್ವೆ ನಂಬರ್ ಲೆಫ್ಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್ ಮಾಡಿ 884 belongs to defendant. Please come to D5.
Yes, sir.
D5, the measurement he has given 14.70 meter. Is 14.70 meter ಅಂದ್ರೆ 48.23 feet ಆಗುತ್ತೆ. 48.23. ನಮ್ದು 50 ಇತ್ತು.
ನಿಮ್ ಸೆಲ್ಡಿನಲ್ಲಿ ಎಷ್ಟಿದೆ?
50 ಇದೆ. 50 ಇದೆ. ಬಟ್ ಆನ್ ಮೆಜರ್ಮೆಂಟ್
ಈಸ್ಟ್ ವೆಸ್ಟ್ ನಿಮ್ದು 36 ಇದೆ.
ಅಲ್ಲ, ನಾರ್ದರ್ನ್ ಸೈಡ್.
ಕರೆಕ್ಟ್. ಅಲ್ಲ, ನಾರ್ದರ್ನ್ ಸೈಡ್. ಆಲ್ ರೈಟ್.
ಇದು ಸದರ್ನ್ ಸೈಡ್ ನಾನು ಕೇಳಿದೆ.
ಆಯ್ತು.
ವಿ ಆರ್ ಕನ್ಸರ್ನ್ಡ್ ಅಬೌಟ್ ಸದರ್ನ್ ಸೈಡ್ ಓನ್ಲಿ ಬಿಕಾಸ್ ನಾರ್ದರ್ನ್ ಸೈಡ್ ಇಬ್ರು ಸೇಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಬೇರೆಯವರಿಗೆ.
ಆಲ್ ರೈಟ್.
We are we are concerned about southern side only. The southern side is the road formed by the CITV. So the southern side nalli namdu 48.23 feet, avrdu 41 point.
One ನಿಮಿಷ. Let this property on southern side measures
41.01 feet. 41.01 feet ಅಂದ್ರೆ 12.50 meter. ಕರೆಕ್ಟ್ ಅಲ್ಲ? ಮೆಜರ್ಮೆಂಟ್ ಅಷ್ಟೇ, ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿ ಅಷ್ಟೇ ಬರುತ್ತೆ.
Difference property on southern side
41 ಆಗುತ್ತೆ.
Difference property on southern side.
Southern side 48.23 feet.
48.
48.23. ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ 50 ಇದೆ, ಇದು 48 ಆಗಿ
48.823
feet.
823.
48.23 feet.
23 feet. All right.
Yes. And my lord, the north to south 127.87 feet
length
ಬರುತ್ತೆ.
ಬೇಡ.
ಅಲ್ಲ, ಯಾಕಂದ್ರೆ ಅದು-
Question is
ಅಲ್ಲ,
only
correct.
with regard to common passage.
Yes, ma'am. This is how it is.
Now what is
Then
the,
please come to commissioner's report.
what is the built up order? What is the built up?
Built ನಾವು ಖಾಲಿ ನಮ್ದು ಬ್ಯಾಕ್ ಸೈಡ್ ಕಟ್ಟಿದ್ದಾರೆ, ಫ್ರಂಟ್ ಸೈಡ್ ಖಾಲಿ ಇದೆ ನಮ್ದು. ಅವ್ರದ್ರಲ್ಲಿ ಫುಲ್ ಕಟ್ಟಿದ್ದಾರೆ. Lordship may now come to commissioner's report. Lordship got it, right? Commissioner. Sketch ನೋಡಿ ಗೊತ್ತಾಗ್ತದೆ. ಅವ್ರಿಗೆ ಕೊಡಿ, ನೋಡ್ತಾರೆ. Lordship got this commissioner's sketch.
ಅವ್ರದ್ದು east west 48 ಇದೆ, plaintiff 1967 sale.
ಅಲ್ಲ, ಅವ್ರು ಕ್ಲೈಮ್ ಮಾಡೋದು 48 ಅಂತ. ಬಟ್ ದಿ ಸೇಲ್ ಡೀಡ್ ಸೇಸ್ ದಿ ಮೆಜರ್ಮೆಂಟ್ is approximate measurement. Based on the document, the physical occupation and the construction, he has taken all the sale deeds of many people, and the measurement was given by the surveyor, the city surveyor. And the commissioner's report also, Lordship may kindly compare with this. Who are in occupation, how they have been enjoying. Is the alignment with which
What is the ultimate conclusion by the commissioner, court commissioner?
Commissioner, you could not give anything. His conclusion is not, but ultimate sketch may kindly be seen with the reference to the survey sketch. That is all we can make out. As commissioner sketch ಅಂತಲ್ಲ ತಾವು ತಗೊಂಡ್ಬಿಡಿ ಗೊತ್ತಾಗುತ್ತೆ. ಇಲ್ಲಿ ಕಂಪೇರ್ ಮಾಡ್ಬಿಟ್ರೆ ಗೊತ್ತಾಗೋಗುತ್ತೆ. ಕಮಿಷನ್ ಸ್ಕೆಚ್ ತಗೊಂಡ್ಬಿಡಿ. ಎಕ್ಸಿಬಿಟ್ C1,
C2.
ಅದೇ ಅದೇ ಎಲ್ಲ ಒಂದು C1 to C3 ಅಂತ ಮಾಡಿದ್ದಾರೆ. Lordship may kindly take the sketch. Got it?
What is the built up area measurement? Yours.
ಯಾವ್ದು ಅವ್ರದ್ದು ಬಿಲ್ಟ್ ಅಪ್ ಏರಿಯಾ ಬರೀಲಿಲ್ಲ ಅವರು.
ಯಾರ್ದು?
ಹೌದಾ, ಇದರಲ್ಲಿ ಕಮಿಷನ್ ಸ್ಕೆಚ್ ನಲ್ಲಿ ತಾವು ಆ ಕಮಿಷನ್ ಸ್ಕೆಚ್ ನೋಡ್ಬಿಟ್ಟು ಅವರೆಲ್ಲ ಬರೆದಿದ್ದಾರೆ ಒಂದು ಎಲ್ಲೆಲ್ಲಿ ಮೆಜರ್ಮೆಂಟ್ ಇದೆ ಅಂತ ಬರೆದಿದ್ದಾರೆ.
ಅಲ್ಲ, ಎಲ್ಲಿ ಬರೀತಾರೆ? ಬಿಲ್ಟಪ್ ಏರಿಯಾ
ಅಲ್ಲ, ತಾವು ಇದು ನೋಡಿ, ಲಾರ್ಡ್ಶಿಪ್ ಗಾಟ್ ದಿ ಕಮಿಷನ್ ಸ್ಕೆಚ್. ಸ್ಕೆಚ್ ಇದೆ, ಈ ಸ್ಕೆಚ್ ನೋಡಿದೆ ತಾವು? ಈ ಸ್ಕೆಚ್ ತಗೊಂಡ್ರೆ ತಾವು ಕಮಿಷನರ್ ಸ್ಕೆಚ್
C2.
ಅದೇ ಅದರಲ್ಲಿ ತಾವು ನೋಡಿ A1 ಲಾಸ್ಟ್ ಪ್ಲೀಸ್ ಸಿ ದಿಸ್ ಬರೆದಿದ್ದಾರೆ. A1, A2, A3 ಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ ಸ್ಕೆಚ್ ನಲ್ಲಿ.
Now A2, C2, A3 is the disputed portion now.
Correct. A2, C2 and A3, correct. This is the disputed portion. Now I'll explain to you, Lordship, how it can be understood. A1, A2, plaintiff's constructed area of the plaintiff. A1 and A2. Lordship got it right. A1 and A2 constructed area and third. Then A1, A2, A3. ಕೆಳಗಡೆ ಬರೆದಿದ್ದಾರೆ, ಮೆಜರ್ಮೆಂಟ್ ಬರೆದಿದ್ದಾರೆ. A1, A2, A3. A1, A2, A3. ಮೆಜರ್ಮೆಂಟ್ ಲೆಫ್ಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್ ನಲ್ಲಿ ಲಾಸ್ಟ್ ಕ್ಯಾನ್ ಸಿ ಇಟ್ 48 ಫೀಟ್ ಅಂತಿದೆ. ಅದೇ ಕೆಳಗಡೆ ಬರೆದಿದ್ದಾರೆ A1, A2, A3 ಕೆಳಗಡೆ. ಅದರಲ್ಲಿ ಮೆಜರ್ಮೆಂಟ್ ಫ್ರಮ್ ದಿ ಪ್ಲೇನ್ಸ್ ವೆಸ್ಟರ್ನ್ ಬೌಂಡ್ರಿ till the line up to which portion of the construction of the dependent as shown in the sketch is made. ಅಂದ್ರೆ A1, A2, A3 ನ ಟೋಟಲ್ ಅವರಿಂದ A1 ನಿಂದ ನಮ್ಮ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ವರೆಗೆ 48 ಫೀಟ್ ಅಂತಾರೆ. ಸೊ ದಿ ಸರ್ವೆ ಸ್ಕೆಚ್ ಸೇಸ್ his extent available is 41 feet. Here difference is 48 feet. 7 feet is not of the plaintiff.
Some technical, some engineer should have been appointed.
ಅಡ್ವೊಕೇಟ್ ನೋಡ್ಕೊಂಡಿದ್ದಾರೆ,
Advocate is appointed.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಒಂದ್ಸಲ ನೋಡ್ಬಿಡಿ.
ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಇದೆಯಲ್ಲ ಅಂತಾನೆ ತೋರಿಸಿಲ್ಲಲ್ಲ ಈಗ. Actual location is depicted in the commissioner report. It doesn't indicate whether you have encroached or not is not forthcoming from the
ಅಲ್ಲ,
report.
ನಾವು ಒಂದು we have to gather from the survey sketch and from this and the document ಅಷ್ಟೇ. ಮತ್ತೆ ನಾವೇ ಆಲೋಚನೆ ಮಾಡ್ಬೇಕು, ಜಡ್ಜ್ ಏನ್ ಬರೀಲಿಲ್ಲ.
Sir, I'll tell you, it is very simple.
Yes.
On southern side, both properties have measurements.
ಅದು ಮೆಜರ್ಮೆಂಟ್ ಅಂದ್ರೆ
ಅವ್ರದ್ದು
ಅವ್ರದ್ರಲ್ಲಿ
40 ಇದೆ, ನಿಮ್ದು 50 ಇದೆ. On the
ಅಲ್ಲ,
southern
ಅದ್ರದ್ದು
side.
ಏನಾಗಿದೆ, ಅವ್ರದ್ರಲ್ಲಿ 48 ಅಂತ
And there
ಅಂದಾಜು
are structures. There are buildings in both the plots.
Yes.
So you have to ascertain what is the built up area and what is the open space left
ಅದು
by.
ಅದ್ರಲ್ಲಿ ಕಂಡುಹಿಡಿಯಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. ಕಾರಣ ಏನು ಅಂದ್ರೆ
Huh?
ಸಾಧ್ಯ ಇಲ್ಲ, ಇಂಪಾಸಿಬಲ್. The reason is only boundary was there earlier. Subsequently, approximate measurement was given for their property. For us, my lord, there is a exact measurement from the year 1935 ಇಂದ ಇದೆ ನಮ್ಮ ಮೆಜರ್ಮೆಂಟ್. ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ 1935 ಇಂದ ಇದೆ. ಅವ್ರದಕ್ಕೆ 1964 ಅಲ್ಲಿ ಫಸ್ಟ್ ಟೈಮ್ ಮೆಜರ್ಮೆಂಟ್ ಬಂದಿದ್ದು ಅವ್ರದಕ್ಕೆ.
ಬಂದಿದೆಯಲ್ಲ, 64 is a
ನಮ್ದು
long time.
ನಮ್ 35 ಇಂದ 1935.
All right, your measurements also they can't dispute.
That is the reason why, my lord, now
Question is,
ಅದೇನಾಗಿದೆ, ಅದು ವಿಲೇಜ್ ಆದ್ರಿಂದ ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಿ ಎಲ್ಲ ಬಹುಶಃ ರೋಡಿಗೆ ಹೋಗಿದೆಯೋ ಏನಾಗಿದೆಯೋ ಗೊತ್ತಿಲ್ಲ, ಎಲ್ಲ ರೆಡ್ಯೂಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ಅವ್ರದ್ದು ರೆಡ್ಯೂಸ್ ಆಗಿದೆ, ನಮ್ದು ರೆಡ್ಯೂಸ್ ಆಗಿದೆ. ಆದ್ರಿಂದ ಅವ್ರದ್ರಲ್ಲಿ ಆಕ್ಚುಯಲ್ ಮೆಜರ್ಮೆಂಟ್
both should retain this as a common passage.
ಅಲ್ಲ, ನಾನು ಅದಕ್ಕೆ ನಾವೇನಂತಂದ್ರೆ ಈ ಕಮಿಷನ್ ರಿಪೋರ್ಟ್ ಒಂದು ಇನ್ನೊಂದು ಚೂರು ಮುಂದೊಂದು ಸ್ವಲ್ಪ ನೋಡ್ಬಿಡಿ ತಾವು.
Maintain it as a common passage, that's all.
ಅಲ್ಲ, ಒಂದು
Subject to what you.
ಅಲ್ಲ, ನಾನು ಅದಕ್ಕೊಂದು ಸಜೆಷನ್ ಕೊಟ್ಟೆ, ಏನಂದ್ರೆ
ಹಾ?
ನಮ್ಮ ಫ್ರೆಂಡಿಗೆ ಕೊಡ್ಲಿಲ್ಲ, ಬಿಕಾಸ್ ಅರ್ಲಿಯರ್ ಮದರ್ ಅಡ್ವೊಕೇಟ್
10 feet ಇದೆಯಾ?
8 ಫೀಟ್ ಇದೆ. 8 ಫೀಟ್ ನಲ್ಲಿ ನಾನೇನಂದೆ ಅಂದ್ರೆ ಇವ್ರದ್ದು ಕಮಿಷನರ್ ಗಿವನ್ ಎ ಫೈಂಡಿಂಗ್ ಆಲ್ಸೋ. ಅದರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅವರು ಅಂದ್ರೆ, ಈ ಕಲ್ಲು ಹಾಕಿದ್ದಾರೆ ಸರ್ವೇಯರು ದಟ್ ಇಸ್ ಇನ್ ದ ಇಯರ್ 1971. ಈ ಫೇಸ್ 1971 ಹ್ಯಾವ್ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ದ ಬಿಲ್ಡಿಂಗ್ ಟು ಪುಟ್ ಅಪ್ ದಿ ಕಾಂಪೌಂಡ್. ಅದು ಕಾಂಪೌಂಡ್ ಏನು ಹಾಕ್ಲಿಲ್ಲ. 1971 ಇಂದ 2001 ವರೆಗೂ ಕಾಂಪೌಂಡೇ ಇಲ್ಲ. How the decree can be granted in his favor? Nothing. Therefore, ಇದೆಲ್ಲ ಕಲ್ಲು ಹಾಕಿದ್ದಾರೆ, ಓಲ್ಡ್ ಕಲ್ಲಿದೆ. ಆ ಕಲ್ಲು ಅವ್ರಿಗೆ ಪ್ರಾಪರ್ಟಿಗೆ ಅದಕ್ಕೆ ಜಸ್ಟ್ 3 ಫೀಟ್ ಇದೆ. 5 ಫೀಟ್ ನಮ್ಮ ಜಾಗದಲ್ಲಿ ಬರೋದು. ಸೊ ನಾನೇನಂದ್ರೆ 3 ಫೀಟು 5 ಫೀಟು 8 ಫೀಟ್ ಆಯಿತು. ಇಬ್ರು 4 ಅಡಿ ಮಾಡ್ಕೊಳ್ಳಿ, ಕ್ಲೋಸ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಸುಮ್ಮನೆ ಅನ್ನೆಸೆಸರಿ ಕ್ವಾರಲ್ ಅಂತ ನಂದು ಒಂದು ಸಜೆಷನ್ ಕೊಟ್ಟಿದ್ದೇನೆ. ಐ ಡೋಂಟ್ ನೋ ದೇ ಆರ್ ಅಕ್ಸೆಪ್ಟಿಂಗ್ ಆರ್ ನಾಟ್.
Get the instructions.
This is this is, my lord, all, if your Lordship can go through the judgment, it is highly impossible to understand and compare, because I have spent lot of time, ಎಲ್ಲ ನೋಟ್ಸ್ ಮಾಡಿಟ್ಟಿದ್ದೀನಿ. ಏನ್ ಮಾಡಿದ್ರೆ ನನ್ನ ಹತ್ರ ಹುಡುಕಾಗಲ್ಲ. ನಾವು ಟ್ರಯಲ್ ಮಾಡಿದವರಿಗೆ ನಮ್ಗೆ ಕಷ್ಟ. ಎಷ್ಟೋ ವರ್ಷ ಟ್ರಯಲ್ ಮಾಡಿ ಬಂದವ್ರು ನಾವು. ನನಗೆ ಕಷ್ಟ ಎಲ್ಲ ಬರ್ದಿಟ್ಟಿದ್ದೀನಿ. ಬಟ್ ಲಾರ್ಡ್ಶಿಪ್ ವಾಂಟ್ಸ್ ಟು ಸಿ, ಬಟ್ ಐ ಟೈಪ್ ಇಟ್ ಅಂಡ್ ಗಿವ್ ಟು ಲಾರ್ಡ್ಶಿಪ್ ಆಲ್ಸೋ. ಮೆಜರ್ಮೆಂಟ್ ಬರೋದು ಸಾಧ್ಯನೇ ಇಲ್ಲ. ಯಾಕೆಂದ್ರೆ ಅವ್ರು ಫಸ್ಟ್ ಸೇಲ್ ಡೀಡ್ನಲ್ಲಿ ಅವರು ನರಸಿಂಹಮೂರ್ತಿ, ಆ ನರಸಿಂಹಮೂರ್ತಿನೇ ಇಲ್ಲ.
Without measurements, it's by boundaries.
ಅದೇ ಪ್ರಾಬ್ಲಮ್.
Very uncertain boundaries, according to you.
ಮೆಜರ್ಮೆಂಟೇ ಇಲ್ಲದೆ ಹೇಗೆ?
Tomorrow, part third, tomorrow.
Maybe take it up Tuesday.
No time. No, I'm sorry. You argue settlement burden. I'll decide this judgment.
Tuesday.
Huh?
Tuesday ಆಗಲ್ಲ ರೀ. Civil matters only on Thursdays and Fridays. Come prepared tomorrow.
Please,
And
I'll prepare, I'll
look
secure
at
the,
this offer also.
please. I'll
ಕಾಮನ್ ಪ್ಯಾಸೇಜ್.
get the instructions from my client as well, and I'll, if they are not agreeable, I'll address the arguments tomorrow itself, I'll.
Without file in hand, you were able to assist the court.
ಅಲ್ಲ ಒಂದೇ ದಿನಕ್ಕೆ ಓದ್ಕೊಂಡ್ಬಂದ್ರೆ
ಅದಕ್ಕೆ ಅವ್ರ ಹತ್ರನೇ ಕಾಪೀಸ್ ತಗೊಂಡು ಈಗ ಜೆರಾಕ್ಸ್ ಮಾಡಿಸ್ಕೊಂಡು ಇವತ್ತು
You went through the papers.
Please,
ನೀವು original records ನೋಡ್ಕೊಳ್ಳಂಗಿದ್ರೆ ನೋಡ್ಕೊಂಡ್ಬಿಡಿ ಈಗಲೇ.
please,
Go through the records.
I'll look into the documents.
Please go through the records and make your submissions tomorrow. Especially tomorrow. ಇಲ್ಲಿ ಟೆಕ್ನಿಕಲ್ ಹ್ಯಾಂಡ್ ಯಾರಾದ್ರೂ ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ಒಂದು ಅಲ್ಲ,
What commissioner has done is, he has only depicted factual on ground in.
ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಏನಿದೆ
Is answering the memo of instructions
Ah.
ಅಂತ ಮಾಡ್ಬಿಟ್ಟು.
ಅಲ್ಲ, ಅದು ಈಗ ಸಪೋಸ್ ಮಾಡಿ ಸರ್ವೆ ಸ್ಕೆಚ್ is accepted.
Based on cell deeds.
41 feet ಅಂತ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಬಿಟ್ರೆ ಅವ್ರದ್ದು 7 feet ಇಲ್ಲ ಅಲ್ಲಿ. ನಮ್ಗೆ ಬರ್ಬೇಕು.
ಎಲ್ಲ
ಬಟ್
ನಿಮ್ಗೆ ಬರ್ಬೇಕು.
ಅದೇ ಕ್ವಶನ್ ಮಾರ್ಕ್ ಆದ್ರೆ
ಆದ್ರೆ
ಇಬ್ರದ್ದು ನೋಬಡಿ ಕ್ಯಾನ್
Sanjeevappa, who is the original property holder, he sold the property thrice with a condition that it has to be resold to him. So by reselling the same, it has been, measurement has been improved.
That is not permissible.
That is not permissible. That is the case where the Honorable High Court. Please.
ಆಲ್ರೆಡಿ ಇತ್ತು 130 feet ಇತ್ತು. ಐ ಸ್ಯಾಟಿಸ್ಫೈ
I think the best way is to settle the matter.
Please,
Don't pressurize your client. If he's not ready to settlement,
No.
you argue the matter will
please,
decide.
please.
ಈಗ when the court comes to the conclusion both have not able to prove, alternative is only to dismiss the suit. ಇಬ್ರು ಪ್ರೂವ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ ಮೇಲೆ ಎಂತ ಮಾಡಿ ಎಲ್ಲಿ ಕೊಡಕ್ಕಾಗತ್ತೆ? ಒಂದು ಎರಡನೇದಾಗಿ ಶೆಡ್ಯೂಲೇ ಇಲ್ಲ ಪ್ಲೇಂಟ್ ನಲ್ಲಿ.
Now injunction is granted.
ಅದೇ ಅವ್ರ ಪ್ರಕಾರ ಹಿಂಗೆ he wants to possession to be handed over.
ಏನ್ ಮಾಡ್ಬೇಕು 4 feet ಅಲ್ಲಿ ನೀವು ಏನು
ಬ್ಯಾಕ್ ಸೈಡ್ ಹೋಗಕ್ ಜಾಗನೇ ಇಲ್ಲ, ಏನ್ ಫ್ರಂಟ್ ಸೈಡ್ ಇಲ್ಲ. ಅದಕ್ಕಾಗಿ ನಾವು ಇದು ಮಾಡ್ತಾ ಇಲ್ಲ.
ಅವ್ರು ಯೂಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಅದು ಆ ಪಾತ್ ವೇ ಏನಿದೆ 8 feet by 97 feet, it is using by us. We have construction, factory shed ಎಲ್ಲ commissioner reports ಅಲ್ಲಿ ಇದೆ. Entrance is towards the passage. We are using the passage. They are not. That is the rear side for the defendant's property.
ನಾಳೆ tomorrow.
Please,
Records.
I may permit it to.
Yes, please go through the records. Next.
Appeal for appellants, Your Lordship. Appeal for appellants, Your Lordship.
You are not keeping well, no?
I was not keeping well.
Recovered.
I'm better. Thank you. Much obliged.
I have heard you actually substantially. You argued on that day.
Yes, I.
Heard you.
No, Your Lordship, I wouldn't go much into it. I heard my learned senior's argument. Now, my initial point is the appellant in 40.
Actually, your good name?
I'm Shri Gopinathan.
Gopinath.
Yes.
When you look at the commissioner report, your property has gone missing.
Your Lordship, I'll tell you why. Now,
Actually, in your sale deed,
yes.
Vanda says that this portion on either side of the road, correct?
No, Your Lordship, none of the schedules have property numbers. They have title owner's name. Now, these are dynamic in nature. Or it'll over a period of time, some purchases come, somebody else's name came, and then the structure of the property geographically also kept changing. So therefore, what happens is when you describe the title and the schedule, it's never in consonance to the original one.
But you have to go by the schedule.
Yes, Your Lordship. Now, the commissioner says only this, that the survey done or the POD done is not accordance to the sale. Now, survey was done in 90, I'll just go through the, since Your Lordship.
That commissioner work done is also defective according to you?
No, I'm not saying that. I'm not saying that.
Commission work was done before the trial court or before the high?
By the High
Happened
Court.
is this, my lord, before this court.
The High Court,
But that report, that sketch,
I'm relying upon that only.
no, that cuts your property road.
No, that was conceived in the 1997 sale deed itself. 1997 sale deed defined the boundaries as a property lying on each side
Correct.
of the road.
Of the road.
Of the road.
Ah.
It was conceived even then itself. What happened? There was a resurvey done post that, and then the POD was done. And POD described this.
And you are the first, your vendor was the first purchaser, Tukaram,
Yes, Tukaram.
13 gundas.
Yes, Your Lordship.
Let us see that sketch once again.
Yes, Your Lordship. Yes. The weakness of my case is not the strength of the appellant's case in 407.
Like
He has to
yours.
prove it. He has to prove his case on his own merits.
No. It's your suit, you are the plaintiff.
Yes.
Please see the sketch now.
No, I'll just, Your Lordship, at page number 3 of the report. Now, the POD has been done in 1997. November 1997, paragraph 2 of the report. Page number 3 of internal page 3.
Internal page 3. Internal page 3, the sketch.
The next page, 4.
Yes.
The survey number 47 bar 3B, coded dated 18/11/1997.
Where are you reading, Gopi?
Paragraph 2. 47, survey number 47 bar 3B, coded dated 18/11/1997.
Yes.
Now, my predecessor's sale deed is 1962.
Correct.
Now, that sale deed describes the property. Now, Your Honor, the two suits belonging to my clients are mutually confirmatory to each other. It totally accumulates into 13 guntas.
First plaintiff has sold a portion.
Portion of it.
Second plaintiff.
Yes. Now, they are mutually confirmatory. So now, my entire concentration is whether this 13 guntas exist on record or not. Now, what the learned trial judge has said, that I am non-suited. I'm non-suited, not because I do not have the merit, because on merit as regards the issue number 2, wherein I'm seeking a declaration that this partition, the compromise decree, doesn't bind me. He holds it in my favor. That also, it does not dispute my title per se. It says that the description of the property mentioned in the schedule of the plaint is not correct, and therefore I'm non-suited. Now, Your Lordship, now the appeal in my sale deed, Your Lordship. March 29, 1997. Exhibit P1, Your Honor.
Yes.
Now, that describes 13 guntas as being lying on each other side of the roads.
Suit is for what? Declaration and?
Declaration of my title
Ah,
and also a declaration that the compromise decree does not bind me.
and what is the consequential relief sought by you?
Injunction,
Injunction.
yes.
Is it still a vacant site?
I'm not aware of the correct, the geographical situation now.
Maybe one clarification, just one small clarification because of this question. What had happened was a miscellaneous first appeal was, had arisen out of an interlocutory order from the original suit proceedings before this court. In that, what happened, a commissioner was appointed by this court in an MFA, not this commissioner's report. In that commissioner's report, when the commissioner has submitted a report saying that their allegation was that the building has been constructed recently and there is a violation and all that. So on that basis, when the commissioner visited the spot and conducted and submitted a report, he said that the constructions are found on the either side of the road, on the western side of the road, and that may not, the constructions are very old.
New?
Constructions are very old. That is the report given by the commission in MFA. That situation stands even now is by instruction. That is, the property is not a vacant property, is one aspect of the matter. Second aspect of the matter is the road, width of the road. It has, it has been increased is my other instruction. Recently, the road has become a wider road. The width of the road has become, as a result of which the property on the either side of the road, it may not be of the same extent is the submission.
Anyway, you're tracing your right under agreement, same document.
That's right.
Yours is not, your title doesn't flow, not title also.
No,
Agreement to sell, unheard of,
I am
in a
claiming
partition suit.
my
And you
case was-
argue that section 52.
I don't
is
want to say
applicable.
anything further now, Milad.
I will answer on that. You are a senior.
I am sure, Milad, I am sure your lordship will answer.
Lawyer, and you said that his transaction is hit by section 52. I'm still not able to digest it.
Section?
You said that it is hit by section
Yes.
52.
By what I
Not
submitted,
able to digest that stuff.
I will try to convince your lordship.
No,
Let-
I don't need any further.
No, it's all right, let him complete, and if there is an opportunity
No, no,
given to me, I will try to convince your lordship.
Not
Otherwise, I
on
leave
that
it to your
point.
lordship.
I've heard him.
Yes, sir.
On that point, I've heard him.
Yes.
Yes, Mr. Gopi, yes.
No, your lordship, I will just straight away go to the judgment where this reference is made vis-a-vis the property and the boundaries are concerned. Paragraph, internal page 30, paragraph 29.
Paragraph 29 of what?
Of the impugned judgment. Oh, I'll go. Paragraph 28. Yeah.
Yes.
It is not the case of the plaintiff that the survey number mentioned in the sale deed executed in favor of Tukaram Revankar was wrong, but the boundaries furnished in the sale deed are in respect of 13 guntas in survey number 47/3B. Now, your lordship, what has happened is in the sale deed of Tukaram Revankar, there is a wrong survey number mentioned, which is not 47/3B, but instead it was 45/6. Now, your lordship, I will just take you to exhibit D1. Which is a report of the Tehsildar.
The boundaries in your sale deed
Yes, your lordship.
and agreement to sell, both are the same. They tally to each other?
We cannot compare it offhand, your lordship, because there is certain
Revankar-
areas which,
Revankar.
Yes.
Executed a sale deed in favor of Jairamapala.
Jairamappa. Yes.
Agreement to sell. What is
Yes,
the schedule? Schedule in that agreement to sell.
that agreement of sale was never produced anywhere,
It was never produced.
never produced. 1978 agreement of sale was never produced.
Trial court proceeds on an assumption that you did not seek rectification. And
Yes.
therefore you have failed to substantiate your title over 47/3B.
Yes, no,
It's
your
wrongly
lordship.
mentioned as 45/6.
37/3B has three portions. One is 1 acre 5 guntas. Another is 32 guntas, and then this 13 guntas. There are no other further divisions. Now, the survey report of the ADLR, which was sanctioned by this court, defines the 13 guntas across the two sides of the road marked in green. So there is an existence of the property. Now, this will create an anomaly that in revenue records, 13 exists, but within the judgment, there is an anomaly of the title being vested into that particular geographical position of the property. Essentially, this court would have to answer that question as to how this judgment will affect the revenue records, because it has been multiple times challenged as regards the boundaries are concerned, and every time we have succeeded in it till the KAT.
Where is it?
I don't think it's part of the records, your lordship,
Then you can't look into it.
but it does exist.
Why not produced of the trial court?
No, I think it came subsequent to the judgment is dated March 2017.
Yes.
Now, your lordship, I will just go to exhibit D1.
E1.
D1.
Ah.
It's a Tehsildar's order. I'll just read this order. It summarizes quite a bit of the dispute. One Srimati Muniamma, Mr. Revankar's seller, wife of so-and-so of Tindu village, has represented in her application dated 24/1983. This order is 1983, September 13, 1983. That she actually sold an extent of 13 guntas of land to Tukaram Yashwant Revankar out of survey number 47/3B and not out of 45/6B. But the same has been wrongly mentioned in the sale deed that it has been sold out of 45/6B, and as a result, the Pani also been shown according to the sale deed, which she requested to rectify the mistake in question after due survey. The Taluk surveyor to whom the application was referred has reported with sketch stating that the contentions of the appellant, as mentioned above, is correct. On a detailed scrutiny of the records, that is copies of the sale deed, extract from the mutation, RTC, the report and sketch prepared by the Taluk surveyor, it transpires that the applicant already sold 6 guntas of land in 2 installments and 13 guntas of each on 2 different dates, on 4/10/1962 and 2/11/1962 to Mr. Revankar out of 45/6, not this one. Subsequently, the applicant also sold an extent of 1 acre 5 guntas on 25/10/1972 in survey number 47/3B to Jairamappa. The boundaries defined in the sale deed executed in favor of Revankar tallies with the details of the boundaries of survey number 47/3B. It is therefore evident that 45/6 has been inadvertently mentioned in the sale deed instead of 47/3B. It is further noted that 3 transactions effected out of survey number 47/3B only. But the details of these sale deeds mentioned below then arises a doubt as whether the 2 bits of land out of survey number 47/3B of an extent of 13 guntas as each have actually been sold to Revankar twice on 4/10/1962 and 2/11/1962. There is a tabulation. Your lordship has the exhibit?
D1. Please read it. All right, it says that all these three transactions are out of surrey number 47.
Yes, and on the next page, there is a tabulation, your lordship. Page number 2 of the order.
Yes. No, what's your argument?
No, the point I'm making it is that as in the hands of Revankar and also as in the hands of the plaintiff into Mr. Harish, the property was described to be lying in both the sides of the property, both sides of the road. The anomaly came after the podi was done, and then subsequent to the podi, the property was further sold to Mr. Abdul Salim in another suit. And that is where the entire anomaly came and the description of the properties went bad. Now, post the commissioner's report now, it says that the properties are lying like this and the survey and the podi done was wrong. And therefore, it has to be resurveyed and repodied. That is the remedy the commissioner is recommending.
Where? Read that part.
I'll read. The commissioner's report. At paragraph 13 of the commissioner's report. Paragraph 13 of the commissioner's report. My argument is existence of 13 guntas and my title over it.
Wait. Page?
Internal page 7, Your Honor. 7 or 8, Your Lordship, I think. Paragraph 13.
Yes.
The property bearing old survey number 47/3B, PODI conducted on 18/11/1997, new survey number 47/3B1, B2 and B3 situated and so village. The PODI boundaries is not tallying the boundaries in the sale deed dated 4/10/1962, 72, 84, 97 and 99. Hence, it seems to cancel the entire PODI of 1, 2 and 3 and to conduct resurvey of 47/3B and to conduct a resurvey in consonance to the sale deed. My submission.
Correct. Yes, sir. Yes.
Now, Your Lordship, I will just go to the trial court's analysis of this at paragraph 30 of the judgment, impugned judgment. The boundaries mentioned in respect of 13 guntas, this goes against me, but I'm just reading to be fair. The boundaries mentioned in respect of 13 guntas sold in favor of Tukaram Yashwant Revankar under registered sale deed dated 4/10/1962 are as follows. Internal page 32, Your Lordship.
Yes.
Paragraph 30 at the bottom, Your Lordship.
Yes, sir.
Paragraph 30, Your Lordship. The boundaries mentioned in respect of 13 guntas sold in favor of Tukaram Yashwant Revankar under registered sale deed dated 4/10/1962 are as follows. Now, the learned judge indulges into a comparison as to how I've described the boundaries. East by Halla, west by the land retained by Muniamma, north by land retained by Srimati Muniamma, south by Halla. Now, Your Lordship, these are our names, not numbers of any units. And Halla is a geographical description of probably a canal.
Natural.
And these need not be always permanent in nature, Your Lordship. Next, Your Lordship.
Yes.
The next is, it is also mentioned that 13 guntas sold under the sale deed is situated on either side of the road. So the title has vested mutually into the plaintiff Harish. Since in the sale deed dated 1997, it is mentioned 13 guntas of land is situated on either side of the road. It's an accepted fact. It has to be presumed that Tukaram Yashwant Revankar has executed a sale deed in respect of 13 guntas purchased by him under registered sale deed dated 4/10/1962. In the sale deed dated 29/3/97, the boundaries are mentioned as east by Kodigehalli boundary, west by the land of Nanjamma and Channakeshava, north by land of Bayamma, south by Kodigehalli boundary. The boundaries mentioned in the sale deed does not tally with the boundaries mentioned in the sale deed dated 1962. Which is at Exhibit P4. In the plain schedule, property purchased by the plaintiff is described as east by Kodigehalli boundary, west by private property, north by Kodigehalli, Tindlu village road, south by the land of Veerabhadrappa and Narayan Swami. So 1962 is compared with 97 and then 99 again. Further, as could be seen from the sale deed executed by Srimati Muniamma and her sons in favor of Tukaram Yashwant Revankar and the sale deed executed by Tukaram Yashwant Revankar, his son Srimati Nanjamma and Chennakeshava, it is found that 13 guntas of land is situated on either side of the road leading from Kodigehalli to Tindlu village. The boundaries mentioned, this is pertinent, Your Lordship. The boundaries mentioned in the sale deed does not tally with the boundaries mentioned in the plain schedule, even though northern boundary of 13, as per the sale deed dated 1997, is Bayamma's land. In the plain schedule, property is mentioned as Kodigehalli Tindlu Road. Even though southern boundary is described as Kodigehalli boundary, in the plain schedule, southern boundary is mentioned as Veerabhadrappa and Narayan Swamy. As could be seen from the sale deed, road is situated in the middle of the 13 guntas of land, but in the plain schedule, it is described as northern boundary. The boundaries mentioned in the sale deed and the boundaries mentioned in the plain schedule are quite different. When such is the case, it has to be held that the plaintiff is claiming 13 guntas in survey number 47/3B by furnishing wrong boundary. The property purchased by him in Exhibit P is not claimed in the suit. In the circumstances, it cannot be said that the plaintiff has become the owner of 13 guntas of land as mentioned in the plain schedule by virtue of the sale deed 1997. Out of the 13 guntas purchased, plaintiff in 2426 has retained 5.5 guntas and he has sold 7.5 guntas in favor of 2426. The sale deed executed by the plaintiff in 2426 in favor of the plaintiff in 2427 is produced before the court and is marked as Exhibit P10. This document is dated 31/8/1999. Under this sale deed, 7.5 guntas, which is situated on the eastern side of this, is sold in favor of the plaintiff in OS 2427/2000, retaining 5.5 guntas on the western side. The boundaries mentioned in the sale deed does not tally with the boundaries mentioned in the sale deed executed in favor of the plaintiff in 2426. Since the plaintiff in 2426 has acquired a valid title under 13 guntas claimed in both the suits, plaintiff in 2426 will not derive any right in respect of 7.5 guntas in accordance to the sale deed in 1999. On account of wrong description of the plaintiff in both 2426 and 2427 cannot be declared as owners in respect of 5.5 guntas and 7.5 guntas described in 2427. So the judgment, there is an acquiescence of the existence of 13 guntas merely because there is a wrong description, which is unaccepted fact.
No, see, once there is a spot inspection done, pending appeal, this is done pending.
Yes, yes, pending the appeal. The reason the spot inspection was done, that these arguments were present before the court. Despite that, a spot inspection was done through the ADLR.
Now see, even this, the claim.
Yes, sir.
The claim of respondents that there are shops on the western side of this road is also not indicated in the sketch.
I say that is in respect of the report submitted by the commissioner. The earlier proceeding that came out, that's what I mentioned in the earlier.
No, in this sketch it is not.
This is a subsequent bill. What happened was at that particular point of time, the question that arose.
This spot inspection was earlier.
No, not this. Earlier to spot, there's one more spot inspection that was conducted earlier.
And there is a conflicting report.
Not contrary, only regarding the age of the buildings constructed and the location of the buildings constructed.
All right.
Not regarding the identity of the properties. This is in respect to the identity.
You are also tracing right through Tukaramu. You are not independently asserting right over this.
So far 13 guntas is concerned.
So you can't dispute its location and identification.
But I'm only
We
disputing.
don't know. Question is whether you are in possession, who is in possession. That is
Apart
not
from
dealt.
that, my own another submission would be, when he has claimed in the suit a property which is different from what he has purchased. Ultimately, what he has done is, he has tried to shift the property to the southern side of the road, which property admittedly belongs to my clients in, that is 1 acre 5 guntas of land, purchased by Jairamappa.
3B1, that is at far off.
What I am saying, isn't it?
That is far off. You are entitled to protect.
That is southern side. That is the western side, the southern portion.
Mr. Rao, you are entitled to protect that 1 acre 5 guntas.
That's correct. What I'm submitting was,
He can't.
the shifting of this property to the southern side of the road, instead of on either side of the road, would definitely mean that he is trying to lay claim in respect of a different property altogether, not the property which he has purchased. That is what the trial court has held and has dismissed the suit on the ground that
Plaintiff should have gone for a proper survey and then filed a suit.
no, it is not as if he did not know the proper survey. It is a deliberate because they knew that the property which is on either side of the property.
Very interesting, I'll tell you, Mr. Rao.
Yes,
These 13 guntas, both of you are asserting under two different documents So there can't be any dispute in
No, I am
regard to
not,
identification.
I am not, what I am submitting is this.
Order, your brother secured an agreement. You show where that property lies.
Yes, which one?
Your brother Jaramappa. has
For
secured
that,
an
only
agreement.
one answer I have, Milord, for your lordship's query. The fact that in respect of this particular land, there was an agreement and he was put in possession of the property. He is not, cannot be disputed by the appellants here because in their own sale deed, exhibit P1, there is a reference to that. The sale deed specifically says.
No, after death of Jairamappa, you have no locus, your brothers.
Not that, again, coming again.
And I'll come to
Your
that.
lordships are right. There, Milord, your lordship may not agree with
And
me,
maybe,
but what happened is Jairamappa's only, what happened is this, Milord.
what partition suit you have filed, sir?
Parti-
Partition suit in respect of what?
All the properties.
What all? How many? Show me for.
Your lordship may
It's a
can-
collusive suit. It's a collusive.
Yes, Milord.
It's a collusive suit.
No, it is not. I'll submit, Milord.
The com-
I
the
will
com-
answer that. Your
the
lordship may
compromise
kindly-
became
No, no,
collusive.
Your lordship may kindly
You
bear
have
with,
no properties, sir.
no, I will kindly bear with me for 2 minutes.
Jairamappa.
No, kindly bear with me for 2 minutes because I don't want your lordship to have a wrong impression about the case.
Alright.
In 1983, suit is filed. Kindly see this. Suit is filed in
I'm asking you,
1980.
what are your ancestral properties?
All the properties, including this property.
Sir, show me, sir. You're not,
It is
from
my,
day one, you're not answering. But
it has been, it is
ನಾನು
produced.
ನೋಡಿದ್ದೀನಿ, last time ನೋಡಿ. Last time ನೋಡಿದ್ದೀನಿ, ಈಗ ನೋಡಿಲ್ಲ.
ಅಲ್ಲ, ಈಗಲೂ ಇದು exhibits.
ಒಂದು ಯಾವ್ದೋ ಒಂದು 10 ಗುಂಟ ಲ್ಯಾಂಡ್ ರೀ ನಿಮ್ದು ancestral
Your
property.
lordship may kindly go to the exhibits, Milord.
Dominant property is this property covered under the agreement.
No.
sir. Please
That
see,
is
sir.
not the only property, Milord.
No, sure.
No, there are multiple properties.
There are
There are
multiple
other
properties.
properties. Look into the extents.
Exhibit,
Yes, Milord.
Look
think,
into the extent.
his suits exhibit P9.
P9.
Ah.
Exhibit 10. It is not only one property.
The suit was not collusive, but the compromise was collusive.
Again, whether the compromise is collusive or not, again, Milord, I will only submit.
Will not examine that.
No,
That is not the issue.
No, what I am
Yes,
submitting is, we are not even going into that because that is not their allegation.
That
also.
is not the case.
No, my only submission is this, Milord. What happened was this. The property was purchased by Jairamappa under the agreement to sell in 1978.
Now you repeatedly say that it is purchased in an agreement. I'm not.
No, purchase means he has acquired the
I have
property.
strong objection.
Why I am
I'm saying
submitting is,
You have purchased under an agreement under Haggerty.
that's what I am trying to clarify, Milord. It is there because it is in part performance of the contract he has been put in possession. That is not in dispute.
Don't
That is
argue-
not in dispute. Is
don't
the
do that.
sub- Let us, Milord, your lordship may not decide.
Don't argue in my court.
No, no, your lordship, yes, Milord.
No. That
No,
proposition cannot be.
I am not
I'm
making,
sorry.
I am not making even one submission contrary to the records.
You're saying you have purchased under an agreement.
Well, I have acquired the property in agreement to sell in part performance of the contract. I means my Lord Jairamappa on behalf of the family. That is the case put forth. Ready. Ultimately, Miller, what happened is this particular 78
I
acre.
want your assistance only on,
Yes, Milord.
only on this point.
Yes, Milord.
There can't be any dispute in regard to identification
That
of
is
the
not, there can't be any dispute.
because both are tracing through common vendor.
Correct.
One is sale deed, one is
Correct.
agreement.
There is no dispute. Your
There
Lordship,
is the matter.
there is a matter. But only
so-
thing is,
Actually, this
I
matter
was-
requires remand only to ascertain where is that property. And if he's not in possession, you have to amend a plaint and you have to seek appropriate.
my submission is this, Milord, whether, my submission is only this.
Even
When
the
a
suit-
plaintiff has deliberately tried to lay claim in respect of a property which is other than the property purchased by, can the court, Milord, give him an opportunity to amend the plaint and get this suit?
Why not? Why not?
Yes, the
There is a
conduct
sale
of the
deed.
plaintiff, Milord,
There is a sale deed.
the conduct of the plaintiff.
No, what conduct he has purchased, sir, by investing.
But
huge money?
understand, conduct of the plaintiff in filing the suit.
What conduct?
But
What conduct, sir?
Milord, he has laid a claim in respect of it.
ಮಾರೋರು ಏನೋ ತಪ್ಪು description ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ.
That doesn't mean that they will.
Yes, Milord, I
lose
did
that.
not follow it. Are you not?
And you are in an agreement through your brother. And widow and children have already.
Not
joined-
children, only one son,
One son.
not all the children. And that we are not parties to that. That sale deed.
Sir, you have no right, sir. You can only defend your possession provided
Yes, Milord.
you are able to substantiate that you are in possession.
That is admitted by
Where?
sale exhibit P1. Wherein they say Jairamappa was put in possession of the property at the time of the agreement of sale.
Correct.
And Jairamappa, as the karta of the family, had purchased your case.
And once there is a sale in favor of plaintiff by the legal heirs of Tukaram and legal heirs of Not
Jairamappa.
all, then there is a recital indicating that handing over of possession, that binds everybody.
Yes, sir.
But we are not parties.
Factually, he may not be in a possession. then it is for him to look out what relief he has to seek.
Yes, Mr.
Provided this court remands the matter, then it is for the plaintiff to work out his remedies.
Yes, your lordship.
Lord, if it is to be remanded,
And on spot inspection commissioner says that the 4D is defective.
That's what I'm submitting. 4D is defective because what the, lordship, and one more aspect which has not been explained is this.
Correct.
This 32 guntas of land, which is sold to one Lanjappa, he is also a party in the proceedings, in other proceedings.
Suital ಅವರು.
ಈ connect you housing, ಈ suitally now ಹಾಕಿರೋ suital ಇದೆ ನಮ್ಮ appeal ನಲ್ಲಿ. What has happened is the 32 guntas ಇದೆ ಅಲ್ಲ ಅದು, it is not available at all. She could not have sold. That is the last sale deed.
That is also wrong.
That's what I'm submitting. These are the aspects. But I am not claiming right in that. Ultimately, what happens is the reason why he has laid a claim in respect of a different property than the property which he has bought is that particular property which he had bought was not in his possession. That is why he has shifted the property. That is my only submission. And apart from that, kindly see the commissioner's report.
No, it's not the case that I describe my schedule in the plaint contrary to my sale date. That's not the case at all.
That is the case.
No. My schedule in the sale deed is in consonance in same as the schedule here.
It can't be made. I don't think he's right.
Exhibit P10, your lordship,
Exhibit P10
is my sale deed of 7.5 guntas.
That is,
Sir, original your vendor sale deed, on two sides there is a stream
Yes, your lordship,
and the stream goes missing.
road.
No, Halla.
Allah
North,
means,
south.
Yes.
Allah is there are so many other discrepancies. Even in the sale deed
Your
between.
lordship, the properties,
I'll tell you, sir, Rao, sir. Ravenkars is the first sale deed.
Correct.
In a
1962.
land measuring to acre
10 guntas.
10 guntas.
Oh.
You have to carve out his share. That can't be done.
And apart from
By
that,
seniority, it has to be done. And you are also entitled to protect your 1 acre 5 guntas.
no, that's right. Apart from that.
And you can't have a conflicting stand because both of you are claiming under common vendor.
I understand. Ultimately, my lord, whether my agreement to sell,
Which prevails
will
over
it,
which document has to
I can,
take.
I mean, protect my rights because I have handed over one.
And why
judgment.
that agreement to sell is not placed on record in this suit? Why you are not produced?
The reason is this. The agreement to sell was in the custody of Jairamappa's son. He had handed over the proper, agreement to sell to the purchaser, that is the plaintiff here.
Why you didn't produce it in a partition suit?
My lord, we were not in the partition suit.
ಮತ್ತೆ it was an undisputed.
ಅದರಲ್ಲಿ ಏನಾಯ್ತು ಅಂದ್ರೆ
Texas.
ಅದರಲ್ಲಿ ಏನಾಯ್ತು ಐ ಸಬ್ಮಿಟ್ ಐ ಗಿವ್ ಎ ರೀಸನ್ ವೈ ಇಟ್ ಕುಡ್ ನಾಟ್ ಹ್ಯಾವ್ ಬಿನ್ ಪ್ರೊಡ್ಯೂಸ್. ಆ ಸೂಟ್ ಅಲ್ಲಿ ದೇರ್ ವಾಸ್ ನೋ ಡಿಸ್ಪ್ಯೂಟ್ ಬಿಟ್ವೀನ್ ಜೈರಾಮಪ್ಪ ಆರ್ ದ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ವಿತ್ ರೇವಂಕರ್.
Yes.
There was no dispute. So there was no need for us to produce the agreement to sell. And ಇನ್ನೊಂದೇನಾಯ್ತು ಅಂದ್ರೆ that property is one of the several properties. And Jairamappa never said it is not the joint family property. And after the death of Jairamappa, during the pendency of the suit, this Jairamappa's son and wife, they execute a sale deed in favor of the plaintiff in 97. In 1999, compromise was entered into.
Yes. What is exhibit P10, Gopi?
P10 is my
Why
sale.
you want to rely on exhibit P10?
No, there was a submission made that in my plaint, my schedule is described contrary to my sale deed. That is not the thing.
No, not your sale deed. You have to go by a vendor.
Yes,
sale
your
deed.
lordship. Yes.
There is, of course, there is a change in description from your vendor sale deed to your sale deed.
Yes, your lordship.
That is not permissible.
Yes, your lordship. I understand. I admit that.
Your mother document, your property purchased by you has to be identified in context of schedule indicated
My
in the
parent
vendor
deed.
sale deed.
Yes, your lordship.
Correct?
Yes, your lordship.
So we have to go by your vendor's sale
Yes,
deed.
yes.
What is exhibit P10?
P10 is my sale deed, your lordship.
No, it's of no
Yeah.
consequence.
Yes.
I'll go through records. Pass
Much obliged. Yes, your lordship.
There is only one latest judgment of the Supreme Court, recent judgment. I will be giving it along with a printout a little later.
Tell me the copy.
I have got the copy. I'll just hand over within, when we were lost. What has happened, what is stated by the Honorable Supreme Court in the judgment is that if only one of the co-owners sell the property, tell the other co-owners are not bound and the possession cannot be taken from them. That is the latest.
One co-owner,
If only one of the co-owners of the property has executed a sale deed in favor of a stranger party,
Section 45.
section 44.
44.
44 of the Transfer of Property Act.
Oh.
While referring to that, the Honorable Supreme Court has said that the stranger purchaser cannot claim possession on the basis of such a sale,
such point.
applying section 44 of the Transfer of Property. I will just hand over the judgment.
You still carry an impression that what was executed in your favor is a sale deed.
I don't say that it is a sale deed. It is an agreement to sell with part performance under section 53A. I will never say that it is a sale deed.
It is stuck in your client's mind that it is a sale deed.
No,
That
it is
it.
not so, Miran. We are only claiming part performance.
You are Manjappa, I want the quite new agree.
I have filed an application, impeding application.
Who are you?
He has purchased the property.
Purchaser of the site measuring 80/60 from Sunil, from Sunil. That is
Yaar,
after
plenty
Harish.
far, plenty far, from plenty.
One of the.
One of the
One of the
plaintiffs
appellants.
in
Harish have
2426.
No, we can't decide here. Let us see, if I remind, you can take a call. I don't know, still open. I have to examine, preserve. The impleading application is under very good.
Because I may be.
I'll pass orders on impleading.
Appellant.
You can't be heard here. I just hope that there is a remand, there will be remand, then you can. appear in-
Remand also may not subscribe by the provisions of
Ah.
Order 41. Order of remand, your lordships are aware,
Yeah.
is limited by the provisions of Order 41, 22 and 23.
Remand, normally I don't remand,
I understand.
but
But
this
it
is a
was
case where
another
there
thing
are
is,
compelling
Is it a
reasons.
case where the plaintiff is entitled for such a extraordinary relief?
What extraordinary, there is a sale deed, sir,
That to taking.
with
into account-
defective boundaries.
Yes,
It
Milord.
doesn't mean that he will lose title over it. Yes,
Let
I'll
us-
examine. it. Let us see.
Purchase is 98% from Harish, madam.
From whom?
From Harish. That is.
From the plaintiff in 2426.
You're telling him, you tell him.
From the
that's all.
remaining
If he
point of.
succeeds, he will succeed, that's all.
I have produced the sale deed along with my application.
Reserved, sir.
Not sure, Brother.
Much obliged. Much obliged.
Grateful your lordship, Milord. Your lordship has given us substantial time.
Some litigations can't be decided by judgments.
Yes, Milord.
Some list cannot be decided by rendering a judgment. I feel off late, I'm feeling it. Particularly disputes surrounding Bangalore city, very difficult to render a judgment.
Sometimes what happens is several documents are executed without there being proper registration, proper verification and all that.
Yes,
My application will be considered and I may be implemented as opponent number 2 after the Harish, in Harish matter.
Idral Barala, sir. Pillal Barala. I'll pass orders on your application.
Then I may be permitted to withdraw the application and agitate the matter in a separate suit against the Harish.
Adunu baritin nanu. I'll reserve liberty to you. I'm not simply going to reject that.
Much obliged.
But I will hand over the citation.
Kodi sir, Kodi, memo Kodi.
Memo.
Order.
For the appellant, I appear for the appellant in this matter.
Yes, sir.
I appear for the appellant in this matter, Lord. So, I'm having a viral fever, 2 days help and I need to just get my voice back.
You're not keeping well.
Viral fever ಆಗಿದೆ 2 days, 17th ಅಥವಾ 18th ತಗೊಂಡ್ರೆ I would request.
ಬಹಳ ಜಾಸ್ತಿ ಉಳಿಲಿಲ್ಲ, ಪಾಠ ಮಾಡಿದೀವಿ. Who is opposing you?
Nobody, my lords.
Huh?
Nobody. They are, ಇಲ್ಲ, ಅವರು
You want it tomorrow or next week?
tomorrow ಅಷ್ಟೊತ್ತಿಗೆ I may not be in a position to make submission. 17th or 18th request ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Next Thursday, actually.
ಆಯ್ತು, great.
Lord, appearing for the appellants in the connected matter. Lord, I pray for 1 week's time since my seniors.
What, 1 week?
Fine.
Not even a password.
No, my lord, my senior is not keeping well, and also in the connected matter, the counsel for appellant has suffered a fracture, my lord. He is also unable to appear.
ಏನ್ರಿ ಏನ್ ಮ್ಯಾಟ್ರು? ಲಾಸ್ಟ್ ಟೈಮ್ ಇರ್ಲಿಲ್ವಾ ಅವರು?
Last time, ಇದ್ರ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ. Last time it was posted for admission, my lord. Their matter was admitted in the last.
Admitted.
I'll hear them.
Please,
You make notes.
please.
ಇದ್ರಲ್ಲಿ ನಿಮಗೆ ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಕೂಡ ಹೇಳಿದ್ನ ಏನ್ ಹೇಳಿದ್ದೆ?
Connected ಇದೆ.
ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಕೂಡ ಹೇಳಿದ್ನ?
Family tree ಇದೆ.
ಎಲ್ಲಿದೆ? ಗ್ರೀನ್ ಶೀಟ್ ಅಲ್ಲಿ ಮಾಡಿದಾರ? ಗ್ರೀನ್ ಶೀಟ್ ಅಲ್ಲಿ ಮಾಡಕ್ ಹೇಳಿ.
ಚೆನ್ನಾಗಿತ್ತು ಅದ್ರಿಗೆ ಇದನ್ನೇ ತಗೊಂಡು ಟೈಪ್ ಚೆನ್ನಾಗಿದೆ ಅದರಿಂದ.
Part of record? The family tree is part of record?
ಹೌದ್ರಿ ಪಾರ್ಟ್ ಆಫ್ ದ ಎಕ್ಸಿಬಿಟ್ P14.
Audit will be examined. So,
ಮೇಜರ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ ಈಗ ಪರ್ಚೇಜರ್ ಇದರಲ್ಲಿ ಸೆಕೆಂಡ್ ಒನ್ ಕೇಸಲ್ಲಿ ಪರ್ಚೇಜರು ಮತ್ತೆ ಇದು ಪರ್ಚೇಜ್ ಪ್ರಾಪರ್ಟಿ ಐಟಮ್ ನಂಬರ್ 3 ಫಸ್ಟ್ ವೈಫ್ ಸೆಕೆಂಡ್ ವೈಫ್.
now who filed a partition suit?
ಫಸ್ಟ್ ವೈಫ್ ಶೈಲಜಾ, BJ ಶೈಲಜಾ.
Legal is the first wife.
ಹೌದೌದು.
They instituted a suit.
ಅದು ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಫೈಲ್ಡ್ ಇಂದ ಈಗ ಅಪೀಲ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಫೈಲ್ಡ್ ಸೂಟ್.
Respondent ಅನ್ಬಾರ್ದು ಯಾವಾಗಲೂ.
ಹೌದು.
Nalini and others filed a partition suit, correct?
ಹೌದು. BG ಶೈಲಜಾ ಸೆಕೆಂಡ್ ಡಾಟರ್ ಫೈಲ್ಡ್ ಸೂಟ್ ಅಗೇನ್ಸ್ಟ್.
She filed.
ಹೌದು. ಅವ್ರು ಫೈಲ್ ಮಾಡಿದ್ರು ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಐಟಮ್ 1, 2, 3.
ಇವ್ರು ಯಾರು?
ಇವ್ರ ಐಟಮ್ ನಂಬರ್ 3 ಪ್ರಾಪರ್ಟಿಗೆ ಪರ್ಚೇಜ್
Purchases the.
ಪರ್ಚೇಜರ್ ಲ್ಯಾಂಡ್ ಇದು 2 ಲ್ಯಾಂಡೆಡ್ ಪ್ರಾಪರ್ಟಿ, 2 ಹೌಸ್ ಪ್ರಾಪರ್ಟಿ.
Who appeals for the contesting defendants?
ಫಸ್ಟ್ ಬರ್ತೀಸ್. ಈಗ ಇದರಲ್ಲಿ ಇವ್ರ ಕೇಸಲ್ಲಿ ಕಾಂಪ್ಲಿಕೇಟ್ ಏನಂದ್ರೆ ಸರ್ವೆ ನಂಬರ್ 1/1, 1/2, 2/1, 2/2 ಇಲ್ಲಿ 2 ಪ್ರಾಪರ್ಟಿನ ಮಿಕ್ಸ್ ಮಾಡ್ತಾರೆ ಕಂಬೈನ್ ಮಾಡಿ. ಇದರಲ್ಲಿ 1/1, 2/1, 1/1 2 ಪ್ರಾಪರ್ಟಿ ಬಿಲಾಂಗ್ಸ್ ಟು 1 ರಂಗಪ್ಪ ಅರ್ಲಿಯರ್. ಆಫ್ಟರ್ ಡೆತ್ ಆಫ್ ರಂಗಪ್ಪ ಪ್ರಾಪರ್ಟಿ ಟ್ರಾನ್ಸ್ಫರ್ಡ್ ಇನ್ ದಿ ನೇಮ್ ಆಫ್ ತಿಮ್ಮಕ್ಕ.
ಎಷ್ಟಿದೆ ಪ್ರಾಪರ್ಟೀಸ್?
ಒಟ್ಟು 3 ಐತೆ ಶೆಡ್ಯೂಲ್ ಇದೆ.
91 sir. 91, 32/2 and 2/2.
ಹೌದೌದು.
ಸೇಲ್ ಮಾಡಿದ ಸರ್ವೆ ನಂಬರ್ ಯಾವ್ದು?
ಇದು ಸೇಲ್ ಆಗಿಲ್ಲ. ಪಾರ್ಟ್ 30 ಗುಂಟಾಸ್ ಮಾತ್ರ ಸೇಲ್ ಆಗಿದೆ. 30 ಗುಂಟಾಸ್ ಸೇಲ್ ಮಾಡಿದ್ರು ಅಷ್ಟೇ 2/2 ದಲ್ಲಿ.
2/2 ಅಲ್ಲಿ
30 ಗುಂಟಾಸ್ ಅವ್ರ ಪ್ರಕಾರ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್
ಯಾರು? ಶ್ರೀನಿವಾಸ,
ಚಂದ್ರಕಲಾ,
ಶ್ರೀನಿವಾಸು,
ಚಂದ್ರಕಲಾ.
ಚಂದ್ರಕಲಾ,
Children of second wife.
3 ಸೆಕೆಂಡ್
They have executed one.
ಬರೀ
they sold
30
one.
ಗುಂಟಾಸ್ ಔಟ್ ಆಫ್ 3 acre 10 ಗುಂಟಾಸ್.
30 gunters of 3 acre 10 gunters.
ಫಸ್ಟ್ ಸ್ಟ್ರೈಟ್ ವೇ
What is the defense?
ಇಲ್ಲಿ ನಮ್ದಾಗಿದೆ ಅಂತ ಅವರು ಪೇಜ್ ನಂಬರ್ 25 ಬರೋಣ. ಪೇಜ್ ನಂಬರ್ 25 ಫಸ್ಟ್ ಅವ್ರ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇವರು ಡಿಪೆಂಡೆಂಟ್ ಇವರು ಈ ಕೇಸಲ್ಲಿ. Page number 25, para 3. Depend number 7 to 9 submit that after death of one Timmakka in the year of 1980, or she Garudappa, her son Garudappa sold the 2 acre 18 guntas land out of 3 acre 8 guntas situated at survey number 2/2 Bettalli village, Dasanapura village, Bangalore South Taluk, to the depend number 7 and 7. By receiving sale consideration ಅಂತ ಪ್ಯಾರಾ 3 26 ಪೇಜ್ ನಂಬರ್ ಅಲ್ಲಿ ಪ್ಯಾರಾ 3 ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಇಲ್ಲಿ ಹೇಳಿದಾರೆ ಸೇಲ್ ಮಾಡಿದ್ರೆ ಗೌಡಪ್ಪ ಸೇಲ್ ಮಾಡಿದಾರೆ ಅಂತ. ಡಾಕ್ಯುಮೆಂಟ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್, ಸೇಲ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್. ಇದರಲ್ಲಿ ಸೇಲ್ ಆಗಿಲ್ಲ, ಆಕ್ಚುಲಿ ಸೇಲ್ ಆಗಿಲ್ಲ.
You come to issue number 3. Dependents have to prove issue number 3 and 4, correct?
ಹೌದು ಹೌದು ಹೌದು.
Their defense is that Timmakka has sold 2 acre 18 guntas.
ಟೂ
Till it is not produced.
ಹೌದು ನಾಟ್ ಎರಡು WS ಅಲ್ಲಿ ಒನ್ ಕಂಟೆನ್ಷನ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಒಂದು WS ಅಲ್ಲಿ ಗರುಡಪ್ಪ ಸೋಲ್ಡ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಅಂತ ತಗೊಂಡ್ರು. ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಬರೋವಾಗ ದಿ ಪ್ರಾಪರ್ಟಿ ಗ್ರಾಂಟೆಡ್ ಇನ್ ಫೇವರ್ ಆಫ್ ವೀರಣ್ಣ ಗ್ರಾಂಡ್ ಫಾದರ್ ಆಫ್ ದಿ ವೀರಣ್ಣ ಅಂತ ಬಂದು ಎರಡು ಡಿಫೆನ್ಸ್ ಅವರೇ ಡಿಫೆನ್ಸ್ ತಗೊಂಡಿದ್ದಾರೆ. ಎವಿಡೆನ್ಸ್ ಬರೋ ಅಷ್ಟೊತ್ತಿಗೆ ಡಿಫೆನ್ಸ್ ಚೇಂಜ್ ಆಗೋಯ್ತು. ಇದರಲ್ಲಿ ಈ ಡಿಫೆನ್ಸ್ ಇದೆ. ಮತ್ತೆ ಎಕ್ಸಿಬಿಟ್ DW2 page number 109.
Read only issue number 3, findings on issue number 3 and 4.
ಅದರ ಪೇಜ್ ನಂಬರ್ ಫೈಂಡಿಂಗ್. ಪೇಜ್ ನಂಬರ್ 63 ಪ್ಯಾರಾ 27 ಇಲ್ಲ ಪ್ಯಾರಾ 22 ದಲ್ಲಿ ಬರುತ್ತೆ. ಪೇಜ್ ನಂಬರ್ 59 ಇದು ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 59 ಅಲ್ಲಿ ಬರುತ್ತೆ.
Page 57.
59 ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ 59 ಅಲ್ಲಿ the defendants have contended that as per the exhibit D11 their ancestral property purchased 2/1 measuring 2 acre 18 guntas but not 202. No doubt the document not pertaining to the survey number 202 ಸೇಲ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಡಿಫೆನ್ಸ್ ಕನ್ಕ್ಲೂಷನ್. At the same time, there is no mention, there is no number mentioned survey number 2/1 under the circumstances, the difficulty to accept the ancestor of the dependent have purchased the land number survey number 2/1. There is no doubt it is not subject matter of the present suit on hand. ಇದರಲ್ಲಿ 2/2 ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರಂತ 2/2 ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರೆ 2/1 ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟೆ ಬಟ್ ಸರ್ವೆ ಪ್ರಾಪರ್ಟಿ ನಂಬರ್ ಮೆನ್ಷನ್ ಆಗಿಲ್ಲ ಅಂತ ಇದರಲ್ಲಿ ಡಿಫೆನ್ಸ್ ತಗೊಂಡಿದ್ರೆ. ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ DW2 ಪೇಜ್ ನಂಬರ್ 109 ಅದರಲ್ಲಿ ಸೇಲ್ ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ. ಎವಿಡೆನ್ಸ್ ಆಫ್ ಡೀಟೇಲ್ ಸೇಲ್ ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ, ಗ್ರ್ಯಾಂಟ್ ಬಗ್ಗೆ ಬಂದು. ಕೆಂಪರಾಜು DW2 109 ಪ್ಯಾರಾ 2.
If there is no defense, you appear for purchaser or
I'm for the subsequent purchases.
you have no role.
No.
You can't, you have no locus to
No.
contest this partition suit.
No.
You have to work out a remedies in final electric proceedings. Which property you have purchased?
My lord, item number 3 of the schedule, that
Huh?
2 acres 18 guntas,
Adralli 30 guntas you purchased.
30 guntas out of 3 acres.
ಪ್ರಾಪರ್ಟಿ
8
allotted to
And you can work out a remedies in the final electric proceedings.
ಆರ್ಡರ್ ಪ್ರಾಪರ್ 30 ಕ್ವಿಂಟಲ್ಸ್ allotted to share of dependent 9
ಬರ್ದಿದ್ದಾರಾ?
ಅವ್ರಿಗೂ ಬರ್ದಿದ್ದಾರೆ.
Also, my lord, in the land grant order, there is a slight mistake, that is typographical error. Instead of 2/2, it has been mentioned as 2/1. So in respect of that, there are certain exhibits, but I'll prepare and argue, I'll argue the matter, my lord.
No,
on
no,
text.
no.
No, during certain mutation entries where it is reflecting as 2/2 instead of 2/1.
Grant of what?
My lord, Timaka was the owner of 3 acres 8 guntas, my lord, out of which one Iranna, who is the paternal uncle of the respondent, is the subsequent purchasers. He had applied for an application for grant of occupancy rights. And in that, the grant of occupancy rights was issued in survey number 2/1, whereas that was a typographical error. It was supposed to be 2/2. In the same proceedings, my lord, one BS Garudappa, who is the son of Timaka, late Timaka, he has filed his affidavit objecting to the grant, And in his stand also, he has mentioned that this property is 2/2, not 2/1. So my lord, the subject matter is the same. Their contention is that what was granted to us was 2/1 and not 2/2. So
Exhibit P10 ಕೊಟ್ಟಿದ್ದಾರೆ, P10 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
my lord, exhibit D1 and exhibit D2, my lord, which is the,
Survey number is 2/2.
yes, my lord.
What's your case?
My case is that in the land grant order, it is mentioned as 2/1, my lord, instead of 2/2, which is a typographical error. But in the same case, they have filed an affidavit contesting the matter where,
Now, but partition suit is filed in respect of 2/2.
yes, my lord.
And you have purchased the portion of 2/2.
Yes, ma'am. But also in the same 2/2.
But in the grant, you.
Grant
mean
is
to
also
say
in
that
2/2, my lord. That is our contention.
Grant?
The grant in favor of our paternal uncle was also in respect of 2/2, my lord. In the same 3 acres, 8.
That issue is not involved here. We don't know.
Yes.
Whether there is an issue out to that effect.
Yes, my lord.
The only defense raised by your vendor is that item number 3 is not available for partition because it's already sold. Even if entire extent is sold, that will not bind plaintiff share. They are not signatories to the sale deed.
Yes.
That's all. And you are a purchaser. I will not hear you. Purchases appeal is?
Lord,
2004.
2013, 1650. 2000.
Page number 282.
Allah, defendants, one ನಿಮಿಷ.
Depend number 1 to 3 sold property. 1 to 3.
1 to 3 appeal ಯಾವುದು? Defendants 1 to 3 appeal.
1 to 3 appeal ಈಗ connected
2018.
2018. ಅವ್ರು ಬಂದಿರೋದು ಒಂದು ವಿಲ್ ಆಗಿದೆ, ಒಂದು ಪ್ರಾಪರ್ಟಿಗೆ ವಿಲ್ ಆಗಿದೆ. ಫಸ್ಟ್ ಶೆಡ್ಯೂಲ್ ಐಟಮ್ ನಂಬರ್ 1ಗೆ ಆ ವಿಲ್ ಪ್ರೂವ್ ಮಾಡಿಲ್ಲ ಅನ್ನೋ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ ಅದು ರಿಜೆಕ್ಟ್ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ ಅಲೋ ಆಗಿತ್ತು ವಿಲ್ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ.
RFA 2018, who has filed?
2018 ಇದರಲ್ಲಿ ಡಿಪೆಂಡ್ ನಂಬರ್ 1 to 3 ಫೈಲ್ಡ್.
Who appears for defendants 1 to 3?
ಎಲ್ಲ 3 ದಿವಸ ಬರ್ತಾ ಇಲ್ಲ ಅವರು.
He has suffered a fracture, my lord. That is why he was unable to.
You said that his rights are protected by the trial court. ಎಲ್ಲಿ operative portion,
ಅದು ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್.
Yes, ma'am.
ಎಲ್ಲಿದೆ?
Lord,
ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ 22 ಪೇಜ್ ಪೇಪರ್ ಬುಕ್ 59 22 ಪೇಜ್ ನಂಬರ್ 20 ಪ್ಯಾರಾ 22.
Property purchased by is to be allotted to the share of defendants 1 to 3. By equities are worked out in a prelim decree.
yes.
How we can maintain an appeal? How we can maintain an appeal? ಅದು ತಪ್ಪು, ಕೊಡಕ್ ಬರಲ್ಲ ಆ ತರ. ಅದೇ 30 ಗುಂಟಾಸನೆ ಫರ್ಟೈಲ್ ಇದ್ರೆ and how we can assert possession in respect of undivided interest.
My lord.
Sale ಯಾವಾಗ? What is the date of sale date?
Lord, 2004, my lord.
2004.
Yes, my lord. 1/12/2004.
1/12/2004 ಸೇಲ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್. Exhibit D10.
Yes, sir. We'll pass orders. There's nothing to argue. You want to drag on. There's the entry model,
Entry
but the
stay.
frame decree stayed.
ಇದೆ stay ಇದೆ.
Yes.
ಯಾವಾಗಿಂದ ಎಲ್ಲಿವರೆಗೆ you deposit all the income generated in the 30 guntas. You can't really misuse the pendency of this appeal. What is this? 2 days of the year 2007 and we are in 2024. In will be, there is no defense. Relations are admitted. It is admitted that this properties, 2 items were owned by Timaka. ಆಮೇಲೆ ಅವರು they are the children born through first wife.
Yes.
Your vendor is your vendors are children born through second wife. First wife ತೀರೋದ್ಮೇಲೆ ಮಾಡ್ಕೊಂಡಿದ್ದ.
ಹೌದೌದು. ತೀರೋದ್ಮೇಲೆ.
That is not in dispute.
ಇಲ್ಲ ಅದೇನು ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ. ತೀರೋದ್ಮೇಲೆ ಮಾಡ್ಕೊಂಡು ಸೆಕೆಂಡ್ ಮ್ಯಾರೇಜ್.
ಸಮಪಾಲ equal share.
ಈಕ್ವಲ್ ಶೇರ್ ಅದ ಈಕ್ವಲ್ ಆಗಿ ಕೇಳಿದ್ವಿ.
Equal ಆಗಿ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ.
ಈಕ್ವಲ್ ಆಗಿ ಕೊಟ್ಟಿರೋದು.
That's all. Reserved. By the counsel for appellant and counsel for respondents. Reserved.
Pen ಕೊಡ್ತೀನಿ.
Respondent.
Yes.
Respondent R1 LRs A SC2F, my lord.
Yes, madam.
Appellant, my lords. As
Settled, my lord.
matter.
Drawn up, we have also agreed. Problem is my clients are in the US. We have morning also there, my clients have also agreed.
You want time, Raju?
Yes, my lord, because they need to come sit together and they have to.
When you want?
Within 10 days, we'll do.
How did you take up a date? You pick up a date.
25th.
25th, order. Councils on record submit that matter is amicably settled. It is brought to the notice of this court that some of the parties are residing at states and therefore a short indulgence is sought. Prayer is allowed at the request of councils appearing for the parties. Matter is ordered to be relisted on so and so date to report settlement.
Much obliged.
Appellant's counsel.
Who are you?
Skating on thin ice. I've asked my friend for some, I'm in possession of the property. My lord, my case is that I am the defendant number 1 is my stepmother. It is my case that my father purchased the property in her name. I have certain number of hurdles I have. The section 14 would be a problem to me. Then the court comes to the conclusion that as on the date of this marriage, they set up a case that Yellamma is not my father's second wife. They set up that Yellamma is the wife of Lakshmana. Though we have placed certain documents on record to show that indeed she was my father's second wife.
Where's the family tree, Raju?
Family tree ಹಾಕಿಲ್ಲ ನೋಡ್ದೆ ಹಾಕಿಲ್ಲ.
ನೀವು ತಗೊಂಡ್ ಬರ್ಬೇಕು ಲಿಸ್ಟ್ ಆದಾಗ.
But it's very crudely done.
All right, I'll pen down. I need a family tree, otherwise it becomes very difficult to hear this matter. Who is the propositors? Trial court allo family tree ilva?
ಹಾಕ್ಲಿ ಅದೇ ನೋಡ್ದೆ ಹಾಕ್ಲಿಲ್ಲ ಇವರು.
ಬೆಂಗಳೂರೆಲ್ಲ ಕಲ್ಚರ್ ಇಲ್ಲ. ಪಾರ್ಟಿಷನ್ ದಾವ ನಡೆಸ್ತೀರಾ? ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಇಲ್ದೆ ದಾವ ನಡೆಸ್ತೀರಾ? ಇದೆಯಾ?
ಎಕ್ಸಿಬಿಟ್ ಆಗಿಲ್ಲ
ಕೊಡ್ರಿ. ಆಲ್ ರೈಟ್.
ಇಲ್ಲ ಸರ್.
ಯಾರು ಪ್ಲೇಂಟಿಫ್ ಯಾರು?
Plaintiff is the son of the first defendant.
B. Srinivas.
Yes, Srinivas. Son means stepson of the first defendant. No, it's like this one Basappa.
Whether it's a intricacy dispute between the branch of Guramma or
Between my stepmother and myself.
Correct. Now, Guruma is the first wife.
Gurama
is the mother of this.
first wife, my mother. Yellamma is now my stepmother.
Correct.
The property stands admittedly in Yellamma's name. I have filed a suit for partition. I know I am.
How she received this property?
My case is that my father provided the monies and purchased it.
14 is applied.
14 is applied.
It's the only property now.
That is the only property. I am in possession of the property.
No, only one room is in possession. Other portion is in my possession. Only one room is on his request he was. And I have filed a counter claim also.
A residential house.
Yes.
Residential house in Bangalore. ನಾವು ಸ್ವಲ್ಪ ದುಡ್ಡು ಕೇಳಿದ್ವಿ ಅದು ಸಾರು ಇದಕ್ ಮೇಲೆ ಕೊಡಕ್ಕಿಲ್ಲ ಇಷ್ಟೇ ಕೊಡೋದು ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ. We are asking for a little more. My sir is telling no, I will give you only this much.
You may not get anything if I decide this.
I know.
Why don't you grab it, take it?
No, in fact, my matter was almost settled. His wife came to the court hall and made a galata. Of course, before the other learned.
But on amount.
Wife, then better argue. This court is very sensitive.
I know that.
Raju sir, you also don't take a risk. Argue and.
If they are ready, of course.
But they are not ready. They want to take.
No, I am not. No.
ಇಷ್ಟಲ್ಲ ಅವ್ರಿಗೆ ಇಲ್ಲ ಅವರು ಮೆರಿಟ್ ಮೇಲೆ ಬೇಕು ಅವ್ರಿಗೆ ಮೆರಿಟ್ ಮೇಲೆ ಕೊಟ್ಬಿಡೋ. If that was already explored, then no second chance. If settlement was already explored, no second chance.
Lawyers are changed, except that.
Lawyers are changed, although some of this much was offered.
Whether you will assure that there will be that your client will take what is offered.
Last.
What was offered to you?
5 lakhs was offered. Only 5 lakhs.
5 lakhs.
What I told my
Bangalore,
friend
which
was,
part of Bangalore?
even in Bangalore ಅಲ್ಲಿ ಟೆನೆಂಟ್ ಖಾಲಿ ಮಾಡಿದ್ರೆ ಇನ್ನ ಜಾಸ್ತಿ ಕೊಡ್ತಾರೆ.
ಇಲ್ಲ ಎಲ್ಲಿದೆ ಸೋಮಶೇಖರ್ ಅವರೇ?
ರಾಜಶೇಖರಪ್ಪ ನನ್ನ ಸೋಮಶೇಖರ್.
Sorry, I'm sorry. North Bangalore or South Bangalore?
North Bangalore.
ಶಾಕಂಬರಿ ನಗರ.
ಎಲ್ಲಿ ಬರುತ್ತೆ?
Somewhere near Banshankri.
Somewhere near Banshankri.
Prime property?
ಇಲ್ಲ slum.
It's a small property. 800
45 ಅಡಿ.
800
20 ಅಡಿ 45 ರೋಡ್ ಮಧ್ಯದಲ್ಲಿ ಇದು ಓನ್ಲಿ 25 ಅಡಿ ರೋಡ್.
Please take that 5 lakhs.
ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಕೇಳ್ತಾರೆ.
ನಾನು ನಮ್ಮ ಕ್ಲೈಂಟ್ಸ್ ಹತ್ರ ಮಾತಾಡಿದೆ, because when the matter is being argued again I cannot go. I said on my own I can raise it to another 3 lakhs. Please give me liberty. They said up to 8 lakhs I am ready to.
Just take it.
Tomorrow day.
Yes. We'll ask them to come. Fair offer.
We'll ask them to come to court tomorrow.
Yes, tomorrow.
Yes.
Either you'll report settlement or you'll argue.
I'll do that. Argument ashte, so that is the facts. I know where I stand.
I think you are better placed to convince your clients.
And subject, but he must vacate. Only one room is in small 10 into 12 feet.
Tuesday, Tuesday.
Tuesday, all. The councils on record submit that there's a possibility of settlement. A request is made to grant some time to report settlement at the request of counsel for appellant and respondent. Matter is adjourned in order to be relisted on Tuesday.
Tuesday.
Um, 2004 ಯಾರು ಮಧ್ಯಾಹ್ನ 2:30.
Serial number 19, my lord. Serial number 19. ಇದರಲ್ಲಿ
ರೀಚ್ ಆದಾಗ
ಅಲ್ಲ ಏನಾಗಿದೆ, ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಆಗಿದೆ 641 of 2009. ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಆಗ್ಬೇಕಷ್ಟೇ.
ಅದಿನ್ನೂ ಸರ್ವ್ ಆಗಿಲ್ಲ.
ಅಲ್ಲಿ ಸರ್ವ್ ಆಗ್ಲಿಲ್ಲ. ಟೇಕ್ ಔಟ್ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್.
We'll call it at afternoon. Call it. ಮಧ್ಯಾಹ್ನ. No, wait. No mentioning at 1:30. Paper publication file ಇದೆಯಾ? ಏನ್ you want time? After that?
ಅಪಿಯರೆನ್ಸ್ ಆಗ್ಬೇಕಾಗತ್ತೆ, ಅದು ಬರ್ಬೇಕಾಗತ್ತೆ. ಅದು ಜಸ್ಟ್ ಬಿ ನೋಟಿಫೈಡ್ ಆಸ್ ಎ ಸರ್ವಿಸ್.
ಇವತ್ತೇ appearance.
ಸರ್ವಿಸ್ ಸಫಿಶಿಯಂಟ್ ಅಂತ ಆಗಿ ಡೇಟ್ ಫಿಕ್ಸ್ ಆದ್ರೆ
2005 matter.
ಅಲ್ಲ ಅದು ಇದು ಕಂಪ್ಲೇಂಟ್ ಸೂಟ್ 641 of
ಇದೆಲ್ಲ
2000.
ಬ್ಯಾಚ್ ಇದು ಏನಿದು?
ಅಲ್ಲ 641 of 2019 is the comprehensive appeal RFA. ಇದು ಡಿಸೈಡ್ ಆದ್ರೆ 4 ಅಪೀಲ್ ಹೊರಟೋಗುತ್ತದೆ. ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ಸ್ 4.
And tomorrow.
ಅಲ್ಲ ಇದು ಲೆಟ್ ಇಟ್ ಬಿ ನೋಟಿಫಿಕೇಶನ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಅಂತ ಆಗಿ ಸಫಿಶಿಯಂಟ್ ಅಂತ ಆಗ್ಬೇಕು.
ಅದು ಅಪಿಯರೆನ್ಸ್ ಬಂದಿಲ್ಲ ಇವತ್ತು, ಅದು ಹಿಯರಿಂಗ್ ಅಂತೆ ಬಂದಿದೆ. And why you are holding a caveat for those unserved respondents?
ಅಲ್ಲ ನಾನು ಅವ್ರಿಗೆ ಮಾಡ್ತಿಲ್ಲ, ನಾನು ಕೋರ್ಟ್ ಪರ್ಪಸ್.
2005 matter, sir.
I'm not for seeking.
Wait, I'll hear you and then I'll let you.
Much.
My lord. Serial number 28, my lord.
ಇದುವರೆಗಿಲ್ಲ.
Adjournment, senior ಸ್ವಲ್ಪ out of session, ಸ್ವಲ್ಪ personal inconvenience ಇಂದ.
Wait. Harish, why it was listed today?
My lord,
Harish,
yesterday
ನಿನ್ನೆ
they have
ಬಂದಿದ್ದಲ್ಲ?
moved, yesterday they have moved to the end of the list, my lord. It's a pending matter. Today it is posted for, they're saying that the temporary shed is constructing in their land. But here what happened, my lord, I am told that one temple was in the hill, man, on the hill. Temple ಇದ್ದಿದ್ದನ್ನ ಇವಾಗೇನೋ ಅದನ್ನ ಶಿಫ್ಟ್ ಮಾಡಿ ಅದರಲ್ಲಿ ಅಲ್ಲಿ ಒಂದು ಹೈವೇ ಹೋಗ್ತಾ ಇದೆ. Temporarily they are shifting here.
ಇವ್ರ ಜಾಗದಲ್ಲಿ.
ಇವ್ರ ಜಾಗದಲ್ಲಿ dispute, it's in dispute.
My lord,
Because we have already cancelled their grant also.
Grant ಯಾವಾಗ cancel ಮಾಡಿದ್ದೀರಾ? Whether it
61.
136(3) ಅಲ್ಲಿ
they will not,
Yes.
that they have
that
not
has been
challenged.
challenged before this honorable court.
ಅದನ್ನೇ
ಹೌದು.
Challenge matter
This pending, my lord, wherein they have right to interfere, my lord.
It's a temporary, my lord.
My lord,
Within few days,
petitions
we
and
will
vendors
remove
are
it and we'll give it to some other place, my lord. 2 acres land has been already allotted. to this
even we will
temple.
help out, my lord.
My lord, 2 acres land has been already allotted.
ಯಾರು ಮಾಡಿದ್ದದು?
My lord, ಏನಿಲ್ಲ, ಟೆಂಪಲ್ ಒಂದು ಬೆಟ್ಟ ಗುಡ್ಡದ ಮೇಲೆ ಇತ್ತು, ಒಂದು ಹೈವೇ ಹೋಗ್ತಾ ಇದೆ, ಅದು ಡೆಮಾಲಿಶ್ ಆಗ್ತಾ ಇದೆ. ಅದಕ್ಕೋಸ್ಕರ ಟೆಂಪರರಿ, my lord, ಕೈಂಡ್ಲಿ ಸಿ ದಿ ಫೋಟೋಗ್ರಾಫ್ಸ್, my lord. It is a temporary shed, my lord. ಅಲ್ಲಿ ಇವಾಗ ಸದ್ಯಕ್ಕೆ ದೇವಸ್ಥಾನದಲ್ಲಿ ಇಡ್ತಾರೆ.
But this temple, my lord, temporary means, my
2
lord,
acres of land has already been allotted to the temple, my lord.
Then you have to report compliance, you have to shift it, ಯಾವಾಗ ಶಿಫ್ಟ್ ಮಾಡ್ತೀರಾ?
My lord, within 2 months, my lord. 2 months ಅಷ್ಟೇ. ಅಷ್ಟೊಳಗೆ ಈ ಕೇಸು ಸಹ
temple, my lord, that's what I'm.
ಆಮೇಲೆ
Since it is temple, I'm finding it may not be possible to
Temporary.
shift. That's what my submission, my lord.
No, it's only by way of temporary arrangement, it's
But
shifted.
that's what, for that only with that,
We'll record his statement.
okay, my lord.
And we'll also record his statement that he undertakes to shift it.
Yes, my
Who
lord.
has to do it? Tahsildar has to do it.
And we will also contribute for the same,
For
for temple construction.
Whether AGA on instruction acknowledges that this temple, this structure, temporary structure, is constructed pending consideration of the caption petition. He has brought to the notice of this court that they had to shift the temple, which was initially located at the top of the mountain.
Yes, NH road.
And that had to be shifted in view of formation of road.
please, my formation of
Formation
NH in national highway.
Formation of national highways. He has submitted that this temporary shifting of temple in the petition land is by way of
Disputed land. It is not.
My lord.
petition land.
Petition.
Petitioner and petition land is by way of temporary measure. And the same will be shifted within a period of 2 months. Learned AG also undertakes that this temporary structure will be shifted within the within 2 months. Recording his submission. No further orders are required in the matter. Let this matter in B group.
Please.
Much.
Great.
Yes, Mr. Haldi.
I'm appearing for the appellant, Mulder. This is that RFA 1033 of 2004, Mulder. The dependent number 12 appeal, Mulder.
ಇದರಲ್ಲಿ
Oh,
family tree ಅಲ್ಲಿ ಇದೆ ಹಳ್ಳಿ. Where is the
please,
family?
please, Mulder. Family. The short point involved in this appeal, Mulder,
What's the defense?
that my relief, your lordship may kindly see in the appeal, my prayer is, Mulder, very limited prayer, Mulder, to short, Mulder. Seeking remand the matter to trial court, Mulder.
Why?
Because of that, Mulder, during the pendency of my appeal, Mulder, that my father, that Mahadevappa died, Mulder. Second dependent, Mulder.
Yes.
He died, Mulder. These LRs are came on record before the trial court, Mulder, except this appellant, Mulder.
You're also legal heir of Mahadev.
Please, Mulder, I am also daughter of Mahadev.
You'll be permitted to participate in final decree proceedings.
So what happened in this matter, Mulder? And immediately I filed an application for impleading, Mulder.
We'll permit you to appear in.
My submission, Mulder.
Ah.
Immediately after that, Mulder, filed an impleading application that was allowed, and also I come on record, Mulder. And subsequently, what happened, Mulder, I filed an application for the permission to file the written statement, and also that 8 documents, that original documents have been produced, that my application came to be rejected by the trial court on the ground that the written statement filed after 90 days. And my all the original records are kept in safe locker.
Now, what stand you have taken in written statement?
It is the self-accord, it is the absolute property of my father.
And your brothers have not taken that contention.
They have not taken contention, they filed the written statement, the 2A to 2G, they have filed the written statement, but nothing has been produced before the court. Immediately I came and record and filed my written statement, but your lordship may kindly see, surprisingly the trial court make an observation in the order sheet. Your lordship may kindly see order sheet.
Ali,
Please,
when your application was rejected, what is the date of rejection?
that I filed the writ petition also.
What happened to the writ petition?
So far as the rejection of my written statement. During the pendency of the writ petition, the suit came to be decreed, disposed of. So ultimately I brought notice to the trial court, the pendency of the writ petition, but they are not considered and rejected my the decreed the suit. And ultimately I have brought notice to this honorable court in pending writ petition. Accordingly, this honorable court has liberty to urge all the grounds in the appeal. So accordingly for this appeal, your lordship may kindly see, while rejecting my written statement, that order sheet kind moment on 28/5/2004. I'm sorry, 28/6.
All right, what are the grounds urged by you?
Please,
On what documents you claim that this is the?
They have produced the sale deed and sale agreement and relinquishment deed, executed by the plaintiffs, in favor of this, my father. That fact of the case is that, one Badige Hanumappa had 5 sons. Original propositor Hanumappa had 5 sons.
Hanumappa, yes.
How? And Bhimappa, Naga, less Nagappa, Yardo Antare, Naga, and Channabasappa, Ishwarappa, and Mahadevappa are 5 children. Out of which Bhimappa died issueless. And the plaintiff number 1, 2, and 3 are the sons of Nagappa. And the plaintiff number 4 and 5 are the grandson of Nagappa. And Channabasappa is no more. He has also died. Ishwarappa died. His wife Gauramma is also died. She has executed the registered sale deed in favor of that one Lingachari. Out of 6 acres, 39 guntas. Total extent of land.
How many lands are involved?
Only 2 lands. 2 lands. 2 lands. The total extent is.
According to you, both are self-accord property.
Please, entire the property regrant, it is Badigi Inam land.
Inam land.
How? Badigi Inam land.
Who is the original holder?
How?
Who is the original Inamdar?
Original Inamdar is my that.
Huh?
Like,
Yaro?
Nan idralli.
Hanumappa?
1 second.
Huh?
Allah.
Naga and Deemanna. Naga and Deemanna, my lord.
That,
My father, my lord.
that in the year
Plaintiff's
of
father.
that my lord, I will.
Plaintiff's father.
The entire Badigi Inam land vested with the government. Nevertheless, the wife of third son Hanumantappa, that Srimati Gauramma Malad.
Regrant yarigagide?
Regrant world ಇವರಿಗೆ ಆಗಿದೆ ಮಾದೇವಪ್ಪಗೆ.
ಅವಾಗ ನಾಗ ಇರ್ಲಿಲ್ವಾ?
ನಾಗ ಇರ್ಲಿಲ್ಲ. 44 ನಲ್ಲಿ ಹೋಗಿದ್ದಾರೆ. It was a giant family.
Nandu, what my submission is that already my written statement is on record, but it was rejected, and all the documents what they claim that, it is the proper.
Where are the documents?
Please, your lordship may kindly see.
Let us read your written statement. What is stated in your written statement?
Before that, while rejecting my written statement, your lordship may kindly see. There is the order sheet. ಇಲ್ಲ ಅದರಲ್ಲಿ ಏನಾಗಿದೆ that 28/6/2004, your lordship, kindly moment, see that, my lord. That IA number 13 is filed under section 151 of CPC for permitting the depend number 2 A to G ಅಂತ ಹೇಳ್ತಾರೆ. A to G already filed the return statement. But in this, what happened? Depend number 12 has filed the return statement along with IA number 13.
Read, where is that return statement?
Return statement, my lord.
ಇದೆಯಾ? Part of record.
ಹೌದು.
Records, LCR ಅಲ್ಲಿ.
374 OS 374 of 2003. It is not beyond the 90 days, my lord. Immediately, my impleading application was allowed, my lord. I came to file return statement. Our documents mark ಮಾಡಲಿಲ್ಲ. I filed the writ petition also, my lord. ಈಗ ನನ್ನ ಸೈಡ್ ಯಾವ ಎವಿಡೆನ್ಸ್ ಒಂದೇ ಎವಿಡೆನ್ಸ್ ಆಗಲಿಲ್ಲ ನಮ್ಮ ಸೈಡು. Depend number 5 has been examined. He supported the case of the plaintiff, my lord.
Who is the original inamdar?
That, my lord, I will see my return
Inam
statement.
ಯಾರಿಗಿತ್ರಿ?
That will para 2 of my return statement, my lord. I will read my return statement, my lord. The dependent further submit that survey number 21/1, I got it, my lord, no return statement. 6 acre 29 gunta situated at Aralalli village in Harihar Taluk was the Badgi Inam land. The first son of Badgi Hanamappa, that is, my lord, Bhimappa, died issueless. The plaintiff number 1, 2 and 3 are the sons of second son by name Naga, and Hanumantappa and plaintiff number 4 are grandson of Nagappa. The first son Naga by name Manappa was the father of the plaintiff number 4 and 5. Third son by name Chanbasappa and son of Hanumanto died issueless. Fourth son Ishwarappa, he died living behind his wife Gauramma. The fifth son Mahadevappa was the father of the depend number 1, 2, 3, 4, 5, 6 and 7 and grandfather of the depend number 9, 10 and 11. Depend number 2B to 2H are the grandson and granddaughters of the said Mahadevappa. This dependent further submitted since Inam Abolition Act came into force in the year of 1961. The entire Badgi Inam land vested with the government. Nevertheless, the wife of third son of Hanumantappa, that is Srimati Gauramma, sold an extent of 1 acre in survey number 24/1 and 2 in favor of the Lingachari under duly registered schedule dated 23/6/1969 for the valuable consideration of 300 only, and that and the certified copy is produced, my lord. That depend further submit that said Gauramma sold extent of 1 acre, remains only 5 acre 29 guntas of land, but the sons of Naga, plaintiff number 1, 2, 3 and son of Manappa were left the village and long back and residing elsewhere. The dependent or residing Guladalli village, Malebennuru, since Badgi Inam land was vested with government and Barwadars has no right to alienate said property. This dependent further submit that plaintiff number 1, 2, 3 and their elder brother by name Manappa executed the agreement of sale in respect of 2 acre 29 guntas of land belonging to them out of service Inam land to father of this dependent, that is Maheshwarappa Mallu. Under an agreement dated 22/7/1978 for valuable consideration of rupees 2,400, and in which it was specifically mentioned in the agreement that since the said property was not regranted in their favor, they are unable to execute the said deed. Hence, the agreement was executed. The agreement of sale have been produced, in the list of documents. This dependent further submit that second and fourth son of Hanumappa have lost their property as stated above. The execution of sale deed by Gauramma in favor of Lingachari to an extent of 1 acre and 2 acre 29 guntas, son of Nagappa, to an extent of 2 acre 29.5 guntas in favor of father of this dependent. Hence, the father of this dependent and said Lingachari were applied for a grant.
Only don't read entire return.
Please, madam,
statement.
I will come that one.
No, please read that relevant portion of the return statement where you have set up a claim that this regrant was in your individual capacity.
In para 6 ಅಲ್ಲಿ ಇದೆ in return statement.
ಎಲ್ಲಿ ಹೇಳ್ತೀರಾ ರೀಗ್ರಾಂಟ್ ಇಸ್ ಇನ್ ಯುವರ್ ಫೇವರ್ ಅಂತ?
that they are applied the re-grant part Badige servition of land in their favor. In the meanwhile, your lordship may kindly, they have applied mal that. In the meanwhile, the dependents that Rudrappa, depend number 3, depend number 4, depend number 5 executed the relinquishment deed, their right in Badige Inam land belonging to branch of Mahadevappa, son of Panmappa, as per the relinquishment deed dated 9/8/1980, and the same is here with produced so and so. The said relinquishment deed was executed during the pendency of the re-grant proceedings. Hence, the same is not registered. Then 7 paradalli.
What is the law on that point?
That your lordship may kindly say, para 7 on that.
Okay, now
It is not come on record mal that. That's why.
ಎಲ್ಲ ಓದಿದೆ.
It is my defense mal that.
ಎಲ್ಲ ಓದಿದ್ರೆ I have gone through the written statement. Regrant is in your favor, that is not in dispute. How you can exclude other family members in respect of Inam land?
That what happened mal that they have already executed relinquishment deed in my favor mal that.
Where are those relinquishment deeds?
That your lordship may kindly see that 9/8/1980 mal that.
ಏನು ತಲಾಟಿ ಮುಂದನ?
ಅಲ್ಲ ಅದು that during the pendency of the
Telatina?
re-grant proceedings mal that.
ಇದೆಯಾ? ರಿಜಿಸ್ಟರ್ಡ್ ಇದ್ರೆ ರಿಮಾಂಡ್ ಮಾಡ್ತೀನಿ.
Like say it is not registered because re-grant proceedings are pending mal that. Therefore ಬರ್ದಿದ್ದಾರೆ ಅವರು. Same is here with so and so said relinquishment deed was executed during pendency of re-grant, hence same was not registered.
Yes, sir. I've gone through the grounds raised in the appeal memo also. What are the connected appeals? You are appearing in all connected appeals?
ಅಲ್ಲ connected appeal ಅಲ್ಲಿ that other sellers of my that second dependent they have filed the appeal mal that. 2A to 2G.
ಒಂದು ನಿಮಿಷ. RFA 1033 of 2004 is by defendant number 12. Correct?
ಈಗ ಇದರಲ್ಲಿ on that point mal that I relying on one judgment mal.
ಕೊಡಿ ಬೇಗ ಕೊಡಿ.
How they are that trial court has mal that taken that my return statement beyond 90 days ಅನ್ನೋದಕ್ಕೆ ಅಲ್ಲಿ beyond 90 days ಇಲ್ಲವೇ ಇಲ್ಲ. At least whatever may be mal that defense, it should be considered my documents to be marked mal that. ಈಗ only depend number 5 as part of the return statement, nothing but he has supported the claim of the plaintiff mal that.
Yes.
ಇದರಲ್ಲಿ that so far as the order 8 rule 1 provision return statement
Correct.
filing
You're right.
beyond the limitation of 90
Yes,
days
yes,
ಅಂದಾಗ
you're right.
the honorable apex court my para 17 mal that. Para 17 ಅಲ್ಲಿ even of this matter in the fact and circumstance of the case in view of the reasoning given above, we hold that high court as well as the trial court had erred in rejecting the application for condoning the delay in filing the return statement. Accordingly, the application for condoning the delay is allowed and return statement filed by the appellant is accepted, and consequent thereupon, the impugned order which affirmed by the order of the trial court was rejecting the application for condoning the delay return statement is set aside. The trial court shall now proceed with the hearing of the suit and dispose of the same positively within the 1 year from the date of supply of the copy of this order. That honorable apex court that allowed the application and directed the trial court to take written statement on record and dispose of the appeal within a period of 1 year. My submission is that your lordship may kindly see the order sheet maintained by the trial court that I have filed the application seeking permission to file my return statement that along with 8 registered documents that.
Registered?
ಹೌದು, ಸೇಲ್ ಡೇಟ್ ಇದೆ, ಅಗ್ರಿಮೆಂಟ್ ಆಫ್ ಸೇಲ್ ಅದೇ, ಬಟ್ ಇನ್ ಸೋಪರ್ ರಿಲಿಕ್ವೆಸ್ಟ್ಮೆಂಟ್ ಡೇಟ್ ಒಂದು ಬಿಟ್ರೆ that remaining
what are those registered sale deeds?
That Gauramma has executed the registered sale deed mother. The documents ಇದೆ.
Who is Gauramma?
Gauramma is the wife of the third son of
Channabasapana.
Ishwarappa Malda. fourth son of Ishwarappa, Chanbasappa Anadanala,
What she has executed?
in respect of 1 acre land, mother, to one Lingachari. Other documents, list of documents are there, same has been produced before the trial court, mother.
No, she has executed a sale deed in favor of one.
Lingachari. And remaining 2 acre 29 guntas, this plaintiff have executed the agreement of sale, mother.
In whose favor?
In favor of this appellant father, mother. Our documents are produced, mother. Details of documents produced,
Now,
mother.
how that agreement to sell is going to help you?
Because, mother, that document.
Agreement to sell.
Agreement of sale and
The father, you should have enforced it. Within the family.
But my defense was not at all come on record on that.
No, I'm accepting all the defense. Question is whether this is the case.
Nan written statement record mag barlila.
I'm accepting all
So,
the contentions.
that filed the writ petition also mal that. Nan ಹೇಳಿದ್ದೆ ಹೇಳಲ್ಲ. Your lordship may kindly see, after rejecting my application for permission to see file a written statement mal that.
That's
I
wrong.
filed the writ petition mal that.
It is wrong. That order is wrong. I'll deal with it.
ಅದಕ್ಕೆ your lordship may kindly see provide an opportunity to me mal that. What happened as per the apex court in details they explain mal that. Apex court very same judgment mal that in what the relying on judgment apex court in so far the written statement is concerned of that. The appellate court cannot decide the appeal on merits mal that. It should be remanded to trial court to taken the written statement on record. That your lordship may kindly see. Para 16 mal that.
Yes, sir. Odidini, sir.
Please, para 16 ali. So, my only request is that already my documents are in safe custody before the trial court mal that.
Let them stay in safe custody.
ಅಲ್ಲ ಅವು ಯಾವ ಮಾರ್ಕೆ ಆಗಂಗಿಲ್ಲ ಅವು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೆನಾಟ್ ಬಿ ಮಾರ್ಕ್ ಮಾಲ್ ದಟ್
Right. ಇಲ್ಲಿ ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಜೆರಾಕ್ಸ್ ಕಾಪಿ.
ಅವು ಜೆರಾಕ್ಸ್ ಕಾಪಿಯಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಬಿಕಾಸ್
Is there? Where are those documents? Along with your appeal memo. ಮಾಡಿಲ್ಲ ಇಲ್ಲಿ.
ಅಲ್ಲ ಮಾಡಿಲ್ಲ ನಾನು ದಟ್ ಲಿಸ್ಟ್ ಇಸ್ ದೇರ್ ಮಾಲ್ ದಟ್ ಇನ್ ಅನದರ್ ಜಜ್ಮೆಂಟ್ ಮಾಲ್ ದಟ್ ಇನ್ ಸೋ ಫಾರ್ as the in additional documents in so far as the appeal is filed order 43 rule 1 you ಕೆಳಗಡೆ that appeal has been filed ಮಾಲ್ ದಟ್
Side. Give the judgment.
ಪ್ಲೇಸ್ ಮಾಡಿ ಇದರಲ್ಲಿ ಈಗ only my prayer is that your lordship may kindly provide an opportunity.
ನೋಡೋಣ. We'll hear and then we'll take.
ಈಗ ಇದರಲ್ಲಿ your lordship may kindly see that order 41 rule 23A and a 43 rule 1U section 9600 order of remand appeal against jurisdiction to decide the appeal on merits can be exercised by the appeal court only when appeal is filed under 96 or 100. Recording the finding on merits while remanding the case not within the jurisdiction of High Court mal that. That para 25 to 26 may read mal that. It is well settled that jurisdiction to decide the appeal on merits can be exercised by the appellate court only when the appeal is filed under section 100 or 96 or 100 of the code against the decree. So in miscellaneous, that appeal has been decided mal that. In the light of our discussion, we are the opinion that High Court have no jurisdiction to consider, much less deciding the entire case of the parties on merits in such appeal. We are also unable to agree with the High Court when it held that first appellate court, instead of remanding the case to the trial court, should have heard the appeal on merits. This finding, in our view, is bad in law for the reason. Firstly, it was not possible for the first appellate court how to record the evidence of the appellate stage. And secondly, having regard to nature of the factual controversy involved and keeping in view of the nature of the additional evidence filed, which too needed to be proved in evidence. It was not possible to retain the appeal to itself and invite finding only on additional evidence by taking recourse of powers under Rule 25. And lastly, wholesome remand as directed by the first appellate court would enable the trial court to appreciate the entire evidence on its proper perspective while deciding the suit fresh on merits. We are also unable to agree with the High Court when it was reversed the finding of the first appellate court in so far as it is pertinent to application filed under plaintiff under order 41 rule 27. In fact, I produced the documents is nothing but that order 41 rule 27 more that. Because my returns immediately after impleading more that, I was seeking permission to trial court to permit file me return statement and the entire document, 8 document list of documents are produced more that. It is ordered to keep in shop, safe locker custody more that. The trial court has passed the order more that. Therefore, my request is that more that whatever may be have produced the documents more that it is to be marked more that exhibits of. Now my evidence is not there more that. My evidence is not recorded by the trial court in the absence of my return statement. So only my request is that more that your lordship may kindly remand the matter. My prayer is also more that same more that. Your lordship may kindly see my appeal prayer more that.
ಆಯ್ತು ರೀ ರಿಮಾಂಡ್ಗೆ ಕೇಳಿದ್ದೀರಾ?
Please,
ಓದ್ಬೇಕಾಗ್ತದೆ.
please, ma'am, please, ma'am. I'm sorry, mother, because no opportunity was given, mother.
ಇದು
Your lordship may kindly fix 6 month time, mother. Time bond maybe fix, mother. On the same day, I have recorded my evidence, mother.
this connected appeals are filed by whom?
Connected appeal depend number 2 to A, 2 to J, mother. They are the nothing brothers of this appellant, mother.
ಅಲ್ಲೇ
ಹೌದು,
ಅಲ್ಲೇ ಸಿಕ್ಕಾಕೊಂಡ್ರಿ.
ಈಗ ನಮ್ಮನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ಲೇ ಇಲ್ಲ ಅವ್ರು ನಮ್ಮ ಬ್ರದರ್ಸ್.
ಸಿಕ್ಕಾಕೊಂಡ್ರಿ.
Now immediately after came to knowledge that.
Getting my point. You're not getting my point. I will answer you. I will answer it. What mistake you have done? That was a collusive.
No, mother.
And now you tell me.
Because of your lordship make momently that trial court order ನಾನು 2A to G ಅವರು ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿನಿ ಅಂತ ಹೇಳಿ ನಂದು ಬಿಯಾಂಡ್ ಟೈಮ್ ಅಂತ ಹೇಳಿ ನನ್ನ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಇನ್ ಫ್ಯಾಕ್ಟ್ ಐ ಆಮ್ ಡಿಪೆಂಡ್ ನಂಬರ್ 12 ಮಾಡಿದೆ.
All right. RFA 1034 is filed by whom?
1034 of 2004 filed by my brothers ಮಾಡಿದೆ. That depend 2A to 2G.
2A to 2G.
2G ಮಾಡಿದೆ.
Upon death of
Second dependent.
second dependent.
Second
Upon death of second dependent.
All right.
2A to G were brought on record. Then, my lord, subsequently the daughter has come on record as 12th dependent. That daughter of original second dependent.
Second dependent.
But brothers have filed the data statement.
All right. 2A to 2G have filed.
ಅದು 560 of 2021 ಮಾಡಿದ pertaining to that FDP ಮಾಡಿದ. FDP has been declared ಮಾಡಿದ.
Yes. And the next appeal is by?
560 of 2021 filed by my brothers against the FDP decree ಮಾಡಿದ. FDP has declared ಮಾಡಿದ.
Final decree is also drawn.
Drawn ಮಾಡಿದ.
Also registered, my lord. Final decree is also registered.
ಹೌದಾ?
And I have filed a
ಅದಕ್ಕೆ
suit for.
ವಾಟ್ ಆರ್ ಮೈ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ.
All right. ಇದು ಯಾರು ಹಾಕಿದ್ದಾರೆ?
ಪ್ಲೇಸ್ ಮಾಡಿದ. ಇದನ್ನ ಅದೇ ಡಿಪೆಂಡೆಂಟ್ 2 to A
ಅವ್ರೇ
1034 ಅಲ್ಲಿ ಇದ್ದವ್ರೆ ದಟ್ ಫೈಲ್ದಿ. ಈಗ ನಾನು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೇಳೋದಕ್ಕೆ we have not come, my return statement was not come on record ಮಾಡಿದ. It is only after the trial ಮಾಡಿದ. 3 months or 6 months time fix ಮಾಡಿದ್ರೆ only that documents ಏನು what produce ಮಾಡಿದ come on record ಮಾಡಿದ as a exhibits.
Yes, sir. Gopal, sir.
Your lordship, I kindly take the genealogy, my lord. Genealogy. My lord, one Hanumappa, admittedly, my lord, this is the genealogy. Hanumappa had 5 sons, my lord. 5 sons, your lordship.
ನೋಡಿದ್ದೀನಿ.
My lord, your lordship.
ಕೊಡಿ.
ಇದು ಅದೇ ಸೇಮ್ ಐ ಥಿಂಕ್, my lord. After the death of, yes. My lord, 3 branches, my lord, no issues. Only 2 branches. That is plaintiff's branch, Naga. Through Naga, my lord, we are claiming.
The other 3 all have died.
All have died and no issues. And Mahadevappa's branch, they are.
Mahadevappa's branch, they are.
ಅವ್ರದ್ದು ಡಿಪೆಂಡೆಂಟ್ಸ್. ಇದ್ರ ಗ್ರ್ಯಾಂಡ್ ಚಿಲ್ಡ್ರನ್ ಬರ್ತಾರೆ ಮಹಾದೇವಪ್ಪಂಗೆ.
ಈಶ್ವರಪ್ಪನ ಹೆಂಡತಿ ಗೌರಮ್ಮ. She is also died, no issues.
ಅದು ಸ್ವಲ್ಪ ಮಾರಾಟ ಮಾಡಿದಾಳೆ, ಅದನ್ನ ಅವ್ರು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದಾರೆ. ದಟ್ ಇಸ್ ನಾಟ್ ದಿ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ದಿ ಸೂಟ್, ಮೈ ಲಾರ್ಡ್.
Oh, they sales are up.
Sales, Lingachari also applied for regrant. And from Lingachari, he appears to have purchased. We are not claiming anything in that.
Now,
what is being claimed is 6 acres, 38 guntas, my lord, which is regranted in favor of second defendant.
Because all other brothers had died. Now, who is the Inamdar?
Inamdar, my lord, Naga, my lord, your lordship, kindly see exhibit P2.
P3, P4, P6, Naga and Bhimappa's name finds. But there, Madheppa's name does not find a place. It was a joint family.
So it was actually the Inam holders were Naga and Bhima.
Naga,
Actually, they are not entitled.
yeah, they are not entitled, but we have said it is joint family property all. Well, what has happened is, well, the Naga died in 1944. 1944. Then, Milord, these other three brothers of Naga were not there. Madheppa was there. Madheppa assumed the charge of Karta.
And he sought for regrant.
And no, he did not seek for regrant. Milord, he died. Thereafter, Milord, this Maheshwarappa, he performed the function as Karta. That is defendant number 2. He applied for regrant. He applied for regrant. He was there, Milord, on the date of sale. Milord, under 2 regrant orders. One is, Milord, in 78.
Inam was jointly issued to Bhimanna and Naga.
Naga and Madheppa are the
Bhimanna and Naga.
Bhimanna and Naga. ಅವ್ರ ಹೆಸರಿ ಮಾತ್ರ ಇರೋದು. ಈ ಈಶ್ವರಪ್ಪನ ಹೆಂಡತಿ ಮಾರಾಟ ಮಾಡಿದ್ದು ನಾವೇನು ಇದರಲ್ಲಿ ಸೂಟ್ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಆಫ್ ದಿ ಸೂಟ್ ನಲ್ಲಿ ಇಲ್ಲ. ಅದು ಲಿಂಗಾಚಾರಿ ಹೋಯ್ತು, ಲಿಂಗಾಚಾರಿ ರೀಗ್ರಾಂಟ್ ಮಾಡಿಸ್ಕೊಂಡ, ಇಬ್ರು ಅಪ್ಲೈ ಮಾಡ್ತಾರೆ. ಲಿಂಗಾಚಾರಿಯಿಂದ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದಾರೆ. ದಟ್ ಈಸ್ ನಾಟ್ ದಿ ರೀಗ್ರಾಂಟ್ ಈಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಲಿಂಗಾಚಾರಿ ಮಿಲಾರ್ಡ್ ದಿ ಪರ್ಚೇಸರ್ ಫ್ರಮ್ ಗೌರಮ್ಮ, ವೈಫ್ ಆಫ್ ಈಶ್ವರಪ್ಪ. He said, because he said, Milord,
ಬೇರೆ ಪ್ರಾಪರ್ಟಿಗಳು.
That is not the subject matter of the suit at all. That is the point, Milord. What is the subject matter of the suit is, Milord, 2 lands, your lordship may kindly see. 2 lands, one is 4 acres 31 guntas, another is about 2 acres or so. 6 acres, this is all, Milord. Excluding that, some properties have been sold. And regrant is obtained, Milord, admittedly obtained, in respect of only suit schedule property in the name of second defendant. In 78 and 80, there are 2 regrant. One is in 78 in respect of one of the items.
Now, what the
And Milord,
wait, don't
replacement.
Milord, after Lingachari sold, Lingachari to whom the property was sold by Gauramma, what remained is, Milord, 8 acres 38 guntas. Milord, we all sold 2 acres in 1974. Exhibit P1 is the sale deed.
Which land?
That is some extent in the suit schedule, in the suit schedule survey numbers, not the suit schedule extent.
Oh, not extent.
Not extent. We sold.
They were not Inam lands. How you know?
ಅದು ಇನಾಮ್ ಲ್ಯಾಂಡ್. ಅದು ಸೇಲ್ ಮಾಡಿದ್ರಿಂದ 74 ನಲ್ಲಿ.
So that is not included.
That is not included in the regrant. Milord, exhibit P1 is the sale deed for which, Milord, plaintiffs and defendants, Milord, present defendants, some of the defendants representing the branch of Madheppa have executed the sale deed. In that, Milord, sale deed executed the sale deed in respect of suit schedule survey numbers only, but not the extent involved in the suit schedule survey number. Milord, your lordship may kindly see exhibit P1 is the registered sale deed dated 37/74 in favor of one, Milord, Devendrachari. The extent is, Milord, in survey number 21/4, 32 guntas. Here, Milord, survey number, item number 1 is survey number 24/1. Remaining extent, other than this, kindly see, Milord, suit schedule. Total extent is, Milord, 8 acres 38 guntas. Excluding, Milord, this 2 acres sold by us, defendants and plaintiff. Wherein, Milord, in the sale deed, your lordship may kindly see.
Just a minute. Survey number?
Survey number 24/1 and 24/2. 24/1 is, Milord, the extent is 2 acres 7 guntas. That is schedule A, Milord. 2 acres 7 guntas. In survey number 24/1. B is, Milord, item number B, 24/2, 4 acres 31 guntas. Totally put together, Milord, it comes to
1P ದಲ್ಲಿ ಎಷ್ಟಿತ್ತು extent?
ಜಾಸ್ತಿ 8 acres 38 guntas ಇತ್ತು.
It was 8 acres?
38 guntas.
That is sold by plaintiffs and defendants.
Defendants under exhibit P1 to the extent of 2 acres.
2 acres is sold.
2 acres is sold.
Ah.
Remaining extent, he got the regrant. Second defendant, that is only the suit scheduled property.
So extent of regrant is only 2 acres.
6 acres. Sir. Total extent is 8 acres, 38 guntas, out of which under exhibit P1, 2 acres came to be sold. But in respect of both the survey numbers. Remaining, my lord, 6 acres, 38 guntas.
Correct.
That is re-granted to them. That is the subject matter of the suit.
ಇಲ್ಲ ಬಟ್ ನೀವು ಕೇಳ್ತಾ ಇರೋದಿಲ್ಲ 2 acres ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಓ ಎರಡು ಸೇರಿ.
ಸೇರಿ. ಇದು ಎರಡು ಸರ್ವೆ ನಂಬರ್ 24/2 ಮಿಲಾರ್ಡ್ 4 acres 31 guntas.
2 acres was sold jointly by plaintiff.
Jointly by plaintiff fund. In 74, my lord, a statement is made. Your lordship may kindly see in this. We are all joint family property. My lord, it is part of these 2 survey numbers only. This is not outside or any other survey numbers. What is sold is, my lord, in survey number 24/1.
Excluding 2 acres, regrant was only to an extent of 6 acres.
6 acres and 28 guntas.
So this was sold before regrant.
Before regrant, my lord. My lord, your lordship may kindly see in the sale deed, this is what, my lord, it is mentioned. My lord, the defendants and plaintiffs, some of the defendants and plaintiffs representing the branch of Naga and my lord Mahadevappa have sold 2 acres, 32 guntas in 24/1, suit item number 1, survey number. I'm not saying the extent, my lord, extent is different, which is not the subject matter of suit. And in survey number 24/2, my lord, 1 acre, 8 guntas. Total 2, my lord, your lordship may put together, my lord, this 8 acres, 38 guntas, it comes.
Take it as 1 unit, 24.
24. So what remains is, my lord, 6 acres, 30.
It has come in evidence.
It has come in evidence, my lord. And they are parties, your lordship may kindly see, these are.
The regrant is marked at.
Regrant mark madilla avru. My lord, what has happened is return statement is filed by defendants 2A, 2G, 2B, adopted by 2A, C to G. And those defendants were given plenty of opportunity. 13 times matter was adjourned for my cross-examination. They did not do it. Then application was filed for seeking permission to cross-examine, and it was not granted. They did not challenge it. And they never stepped into the witness box to, to place all these records. My lord, your lordship may kindly see the return statement which my learned friend
At
has.
what stage he filed?
He filed, my lord, he filed in 2004.
Defendant number 12.
Sister, my lord, sister.
At what stage she files?
He files, my lord, after they were brought on record, she comes on record. At what stage is, my lord? Because all this, this is.
At 27/2/2004, my
This application was filed, my lord. 18/3, 2004, 10/3/2004, she came on record. 12th defendant.
ಅದು ನೋಡೋಣ ಯಾರು ಹಾಕಿದ್ದಾರೆ ಅಪ್ಲಿಕೇಶನ್ ಅದು.
My lord, my father died on.
Then, my lord.
No, I want to know who is the advocate who has filed.
Yes.
My lord, my father died on 19/3/2003, my lord.
That I think, my lord. Because brother's application.
My lord, on 27/2/2004, I filed an impleading application, my lord. That in the March 2003, my father died, my lord. My brothers are come on record, my lord. And 27/2/2004, I filed an impleading application that came to be allowed, my lord. And I come on record as a dependent number 2. And 19/3/2004, WS dependent taken not filed, my lord. And 27/5/2004, IN number 13 came to be filed by this appellant, along with WS, and produced 8 documents, my lord. On 28/6/2004, IN number 13 came to be rejected on the reason that dependent number 2 already appeared on 25/1/2003. Where is the question, my lord? I come on record on 27/2/2004. The findings recorded by the trial court that I already appeared on 28/1/2003, my lord. I am not appeared, my lord, on that day. Therefore, my return statement.
Who is, please mention the name of the lawyer who has filed that impleading application on behalf of defendant number.
Impleading application, my lord.
ಯಾರು ವಕೀಲರು ಫೈಲ್ ಮಾಡಿದ್ರು?
Sorry. On 27/2.
Sir, are you aware of who filed?
ಇದರಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್
That is
ಕಾಣ್ತಾ ಇಲ್ಲ.
very relevant. That is very relevant.
Relevant, my lord.
Who
Yes,
filed? Who filed that?
brothers had taken opportunity, they did not need evidence. Now, my lord, daughter was set up. All right, my lord, let her come on record. She has come on record, but
What's the name of the lawyer who filed in pleading application?
that is
That
not
27 to Malad.
Colour coded.
I number.
12th defendant ಗೆ.
Different number 2 ಹಾಕಿದವ್ರು ಯಾರು?
ಬಸವರಾಜ್ ಅಂತ ಇದೆ, DP ಬಸವರಾಜ್.
ಬಸವರಾಜ್ ಅಂತ ಹೇಳಿ ಹಾಕಿದಾರಾ?
ಇದು ಹಿಂಗ್ ತೋರಿಸುತ್ತೆ ಇಲ್ಲಿ. D12 ಬ್ಲಡ್ 134 ex parte, D22A and 12 ಬಸವರಾಜನೇ ಅಂತ ಇದೆ. ಇದು ಎಲ್ಲರಿಗೂ ಅಂತ ಕಾಣುತ್ತೆ. ಅದೇ ಇದ್ರಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಆಗಿದೆ.
ನೋಟಿಸ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
ಇದು ನಮ್ದು
ಬಸವರಾಜ್ ಇಲ್ಲ ಫಾರ್ ಅವರು
DP ಬಸವರಾಜ್ ಅಂತ ತೋರಿಸುತ್ತೆ.
ಪರವಾಗಿಲ್ಲ.
and defend number 11.
DP ಬಸವರಾಜ್ ಅಂತ ಇದೆ ಇಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ಆಗಿ.
ಅಲ್ಲ 12 ಗೆ ಯಾರು ಹಾಕಿದ್ದಾರೆ ನೋಡಿ pleading. Who is the advocate who has filed?
On 27 to 2004.
We can gather it from here, from what is transpired before this court. All these 3 appeals are filed by one lawyer. That is enough.
Yes. That is also, my lord, she is a daughter, and my lord, his brother has contested. My lord, return statement which he has read is the brother's return statement.
Any observation by the trial court that they took sufficient time to cross-examine?
Yes, my lord. My lord, I have got the order sheet. 13 times, my lord, they were given cross-examination.
Whether it is
ಅದು ಬರ್ದಿದ್ದಾರೆ, ಅಪ್ಲಿಕೇಶನ್ ಇದೆ ನನ್ನ ಹತ್ರ, ಆರ್ಡರ್ ರಿಜೆಕ್ಟ್ ಆಗಿರೋದು.
reflected in the judgment.
ಅದು ಇನ್ ಸ್ಪೈಟ್ ಆಫ್ ಆಪರ್ಚುನಿಟಿ ಅಂತ ಬರ್ದಿದ್ದಾರೆ. 13 ಟೈಮ್ಸ್ ಅಂತ ಇದು ಆರ್ಡರ್ ನಲ್ಲಿ ದೇರ್ ಅಪ್ಲಿಕೇಶನ್, ಡಿಫೆಂಡೆಂಟ್ಸ್ 2's application, LR's application was rejected on the ground to cross examine me. 13 times it was given and order is passed on the application rejecting. That has attained finality. So far as 12th defendant is concerned, my lord, 3 times opportunity was given to file return statement. They did not.
Oh, even she was given 3.
She was given opportunity, my lord. I have got the dates. And then, my lord,
Para 5 ಅಲ್ಲಿ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ para 5 of the judgment.
she has not filed the return statement.
ಹಳ್ಳಿಯವ್ರೆ
ಆಯ್ತು ಅವರೇ ಹೇಳಿ.
ಅವರೇ ಹೇಳ್ಬೇಕು ಈಗ. ನೀವು ಭಾಳ ಜಾಸ್ತಿ ಗಲಾಟೆ ಮಾಡಬಾರ್ದು ಈ ಕೇಸ್.
ಇಲ್ಲ
ಹಳ್ಳಿ
ಪ್ಲೀಸ್ ಮಾಡಿ.
This is a collusive setup. Same lawyer files.
ಇಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಎಲ್ಲಿ ಬಂದಿಲ್ಲ.
ಸರ್ ನಾವ್ ಇಲ್ಲಿ ನೋಡ್ತಾ ಇದೀವ್ರಿ.
ಪ್ಲೀಸ್ ಮಾಡಿ.
ಇಲ್ಲಿ ಕೂಡ ನೀವೇ ಹೇಗೆ ಅಪೀರ್ ಆಗ್ತೀರಿ? Having appeared for defendants 2A to 2G, how we can maintain an appeal?
27 to 2004 of had an IA number.
ಎಲ್ಲ collusive. You're all together. Same lawyer is engaged.
ಅಲ್ಲ para 5 ಅಲ್ಲಿ ಇಲ್ಲ para 5 ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕ್ಯಾಂಡ್ಲಿಸಿ para 5 of the judgment ಮಾಡಿದೆ. That para ಇಲ್ಲ para 5 of the judgment your lordship may kindly say. Para 5 ಅಲ್ಲಿ the defendant number 12 intend to file his return statement by an application same was rejected by this court. No other findings was recorded whether sufficient.
Correct ರೀ. ಆ ಆರ್ಡರ್ ತಪ್ಪಿದೆ. That wrong. It's wrong. ಹಿಂಗೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜಸ್ ಮಾಡೋ ಕೆಲಸ.
Here also,
ಅಪರ್ಚುನಿಟಿ ಕೊಟ್ಟು ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬೇಕಾಗಿದೆ.
ಕೊಟ್ಟಿದ್ದಾರೆ, ಅಲ್ಲೂ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಇಲ್ಲೂ your lordship may kindly say 3 times matter.
Sir, return statement should have been taken on record. ಅದ್ರಲ್ಲಿ ಏನು?
No, ಅದು ಹಾಕಿದಂಗಿಲ್ಲ, ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅದು. ಅವ್ರು ಓದಿದ್ದೀಗ 12
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲೇ ಇದೆ ಅಲ್ಲ.
ಅಲ್ಲ 2D ಇದೆ, 2D ಇದೆ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್. Not my lord, his return statement. He sought for permission. Your lordship may kindly see.
That return statement is part of record.
ಅದಲ್ಲ, ಅದು 2B ಹಾಕಿರೋದು.
12 ಅಂತಿದೆ.
ಅಲ್ಲ ಅದು ನನಗೆ ಅವ್ರು ಓದಿದ್ ನೋಡಿದ್ರೆ ಅಲ್ಲ 12 ಅಲ್ಲ, ಅದು 2B ಅಂತ ಇದೆ.
12/6/2003 your lordship may kindly see.
12/6/2000. ಅಲ್ಲ ಇದು ನನಗೆ ಗೊತ್ತಿದ್ದಂಗೆ ಇಲ್ಲಿ ನನ್ನ ಹತ್ರ ಕಾಪಿ ಇರೋದು 12B ಅಂತ ಇದೆ, 2B ಅಂತಿದೆ. ಅದು B ಆಗ ಸಾಧ್ಯ ಇಲ್ಲ ಅದು.
ಅಲ್ಲ, ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಬೈ ಡಿಫೆಂಡ್ ನಂಬರ್ 12 ಇದೆ.
ಅಲ್ಲ ಇದು
ನಾಗರತ್ನ ಅಲ್ವಾ? ನಾಗರತ್ನ
ಸೈನ್ ಮಾಡಿದ್ರೆ ಆಯ್ತು. ಇಲ್ಲ ನನ್ನ ಹತ್ರ ಇರೋ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್
ಸರ್ ಇದೆ ಸರ್. We'll accept that return statement.
Yes.
I have gone through the return statement. I have to examine whether she has made out a case for remand.
Remand. Yes.
I have to examine in the
Yes. Here
context. complete context of the
Yes, yes,
conduct.
that is true, my lord.
Okay.
My lord, what has happened is, here, my lord, 3 times RFA was dismissed by default. In the meanwhile, my lord, FDP was pending and it was proceeded, and my lord, commissioner was appointed and
Final decree is drawn now.
my lord, kindly come to my lord, para 13 of the judgment, my lord, 13 and 14. That's all, my lord, with regard to merits. There is any merit, my lord, I can understand, my lord. Your lordship, para 13, your lordship got, my lord. Para 13. Now we shall have to consider whether the plaintiffs are able to show that the suit schedule properties are ancestral properties of themselves and defendants, and they are enjoying the said property jointly at the time of filing the present suit. As per Exhibit P2, P8, Index of Land, Survey number 24/1, 24/2,
Yes.
and 24/1 and 24/2, that is suit schedule survey number. 24/3 were standing in the name of Badagi Service Bhimanna, that is Bhimanna and Naga, and Malla son of Bhimanna, respectively. As per Exhibit P7, another index of land, survey number 24/5 is also standing in the name of Mallappa, son of Pannappa. Survey number 24/1 and 2 were standing in the name of Bhimanna and Naga as per Exhibit P6, index of lands. According to genealogy shown at para 2 of the plaint, it clearly goes to show that the said Bhimanna and Naga are the sons of original propositors Hanumappa. As per the said judgment document, the father of the defendant 1 to 7 and grandfather of defendants 8 to 11 by name Madhyappa was not at all holding any lands. Your lordship may kindly see, this is Naga and Bhimanna. Father of the defendant never shown. Even then, my lord, we say it is a joint family. It was here they have said. So from this document, it clearly goes to show that the said survey numbers were cultivated by Bhimanna and Naga in their joint family. Now, let us consider Exhibit P3 record of rights in respect of 24/2, which was earlier standing in the name of Naga. Though the name of defendant 2 by name Maheshwarappa has been entered in pursuance of regrant as per Exhibit so-and-so, as per white document number so-and-so. As per Exhibit P5, survey number 24/1 is in the name of Maheshwarappa, that is second defendant, my lord. Father, as per regrant order number so-and-so. As per Exhibit P6, also survey number 24/1 and 24/2 were standing in the name of Bhimanna and Naga respectively. In respect of grant made in favor of Maheshwarappa, mutation arising bearing number 57, 80, 81 is also produced as per Exhibit P9. Another record of right is also produced at Exhibit P2 to show that the said lands were in the name of Bhimanna and Naga. Now, from the perusal of these documentary evidence clearly goes to show that the earlier suit schedule properties were in the name of Naga, father of plaintiff 1 to 3 and grandfather of 4 to 5. Only the contention of defendant 2 is that the said properties are granted in the name of Maheshwarappa, and hence these properties are his individual properties. The defendant 2B is the legal heir of the deceased defendant 2, and hence the legal heirs of deceased defendant number 2 are only having right over the suit schedule properties. Further, the contention of defendant 2B is that during the year 1962, there was a partition between defendant 2 and his brothers. Though defendant Jubani Parikat with the help of Palipati, but the said defendant has neither produced any documentary evidence nor oral evidence to prove the said aspect. So it clearly goes to show that the defendants have failed to establish in respect of partition of the year 1962 through Jubani Parikat with the help of Palipati. It could be gathered that there was no family partition in the family of plaintiffs and defendant till so far. Under such circumstances, it clearly shows that the suit schedule properties are still joint family properties of the defendants and plaintiffs and defendant. When the plaintiffs and defendants are in joint, even though the suit schedule properties granted in favor of defendant 2 in the year 1980-81, but those properties will have to be treated as joint family properties, because earlier to grant, the said properties were in actual peaceful possession and enjoyment of father of the plaintiff 1 to 3 and grandfather of defendants 4 and 5 by name Naga, plaintiff Antag. So it shows that said Naga was in actual peaceful possession and enjoyment of the suit schedule property. Even though the suit schedule properties are re-granted in the name of defendant, it is made on behalf of the joint family. On the other hand, from the perusal of evidence of PW 1 to 3, it clearly goes to show that there is no partition in the suit schedule properties between the plaintiff and defendant. Even though defendant 2B has contended that the plaintiffs have sold their share in the house property in the year 1977 in favor of one Chikkappa, but that aspect has not been cross-examined in the evidence of PW 1 or PW 2 and PW 3. Moreover, they were not at all produced any iota of evidence to that aspect. Exhibit P1 is the certified copy of this is important, my lord, your lordship. Sale deed clearly speaks in respect of alienation made by the plaintiffs and defendants on 3474 itself. From this document clearly goes to show that the plaintiffs and defendants together have sold the property as mentioned in the.
Yes, Lord.
So ಅದರಲ್ಲಿ ಇಬ್ರದ್ದು ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಬರ್ಕೊಂಡಿದ್ದಾರೆ.
Have the defendants have let in any evidence, oral evidence?
Oral evidence ಏನಿಲ್ಲ ಅದು. Milord,
DW1 Bhimappa is nothing but supporting the claim of the plaintiff.
DW1 is Bhima, Milord, one of the second defendant's brother, he said plaintiff's case is correct, he share half of is granted.
WSL ಏನ್ ಹೇಳ್ಬಿಟ್ಟ ಅವ್ರು ಸೂಟ್ ಡಿಕ್ರಿ ಮಾಡ್ರಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟ DW1. ನಮ್ ಎವಿಡೆನ್ಸ್ ಆಗ್ಲಿಲ್ಲ.
Gentlemen.
Your lordship may kindly see 28/6/2004 more that what the trial court has recorded the finding while rejecting my IA number 13. Your lordship may kindly see on 28/6/2004 more that that objection was filed by the plaintiff to my application. Said dependents have already appeared through their counsel on 28/1/2003. I am not appearing more that. I have appeared on only in the year of 2004 more that. Immediately if I came to file application, the findings recorded by trial court while rejecting my return statement that 2A to 2G filed this application ಅಂತ ಹೇಳ್ತಾರೆ. ಅವ್ರು already before that more that their return statement is taken on record more that. My return statement IA number 13 was came to be rejected on the ground that this appellant has filed the beyond 90 days.
Order sheet ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ಅದು?
28/6/2004 more that.
That is 13
Adjournments.
adjournments, my lord. ಇದ್ರಾಗಿದೆ. ಇಲ್ಲಿ.
Then it was taken as no cross or they were permitted to cross examine?
No.
But they did not cross, then they filed application for 13 adjournments, for 13 occasions, they were given time. Then they filed application.
That was rejected.
That was rejected.
They were not allowed to cross examine.
Not,
Then this application is filed.
then this application, I think, my lord, subject to correction, my lord, I don't know, but same advocates, my lord, files.
Advocate, same advocate is filed.
And your lordship knows, my lord, that judgment of this court is that if in respect of Inam lands, one of the division bench, my lord, that is what.
The individual capacity ಬರೋದಲ್ಲ ಇದು.
ಬರೋದೇ ಇಲ್ಲ. It is ಅದು ನಾಗನ ಹೆಸರಿದೆ, ನಮ್ಮ ತಂದೆ ಹೆಸರಿದೆ. ಅವ್ರಿಗೆ ಬರ್ಲಿಕ್ಕೆ ನಾವು ಮಾಡಿದ್ರೆ ಕಂಟೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ ಬರ್ತೀವಿ.
ಬರಿಬೇಕೀಗ ಹಳ್ಳಿಯವ್ರ ಕ್ಲೈಂಟಿಗೆ ಕೊಡಬಾರ್ದಾಗಿತ್ತಂತ ಬರಿಬೇಕೀಗ.
27/2004 my application was already in order sheet more that and 2 times granted more that. On 10/3/2004, 18/3/2004, finally on 19/3/2004 WSC penny depend number 2 and 19/3 I file an application more that.
So you
Permit without.
You didn't file on 3 occasions time was granted.
ಅಲ್ಲ ನಾನು 2 occasion.
3 occasion matter was urgent only to enable you.
No,
to
more
file
that.
extension.
On 27/2/2004 my implementing application was allowed more. I come on record on 10/3/2004 and amended plaint was filed and the one time is granted but WSC penny on 18/3/2004 and subsequently 19/3/2004 depend number 12 is absent, WS not filed.
All right.
And immediately file an application along with 8 documents more that. Whatever may be more that. My submission is that whether I am entitled or not more that my documents can be taken on record to the trial court or to record the findings on my documents more that.
Yes, sir.
So my request is that as per the observation made by the apex court more that so my WS may be taken on record and dispose of the suit as a press within a period of 3 months more that. None documents already on record more that.
Order on IA number 10 and 11 for cross-examination. Order is passed, my lord, on 7th February 2004. My lord, your lordship may kindly see, rejected. My lord, here the observation is, in the finding is, my lord, that 13 times he had taken, and my lord, therefore it clearly goes to show that the intention of the defendant is to drag on the suit.
Audited, tagged. 7/2. 7/2.
No, my submission.
ಅಲ್ಲ 13 estimates ಇತ್ತಲ್ಲ.
No, 13 times the cost examination.
On deck, my lord, will not permit, particularly so when there is no merit.
No, whatever that the
ಅದು ಆರ್ಡರ್ ಇದೆ. ಆರ್ಡರ್, ವಾಟ್ ಇಸ್ ದ ಡೇಟ್ ಆಫ್ ಆರ್ಡರ್ ಅದು?
Date of order is, my lord, 7th February 2004. Then she comes on record, my lord. Then files an application, and application for impleading was allowed on 10/3/2004. Then, my lord, it was posted to filing return statement on 18/3/2004.
27 to
And
2000.
18/3 to, my lord, 19/3/2004. Then, my lord, different, 1/4 is defendants not adduced any evidence except D5 and posted for arguments. Thereafter, my lord, this IA number 13 is filed to file an application and to permit them to file the return
After
statement.
defendant number 5 led in evidence,
Defendant number 5, my lord, that is supporting defendant has led in evidence. He was not cross-examined by me because he supported my case. They did not cross-examine.
Has no objection to declare the suit of the plaintiff.
PW1 was not, was given opportunity to cross-examine by defendants. They did not do it.
Nothing but
PW 2, 3, 4 were cross-examined by defendants. They are only witnesses to speak, my lord, that family is joined. Nothing is elicited in the cross-examination.
Nothing but ex parte decree has been passed on that. Whatever may be, my documents cannot be considered unless and until it is marked by the trial court.
WS is a judgment, CH judgment. Why judgments? For WS?
ಈ ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ intention is to shows that defendants to drag on the suit.
ರಿಜೆಕ್ಟ್
22 years ಆಯ್ತು, ಇವತ್ತಿನವರೆಗೆ ನಂಗೆ ಒಂದು 3 ಎಕರೆ ಬರ್ತದೆ, 3 ಎಕರೆ ಕೊಡೋದಕ್ಕೂ ಅವರು
ಪೊಸಿಷನ್ ತಗೊಂಡಿದ್ರ?
ಅಲ್ಲ, possession ಮಾಡಿದ್ದಾರೆ, ಅದು ಫೈನಲ್ ಡಿಗ್ರಿ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ. ನಾ ಥಿಂಕಿಂಗ್ ದಟ್ ಮೈ ಲಾರ್ಡ್ ನೋ ಎಕ್ಸಿಕ್ಯೂಷನ್ is needed, I filed suit for injunction.
Injunction
Court says, my lord, the suit is possession will have to be taken by me. My lord, joint possession after division, my lord, after division, I can enjoy the property.
My 13 and 1 and
It is a registered document, my lord.
application came to be allowed by the trial court. Recently, that, and he prepared an appeal. That appeal was rejected. My writ petition, their writ petition is pending before this court. That my submission is that, my lords, my submission is that, that what are the documents produced by me before the trial court? It cannot be considered unless and until it is marked. That by adducing the evidence.
Yes, yes.
So your lordship may kindly provide 3 months time. That only to that aspect to my documents came to be record.
Recording. Recording. RFA 1033 of 2004 is by defendant number 12, assailing the preliminary decree drawn in OS 374 of 2002. RFA 1034 of 2004 is filed by
Brother of defendant number 12.
Is filed by the brothers of defendant number 12, who are arrayed as defendants 2A to 2G. RFA 560 of 2021 is filed by defendants 2A to 2G, questioning the final decree drawn in affidavit number so and so. For the sake of brevity, rank of parties, next family tree is as under. Plaintiffs who are legal heirs of one Naga have instituted a suit seeking relief of partition and separate possession against the defendants. Plaintiffs have specifically contended that the social properties are joint family institutional properties and plaintiff and defendants thereby constitute a undivided joint Hindu family. And they're in joint possession and enjoyment of the social property. Plaintiffs have further contended that that their father Naga and Bhimanna predeceased Mahadevappa. And therefore Mahadevappa continued to act as a karta of the family and was managing the social properties and distributing the yields to all the family members. After the demise of Mahadevappa, defendant number 2 Maheshappa applied for regrant as the suit lands were service inam lands, and the authority has accordingly regranted in favor of second defendant. Plaintiff therefore contended that the social properties being joint family and social properties, and defendant number 2 having bluntly refused to share the yields generated in the suit lands, are compelled to file the present suit for partition. Next, on receipt of summons, second defendant Maheshwarappa contested the proceedings. Pending suit, he died, and his children, namely defendants 2A to 2G, appeared and filed written statement and contested the suit. Defendants 5 to 11, who are the brothers and sisters, who are brothers and sisters and grandchildren, also contested the suit by filing written statement. Plaintiffs to substantiate their right in the social properties led in oral and documentary evidence. Defendants 2A to 2G, who are the legal heirs of second defendant, in spite of sufficient opportunity granted by the court, failed to cross-examine the plaintiff. An application was filed after seeking 13 adjournments by defendants 2A to 2G, seeking leave of the court to cross-examine the plaintiff. The said application was rejected. Several adjournments were sought, and the contesting defendants, namely defendants 2A to 2G, failed to lead evidence in support of their contention. Next, at this juncture, it appears the defendant number 12, who is the sister of defendants 2A to G and daughter of defendant number 12, who was left out and was not brought on record, filed an impleading application and sought leave to come on record. The impleading application was allowed. Defendant number 12 sought adjournment to file written statement, though trial court granted 3 adjournments to enable defendant number 12 to file
Only 1 month.
1 or 3 now.
1 month. Only 1 adjournment.
Yes, defendant number 12 adjournment says
10/3/2004 come on record, my application allowed.
10/3/2004, then my lord it.
WS. No, yeah, this appear. For WS.
Then 19/3 my WS taken as not filed, Malda.
What did she tell you for
Only one adjournment, Malda.
Only 1 now.
Only 1 month. 18/3/2004
3,
10/3/2004 my
18/3
application
ಗೆ
allowed.
ನಂತರ 19/3 ಒಂದು ಡೇಟ್ ಹೋಗಿದೆ.
19/3 not filed.
ನಾಟ್ ಫೈಲ್ ಆಗಿ 18/3 ಕೊಟ್ಟಿದ್ರು.
Defendant failed to file written statement, and therefore London judge passed an order indicating that WS is not filed.
On 19/3/2004.
On 19/3/2004. Defendant number 2 filed an application seeking leave of the court to file written statement. The said application was rejected, and defendant number 12 filed assailed, challenged with the order by filing a writ petition in WP number
know that.
so and so.
WP number 30808 of 2004.
Yes. Next, trial court, having appreciated oral and documentary evidence, decreed the suit by holding that social properties are joint family and social properties, and accordingly allotted half share to the plaintiff's branch Next. Defendants defendant number 12, assailing the judgment and decree, has preferred an appeal in RFA 1033 of 2004. Defendants 2A to 2G, who are the brothers of defendant number 12 and failed to contest the suit, filed an appeal in RFA 1034 of 2004. The connected first appeal in RFA 560 of 2021 is filed, questioning the final decree drawn in FDP number so and so. Heard the counsel for petition appellant and learner counsel appellant and heard the learner counsel appearing for defendant number 12, 2A to 2G, and learner counsel appearing for plaintiffs. Peruse the records. Next, following points would arise for consideration. Whether trial court erred in rejecting the application filed by defendant number 12 in I number
13, ma'am.
13, seeking leave to file different statement. Whether the judgment and decree rendered by the trial court suffers from infirmities and therefore warrants interference at the hands of this court. Next. On independent assessment, my finding on both the points. On independent assessment of the pleadings and the document, oral and documentary evidence, this court needs to take cognizance of the conduct of defendants in the present case on hand. Second defendant contested the suit and sought for dismissal of the suit on the ground that defendant number 2
Defendant number 2 died, my lord. 2B has filed. 2B has filed, my lord. I think
that it is a self-acquired property of.
that is re-granted in my favor. It is exclusive property. It is my father's exclusive property.
Under 2B.
2B ಹೇಳೋದು.
Defendant number 2B has filed written statement, which is adopted by other defendants.
C2G.
It is adopted by defendants 2A, 2C,
2G.
and 2G. Defendant number 2B in his written statement, while contesting the suit, has raised a specific defense that these lands admittedly being inarmed lands are re-granted to second defendant. Therefore, defendant number 2B asserted that these properties are self-acquired properties of Maheshwarappa, family tree bandhi. And therefore, plaintiffs are not entitled for any share in the suitable property. Next, plaintiff to substantiate that these lands were originally held by Bhimanna and their father Naga, have placed reliance on exhibit
P2 to P8.
Exhibit P2 to P8.
P8.
Exhibit P6 are the RTCs indicating that survey number 24/1 and 24/2 were originally standing in the name of Bhiman and Naga. Exhibit P8 is an index of land relating to 24/1, 24/2, and 24/3. And in the said index of land, the lands in question are notified as Badagi Service Inam lands, Badigi Service Inam lands, at the name of Bhimanna and Naga, and one Malla son of Bhimanna are indicated in the index of land. Exhibit P7 is also an index of land relating to 24/5, which is not the subject matter of the suit. On meticulous examination of these three documents, this court is of the view that the suit lands were admittedly Inam lands. And in fact, Bhimanna and Naga were the holders of these lands in question. From the records, it is evident that Bhimanna and Naga died before abolition of inams. After the death of Bhimanna and Naga, the youngest brother, namely Mahadevappa, was managing the suit lands. After his demise, it appears second dependent started managing the affairs of the family and he sought for regrant. Next, if these significant details are looked into, this court is of the view that that in fact plaintiffs alone are entitled to succeed to these Inam lands, as their father Naga along with Bhimanna were the original holders. However, plaintiffs have fairly acknowledged and admitted that these the lands which were regranted in the name of Maheshwarappa are admittedly ancestral lands, and therefore they have sought share in the social properties. If plaintiff's father Naga was the holder as an inamdar, mainly because second defendant having sought for regrant, he cannot assert that it is a self-accord property. The regrant, it is a tri-clause, and this court in content of judgments has held that regrant would inure to the benefit of the entire family. The fact that plaintiff's father Naga was the holder of these lands, the regrant order passed in favor of defendant number 2 will definitely inure to the benefit of the plaintiffs, and they are entitled for half share in the social property. My finding on point number 2. Accordingly, point number 2 is answered in so and so. In regard to finding on point number 1, though defendant number 2B filed written statement and contested the suit, records reveal that the matter was adjourned on at least 13 occasions to enable defendants 2A to 2G to cross-examine plaintiff. Defendants 2A to 2G, in spite of sufficient opportunity granted by the trial court, failed to cross-examine the plaintiffs. The learned judge ultimately passed an order indicating that there is no cross by defendants 2A to 2G. Thereafter, defendant number 5 has led in evidence and has supported plaintiff's case and has acknowledged that plaintiffs have legitimate share in the social properties. After the closure of defendant number 5's evidence, interestingly, defendant number 12, who is the daughter of second defendant and sister of defendants 2A to 2G, files an impleading application through the same lawyer, namely Basoraj. The said impleading application is allowed, and she's permitted to contest the suit. Next paragraph. Though an application was filed by defendant number 12 seeking leave of the court to file written statement,
Evidence was not at close, Mother. At the time of appearance of the defendant number 12, that on 11/2/2004, Sri MRMH advocate filed a memo with chief defendant number 5. He filed the affidavit only, by affidavit for further evidence of defendant number 1 by 27/2.
Defendant number 5 evidence close agita.
Illa, the only but affidavit has been filed, Mother.
When the matter was listed for evidence of the defendant number 5, application was filed at the bottom. And defendant number 12 filed an application seeking leave to file written statement. Learned judge has rejected the application, and defendant number 12 was compelled to challenge the order by filing a writ petition in WP number
3080. Federally, that after allowing the implementing application, I will lordship my tendency, order sheet my that on 27/2/2004, I filed the implementing application. That came to be allowed on 10/3/2004.
ಅದು ಮೊದಲೇ ಹೇಳಿದ್ದೀನಿ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲಾವ್ ಆಗಿದೆ.
10/3/2004 my that. And subsequently 18/3/2004 adjourned WS if any of the depend number 12. And 19/3 taken as not filed. I filed the writ petition 30/8/08 of 2004.
ಏನ್ ಬದ್ರಿ? The same is rejected and writ petition was filed and same was pending consultation before this court. Next paragraph. As there was no stay granted by this court, trial court proceeded to record its judgment and suit is decreed, granting half share to the plaintiffs. This court disposed of the writ petition, reserving liberty to the defendant number 12 to urge all the grounds in an appeal. Though liberty is granted, this court has noticed that there is no specific elaboration of and grounds relating to the questioning the order rejecting the application seeking permission to file written statement.
That writ petition.
The written statement is part of the record. This court has meticulously examined the averments made by defendant number 12 in the written statement. Though counsel appearing for defendant number 12 has tried to persuade this court to remand the matter on the premises that all registered documents on which defendant number 12 is placing reliance are kept in safe custody, this court cannot examine the written statement and also cannot look into those documents unless those documents are taken on record. Next paragraph. This court needs to examine the conduct of defendants in the present case on hand. Defendants 2A to 2G and present defendant number 12 are the legal heirs of defendant number 2. The counsel who appeared for defendants 2A to 2G, namely Basavaraj, has come up with an application seeking leave to has filed an application, impleading application on behalf of defendant number 12. Defendants 2A to 2G have failed to contest and cross-examine the plaintiffs. The lawyer who appears for defendants 2A to 2G files an impleading application. The said application is allowed. Even before this court, defendants 2A to 2G and defendant number 12 have engaged the same counsel. And they're contesting these appeals. These appeals are pending since 2004. The connected appeal in RFA 560 of 2021 is filed by only defendants 2A to 2G, questioning the drawing of a final decree. Defendant number 12 has not chosen to challenge the decree drawn in FDP number so and so. Next. Now let me examine whether defendant number 12 in RFA 1033 of 2004 has made out a case for remand, or whether she has made out a case to lead evidence before this court to substantiate her rights. On examining the records, the subject matter of the social properties are survey number 241/1P, measuring 2 acres 7 guntas, and 24/2P, measuring 4 acres 31 guntas. Defendant number 12 strangely wants to rely on the sale deed executed by plaintiffs and defendants together to one Lingaya in survey number 24.
ಅದು ನಂದಲ್ಲ,
Huh?
ಅದು ಬೇರೆ ಅದು, ಅವ್ರು ಹೇಳೋದು. ಬಟ್ ನಂದು ಎಕ್ಸಿಬಿಟ್ P1 ನಾವಿಬ್ರು ಎಕ್ಸಿಬಿಟ್ ಮಾಡಿದೀವಿ. ಎಲ್ಲ ಔಟ್ ಆಫ್ 8 acres 38
The 2 acres you have sold it before grant, re-grant.
ಬಿಫೋರ್ ಗ್ರ್ಯಾಂಡ್. ಅದಲ್ಲ, ಈಗ ಅವ್ರು ಹೇಳೋದು ಬೇರೆ, ಇನ್ನೊಂದು ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆ ಅಂತ. ಆ ಲಿಂಗಾಚಾರಿಗೆ ಆ ಭೀಮಣ್ಣನ ಕಡೆಯವ್ರು ಮಾರಿದ್ದಾರೆ ಅಂತ ಅವ್ರು ಹೇಳೋದು. ಅದು ಇದ್ರಲ್ಲಿ ಇಲ್ಲ, ಅದು ರೀಗ್ರಾಂಟ್ ಅಲ್ಲಿ ಇಲ್ಲ. ಲಿಂಗಾಚಾರಿ ಒಪ್ಟೈನ್ ರೀಗ್ರಾಂಟ್ ಅಂಡ್ my lord in turn the defendant number 2 has purchased. I am not claiming that. That is not the subject matter of the suit.
ಅದೆಲ್ಲ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಬಂದಿಲ್ಲ.
ಅದು ಬಂದಿಲ್ಲ. ಅದು ಅವ್ರು ಸುಮ್ಮನೆ ಕನ್ಫ್ಯೂಸ್ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ, ಸೇಲ್ ಡೀಡ್ ಇದೆ ಅದಿದೆ ಅಂತ. ಅದನ್ನ ತಂದಿಲ್ಲ. ವಾಟ್ ಈಸ್ ಕ್ಲೈಮ್ ಇಟ್ ಈಸ್ ರೀಗ್ರಾಂಟೆಡ್ ಲ್ಯಾಂಡ್.
No, I want to rely on the sale deed executed by Lingacharya in favor of Bhimanna. ಯಾರು ಭೀಮಣ್ಣ ಯಾರು?
ಭೀಮಣ್ಣ Ishwarapa's wife in favor of my lord Lingachari. Lingachari applied for regrant and he got it, and it is sold to defendant number 2. That is what in the return statement they said. That is not the subject matter.
ಅಲ್ಲ, ಲಿಸ್ಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ಇದೆ ಅದು.
That is not the
2001
subject
ನಲ್ಲಿ ಲಿಂಗಾಚಾರಿ ಇನ್ ಟರ್ನ್ ಸೋಲ್ಡ್ ಟು ಮೈ ಫಾದರ್.
ಅದು how it is relevant for this partition?
ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
How it is relevant?
ಅಲ್ಲ, ವಾಟ್ ದೇ ಆರ್ ಸೇಯಿಂಗ್ ದಟ್ ಐ ಪ್ರೊಡ್ಯೂಸ್ ದಿ
ಹಳ್ಳಿ ಎಲ್ಲ ಕೇಸಲ್ಲಿ ಜೋರಾಗಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬಾರ್ದು. ಏನ್ ಬರ್ರಿ? Executed by Lingacharya in favor of the present defendant's father, Maheshwarappa. Plaintiff has not claimed any right in the property purchased by second defendant in respect of 2 acres.
1 acre.
In respect of
1 acre.
1 acre.
Lingachari ಅಂತ ಹೇಳಿ.
Next, be that as it may, learned counsel appearing for defendant number 12 also asserted that the plaintiffs have relinquished their share, and therefore the present suit for partition is not maintainable. On a query, and when this court queried the counsel appearing for defendant number 12, he submits that the said relinquishment deed is not a registered document.
That is also stated in para 6 of the return statement.
The same is evidenced at para 6 of the return statement. Next, if the material on record is meticulously examined, this court is more than satisfied that defendants 2A to 2G, having failed to cross-examine the plaintiff, have set up their system, and a false claim is made only to drag on the matter. Though final decree is drawn, counsel appearing for plaintiff submits that the plaintiffs are unable to enjoy the fruits of the preliminary decree and final decree. And there are fresh litigations between defendant number 12 and plaintiffs. Next paragraph. My finding on point number 3 of Madilali, whether the final decree drawn in FDP number so and so warrants interference with the hands of this court.
That is opposed, my lord, only on the ground that appeal is pending, no other grounds.
The final decree drawn by the FDP court in FDP number so and so is challenged primarily on the ground that the regular first appeals are pending consideration before this court, and therefore FDP court had no jurisdiction.
And no objection was filed to the commissioner's report.
No objection.
No objection was filed to the commissioner's report. Only objection is not that the matter is pending in RS. Commissioner's report is accepted.
In view of pendency of the appeal. From the records, it is gathered that the commissioner report is not contested by the defendants 2A to 2G. In a final decree proceedings, the scope of a review by the appellate court is very limited. The FDP court is required to examine the equities and examine whether the feasibility report submitted by commissioner is reasonable and adverts to the interest of all the joint family members. On reading the grounds urged in the appeal memo filed in RFA 560 of 2021, no specific grounds are raised indicating as to how the feasibility report submitted by Commissioner would warrant interference at the hands of this court. The fact that defendants 2A to 2G have not chosen to file objections to the Commissioner's report, they would obviously lose the locus to challenge the final decree drawn in FDP number so and so. No grounds are made out, and therefore point number 3 accordingly is answered in negative. As regards stated supra,
Make one submission.
all the 3 appeals are devoid of merits, accordingly stand dismissed.
I will make submission. We rely in support of make two judgments.
Yes, yes, ಅದು ಬರೀತೀವಿ.
Return statement.
ಅದು he has cited to.
ಅಲ್ಲಿ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಾಟ್ ಫೈಲ್ಡ್ ಆದ ಕೂಡಲೇ ಬಿಯಾಂಡ್ 90 days ಅಂತ ಹೇಳಿ that ಮಾಡಿದ್ರು.
He has cited 2 judgments.
And so far as the remand is concerned ಮಾಡಿದ್ರು.
Paragraph ಬರೀತೀವಿ. One paragraph.
One is for the WS, another one is for the case of remand ಮಾಡಿದ್ರು.
Remand. Yes, sir. ಏನಿದೆ? ಇದಾಗಿದೆ. Since appeal is dismissed, madam. Since appeals are dismissed, the applications filed in so and so does not serve.
ಅಲ್ಲ ಅದು that in 560 ಅಲ್ಲಿ all the applications are put up ಮಾಡಿದ್ರು. They have raised objection at the time of filing the application.
ಯಾವುದು?
560 ಅಲ್ಲಿ ಅವೇನು ಅಪ್ಲಿಕೇಶನ್ ಪುಟ್ ಅಪ್ ಮಾಡಿದಾರಲ್ಲ ಅವು they have raised the office objection at the time of filing the RFA. Formal application to be filed. ಯಾಕಂದ್ರೆ ಅವ್ರು ಸತ್ತೋರು ಎಲ್ಲಾರ್ಸೆಲ್ಲ ನಾವು RFA ದಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿದ್ದೀವಿ.
ಆಲ್ರೆಡಿ
ಪಾರ್ಟಿ ಮಾಡಿದ್ದೀವಿ ಟು ಫಾರ್ಮಲ್ ಅಪ್ಲಿಕೇಶನ್.
ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
ಅಲ್ಲ ನೋಟಿಸ್ ಅವರಿಗೆ ಆಲ್ರೆಡಿ ರೆಕಾರ್ಡ್ ಆಗಿದ್ರು, ಅವ್ರಿಗೆಲ್ಲ ನೋಟಿಸ್ ಆಗಿದೆ. 560 ಅಲ್ಲಿ ಎಲ್ಲ ನೋಟಿಸ್ ಆಗಿದೆ. ಅವು ಅಪ್ಲಿಕೇಶನ್ ಕೇಮ್ ಟು ಬಿ ಅಲೌಡ್, ಫಾರ್ಮಲ್ ಅಪ್ಲಿಕೇಶನ್
ಅಲೌಡ್ ಅಂತ ಅಂದ್ಬಿಡೋಣ ಅಷ್ಟೇ.
ಪ್ಲೀಸ್
ದೇ ಆರ್ ಆಲ್ರೆಡಿ ದೇರ್.
ಅವು ಫಾರ್ಮಲ್ ಇನ್
ನೋಡೋಣ ಅದು ಅಪ್ಲಿಕೇಶನ್ಸ್ 560 ದಲ್ಲಿ ಮಾತ್ರ ಅಲೌಡ್ ಅಂತ.
ಅಲ್ಲ ಅವು ಇನ್ನು ಟು ರೆಕ್ಟಿಫೈ ದ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್. To rectify the office objection,
yes sir, yes.
formal application came to be filed.
Yes sir, yes sir. ಕಬ್ಜಾ ಕೊಡ್ರಿ.
Please,
ಗೋಪಾಲ್ ಅವ್ರ ಕ್ಲೈಂಟ್ ಕಬ್ಜಾ ಕೊಡ್ರಿ ಅಲ್ಲಿ.
ಕಬ್ಜಾ ಕೊಡ್ಲೇಬೇಕಲ್ಲ ಸ್ವಾಮಿ, ಈಗ ಅವು ವಜಾ ಮಾಡ್ದಿಂದ ಇನ್ನೇನು ಉಳಿಯುತ್ತೆ.
Suit filed for injunction, then interim order sought, my lord. Dismissed, then RA, then writ petition is filed.
ಅಲ್ಲ actually apex court has found that
possession
written statement is filed more that the appellate court has no jurisdiction.
ಮಾತು ಕೇಳ್ತೀರಾ?
It is not. Please,
actually the order ತಪ್ಪು. Trial court should have allowed you to file return statement.
That elaborately that apex court has recorded several judgments ಮಾಡಿದೆ.
ಅದು ನಿಮ್ WS ನೋಡಿದ್ರು ಗೋಲ್ಡ್ WS ಅಂತ ಹೇಳಿ.
ಇಲ್ಲ ಈಗ apex court findings recorded law laid down by the apex court in several judgment.
There are no
order 8 rule 1 ಮಾಡಿದೆ that.
Mr. Halli,
Please,
there are no substantial differences in your return statement. It is quite clear that your brothers have set up you.
Whatever may be, my defense is that my documents are.
Team leader is 2B, my lord. Team leader is 2B. 2B.
2B.
2B.
Yes. Yes, sir.
Serial 19 ಇತ್ತು.
ಅಲ್ಲ ಒಂದೇ ನಿಮಿಷ 230 ಮಾಡಿ.
That's order at annexure A passed by the Tahsildar.
Government advocate.
Order at annexure A, page number 18, passed by the Tahsildar is under challenge, my lords.
Yes, what is the order?
Now, my lords, without issuing any notice to the landowner, my lords, the petitioner before my lords, they conduct Mazar. They hold spot inspection. They prepare a sketch. And they say, my lords, I have blocked one pathway which is not in existence, my lords. And on the basis of their report, the Tahsildar issues notice to me, calling upon me to vacate the encroached, the so-called alleged encroachment of pathway within 7 days. Then, my lords, he proceeds to pass the order dated 19/8/2024. And my lords directs them to, my lords, form a road, my lords, in my patta property, in spite of the report by the surveyor, saying that, my lords, this property is my patta land.
Where is the survey report?
Please, kindly see, my lords, page 46 minutes.
Based on spot inspection, he says that, this is,
No,
this
survey was ordered by the Tahsildar, my lords.
46.
46, typed copy is at page 46.
All right, what the report says?
Report specifically states that, my lords, second para, Sadri ಬೇಲಿ ಹಾಕಿರುವ ಹಾಗೂ ರಸ್ತೆ ವಾಹನಕ್ಕೆ ಸಂಚಾರಕ್ಕೆ ರಸ್ತೆ ಕೋರುತ್ತಿರುವ ಜಮೀನು ಶಂಕರ ಭಟ್ರಿಗೆ ಸೇರಿದ ವರ್ಗ ಜಮೀನಿನಲ್ಲಿ ಹಾಗೂ ಆಂಶಿಕ ಜಮೀನು ಸರ್ಕಾರದಲ್ಲಿ ಬರುವುದಾಗಿ ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬರುತ್ತದೆ.
And where is the impugned order?
Impugned order is at page 18.
Annexure A.
Annexure A. Kindly see operative portion, my lords,
Okay.
page
Had-
19.
Had the counsel for petitioner perused the survey report, evidence that annexure K and at annexure K.
And also, my lords, the report of village accountant and RI, both says that, my lords, it is my patta land.
ಅದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ?
Yes, my lords.
And also report submitted by village accountant and
RI, my lords.
and the revenue inspector, evidence that annexure
Annexure G and, my lords, annexure H.
G and H. Prima facie, petitioner is able to substantiate that the proposed road, which now Tahsildar intends to provide to the villagers,
Not to the villager, my lord. My next neighbor, my lord,
to the
owns
adjoining
one house.
to the adjoining owner, is admittedly a patta land owned by petitioner herein. Under the impugned notice, while annexure A, Tahsildar has called upon petitioner to remove the encroachment within 7 days.
And also to form 6 feet road in my property.
And there is a proposal to form a 6 feet road in the land owned by petitioner. This court has consistently held that forming of a road in a private land has to be subject to following, subject to complying the land acquisition laws.
Yes.
As the right to property is protected under Article 300, capital E of Constitution of India. It is in this background, matter requires consideration. Father is stated supra, so and so state, the next date of hearing, issue, learned AG is directed to accept notice.
1 to 4 government.
1 to 4, issue emergent notice, 1 to 5.
1 to 5 minutes.
Notice to, emergent notice to 6, yes.
Please. Great.
My lord, strikingly similar matter, my lord.
Similar that?
Strikingly similar. Page 30, my lord, is the impugned order passed by the Tahsildar as regards the road, my lord. Only at least there was an inquiry held. In my matter, absolutely no inquiry also, my lords. Straight away, based on the complaint filed by third respondent that he needs an access to his land, this impugned order is passed, my lord. Page number 30.
Through your land. Not
Our
through
land,
it.
my lord. And pursuant to that, page 54, notice is issued for recovery. Today, right now, as I submit,
You
they
have
have.
served a copy on them.
No, 2:30 ಮಾಡಿದ್ ನಾವು ಇವತ್ತು. ಇವಾಗ right now, ನಾ ಕೊಡ್ತೇನೆ, I'm so sorry.
Hey,
Right
no,
now,
Mr.
right now present,
Mention company.
my lord.
At least the least you can do is you have to serve a copy on the government advocate. What is
ಕೊಟ್ಟಿಲ್ಲ
it?
ಈಗ ಕೊಡ್ತೀನಿ.
Allah,
But my
I-
humble
I
submission-
called it at 2:30. What is this?
My lord,
ನೋಡ್ರಿ, ನೀವೇ ನೋಡ್ರಿ.
ನೋಡಿ.
ಅದೇ file ನೋಡಿ, ಏನು almost same.
And additionally, my lord, as per section 103, Tahsildar does not get the jurisdiction to pass such order, my lord. Only it is the deputy commissioner, 103 of Karnataka Land Revenue Act.
103.
ಹೌದು. It's only the deputy commissioner who gets the jurisdiction, my lord. Therefore, this order also without authority of law. Recently, in one of the.
Harish, ಇದನ್ನ Tuesday ಹಾಕೊಳ್ತೀನಿ. Till then don't precipitate.
Please.
Collect the copy and see.
Please.
Right now, it appears the officials are there in the land and there.
I'm granting you
Please,
protection.
Yes. By invoking, my lord, section 164 of BNSS Act, my lords. BNSS, Bharatiya Nagarika Suraksha Samhita. Tahsildars are, my lords, doing this type of, my lords, passing this type of orders. Under 164, my lords, after hearing, after issuance of notice, they are supposed to do it. Now, immediately on the basis of complaint, they are invoking 164 and, my lords, passing this type of.
Without holding inquiry.
Without holding
Without
inquiry,
inquiry.
without issuing notice.
And section 103, they don't have jurisdiction also, my lords.
So 164,
Is 103.
ಕೊಡ್ರಿ.
Right. ನಾನು ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ, ಅದರಲ್ಲಿ that is 103 only is considered. Two, if any right of way to a land used for the purpose of agriculture is duly entered in a map or land record maintained by this act is wrongfully obstructed or interfered with by any person agreed thereby may apply to deputy commissioner. And this deputy commissioner order is subject to the result of civil suit, my lord. 103.3.
Is it reflected in a village map?
No, it is
Not
not. That
reflected.
also I have taken the ground. It is not reflected in the village map.
Yes, Mahesh. Harish.
My lord, there is already survey sketch has been done, my lord.
Ah.
Annexure D may kindly see.
ಆಯ್ತು ನೀವು ನೋಡ್ರಿ.
Please.
Copies are ಮಾಡಿಲ್ಲ ನೋಡಿ.
Please.
Had the council for petitioner peruse the records. Since there is a threat of forming a road.
For the formation of road, that is the order.
There is a
improved order.
threat of formation of road in petitioner's land. By having recourse to section 103 of Karnataka Land Revenue Act 1964. Petitioner is entitled for some protection till next date of hearing. Copy is not served on Leonard AGA. Petitioner is called upon to serve 2 sets of copies on Leonard AGA. Release this matter in preliminary on Tuesday. Till then, Leonard AGA shall intimate.
Please.
Shall intimate respond number.
4 presently is there, my lord. I issued a notice annexure L.
Respond number 4/village accountant not to take any prescriptive action till next date of hearing.
Grateful. Pursuant to annexure L, man.
Pursuant to annex.
Grateful.
Seek for hand delivery of this.
May I'm sorry to interfere. I'm so sorry to interfere. My request for a hand delivery, I will give them.
Yes, sir. ಏನ್ ಮ್ಯಾಟ್ರು ಅರ್ಜೆಂಟ್ ಮಾಡ್ತೀನಿ.
ಅಲ್ಲ ಇದರಲ್ಲಿ RFA 641 of 2019 ಅಲ್ಲಿ
ಇದು ಬ್ಯಾಚ್
ಅದು ಬ್ಯಾಚು ಇದು ಫೈನಲ್ ಕಾಂಪ್ರಹೆನ್ಸಿವ್ ಸೂಟು RFA 641 ಇದ್ರಲ್ಲಿ ಪೇಪರ್
follow them. For the unserved respondents are sought to be served through by way of substitute service. Today, two sets of citations are placed on record to substantiate that steps are taken by way of paper publication to unserved respondents. Today, their names are called out in the open court. Service is held sufficient. Raised to print their name in the cause list. Yes. ಏನ್ ಮ್ಯಾಟ್ರ್ ಇದು?
suit for declaration and cancellation of sale deed and for permanent injunction that came to be dismissed is the plaintiff's appeal.
Yellow plaintiff. Why so many appeals?
ಅಲ್ಲ ಅದು ಫಸ್ಟ್ 4 appeal injunction suits ಅದು they have filed the suit. The suit has been declared subject to result of the final comprehensive suit. ಹೀಗಾಗಿ ಈ ಅಪೀಲ್ ಡಿಸ್ಪೋಸ್ ಆಯ್ತು ಅಂದ್ರೆ ಅದೆಲ್ಲ 4 ಒಟ್ಟಿಗೆ ಹೊರಟೋಗುತ್ತೆ. ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಆಗ್ಬೇಕು. ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಆಗ್ಬೇಕು.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲ ಇನ್ನು?
ಇಲ್ಲ ಅದು ಬಂದಿಲ್ಲ.
ಬಂದಿದೆ ರೀ.
641 ಅಲ್ಲಿ
ಬಂದಿದೆ.
ದೆನ್ ಫಿಕ್ಸ್ ಡೇಟ್ ಆಗಿಲ್ಲ.
Next Thursday. Orders come. One week.
B and R6D are come back, it's unclaimed, my lord. They are not claimed. Therefore.
Unclaimed ಬರಲ್ಲ, refused.
ಅದೇನಾಗಿದೆ ಮೂರ್ ಸಲ ನಾನು ದೇ ಹ್ಯಾವ್ ರೆಫ್ಯೂಸ್ಡ್, ಈವನ್ ಐ ಹ್ಯಾವ್ ಟೇಕನ್ ದ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಅಂಡ್ ಗೋ ದೇ ಹ್ಯಾವ್ ರೆಫ್ಯೂಸ್ ಟು ಅಕ್ಸೆಪ್ಟ್ ದ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಆಲ್ಸೋ ಮೈ ಲಾರ್ಡ್.
ಅದೆಲ್ಲಿದೆ?
ಅನ್ಕ್ಲೈಮ್ಡ್, ನಾಟ್ ಕ್ಲೈಮ್ಡ್ ಮೈ ಲಾರ್ಡ್, ನಾಟ್ ಕ್ಲೈಮ್ಡ್ ಅಂತ ಬಂದಿದೆ
ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದಾರೆ ನಿಮ್ ಪಾರ್ಟಿದು?
ಮೈ ಲಾರ್ಡ್.
ಅದು ಹ್ಯಾಂಡ್ಸಮ್ ಅನ್ನು ಸರ್ವ್ ಮಾಡಿ ನಿಮ್ಮ ಅಫಿಡವಿಟ್ ಇದೆಯಾ ನಿಮ್ ಕ್ಲೈಂಟ್ ಇದು?
ಅಫಿಡವಿಟ್ ಹಾಕ್ಸ್ತೀನಿ ಸರ್.
ಇದೆಯಾ?
ಇಲ್ಲ ಅಫಿಡವಿಟ್ ಹಾಕಿಲ್ಲ.
ಯಾಕೆ?
ಅಲ್ಲ ಬಟ್ ಇದು
ಹ್ಯಾಂಡ್ಸಮ್ ಜೊತೆಗೆ ಒಂದು ಅಫಿಡವಿಟ್ ಬರ್ಬೇಕಲ್ಲ, ಅದೇ ಅವ್ರು ರಿಫ್ಯೂಸ್ ಅಂತ.
ಐ ವಿಲ್ ನಾಟ್ ಕ್ಲೈಮ್ಡ್ ಅಂತ ಬಂದಿದೆ, ನಾಟ್ ಕ್ಲೈಮ್, ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಟೇಕನ್.
ಅದೇ ನೀವು ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ರೆ then I will hold service.
Please my lord, I will file an affidavit.
Though appellant claims that hand summons though tried to serve on the unserved respondents, they have refused to accept the hand summons, accept oral statement. The same is not supported by an affidavit. To examine whether hand summons is served on R6D, the appellant has to file an affidavit to that effect. For want of
R5B
affidavit,
also.
To file an affidavit to that effect, 1 week's time is granted.
Caste title I will amend my lord.
Yavdu amendment?
Amendment A to it.
Appellant is permitted to amend the cost title
Please,
in the open court office to verify.
please.
Next. One week.
1983 suit, second round of litigation.
Who has denied status of the party? Idenidu report of fingerprint expert.
46.
Yes, 46 sir.
Early hearing application ಹಾಕಿದ್ನಿ.
ಅಲ್ಲ ಅದು ರಿಪೋರ್ಟ್ ಆಫ್ ಟ್ರೂತ್ ಲ್ಯಾಬ್ಸ್ ಅಂತ ಬಂದಿದೆಯಲ್ಲ ಅದೇನದು?
ಅದೇ ಅದರಲ್ಲಿ I am appearing for the respondent. I am for the respondent, my lord. Now the document is referred to the handwriting expert, my lord. He has sent a report. Now it is in cover.
It has to be taken on record now.
That will have to be taken on record.
Copy may be given.
Copy has to be furnished to you.
Yes.
Yes, ma'am.
Report of truth labs is received by this court in a sealed cover. Registry shall furnish a copy, certificate copy of the sealed cover if applied to the respective parties. Yes. Now open ಮಾಡಿದ್ದು ನೋಡಿ.
We may be permitted to file objections if necessitated.
If necessary.
Please.
Sealed cover, the fingerprint expert report submitted by Truth Foundation is taken on record. The sealed cover is opened and the report is placed on record. Office is directed to furnish a copy if applied. The parties are at liberty to file objection to this report if they choose to do so.
Yes. Okay.
Yes, sir. Vardarajan, sir.
Certified copies to be issued to both the parties.
Yes,
Yes, yes. This is the case where I should have made the submission.
Yes, sir.
83 suit, second round of litigation.
Allowed, application allowed, when you want.
Date.
Time, ಒಂದೇ ವಾರ ನಾವು. Next week ಮಾಡ್ತೀರಾ?
ಮಾಡ್ತೀನಿ.
ಮಾಡ್ತೀರಾ? Application is allowed. List it in hearing. Next Thursday ಹಾಕಿ ನೋಡೋಣ.
Very good.
Next. Including application to be heard along with the main matter. Next. 48. Notice ಹೋಗ್ಬೇಕಾ? Notice ಹೋಗ್ಬೇಕಾ?
Notice ಹೋಗ್ಬೇಕು.
Issue notice on LR applications. 40, 50. Bill number 50. ಯಾರ್ ತೀರೋಗಿದ್ದು? This is sole appellant. Cost shown is accepted delay of 129 days in filing. In filing, LR application is condoned, consequently abatement is set aside. Proposed legal heirs of deceased appellant are permitted to come on record. 2 weeks time is granted to carry out amendment and file amended cost settle. Next. 51. Not filing ಏನ್ರಿ ಇದು? IA for TI 2012 matter. ನನ್ನ ಅಪೇಸ್ ಯಾರು ಹಾಕಿದ್ದು? Some other day. Work list it on. None appears for appellant, list it on so and so date. 52.
Yeah, for the.
ಏನ್ರಿ ಗೋಪಾಲ್ ಸರ್?
Blood.
ಆಯ್ತಲ್ಲ ನಿಮ್ ಕೋಟ ಆಯ್ತಲ್ಲ?
ಆಯ್ತು, ಕೋಟ ಆಯ್ತು. ಇದು ನಾನು ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಅಲೋ ಆಗಿತ್ತು ಅರ್ಲಿಯರಿಗೆ. ಈಗ ಅವರೊಂದು ಹಾಕಿದ್ದಾರೆ. ಯಾವತ್ತಾರು ಒಂದು 26th ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ ಶಾರ್ಟ್ ಕ್ವಶನ್ ಮಿಲಾಡ್. After selling it to me, my lord, I have developed a farm layout, housing society. Then, my lord, he purchases again the dependent 6 from dependent 5, 1 to 5.
Parted.
Yes. Next, my lord, 25th, your lordship, have it.
Thursday. Yes.
25th.
Yeah.
26th.
Yes, sir. ಆಯ್ತಾ?
Kind leave, my lord. Serial number 39, my lord. That is covered by Revana Siddhappa statement.
ನೀವು ಯಾರು ಎಫ್ಐಆರ್ ಆಗೋದು? ಲೆಜಿಟಿಮೇಟಾ ಇಲ್ಲೆಜಿಟಿಮೇಟಾ? I think
Appellant.
you represent first wife it appears.
Please, ma'am.
Correct?
Please.
ಅವ್ರಿಗೆ ನೋಸ್ಟಲ್ಲಿ ಹೋಗ್ಬೇಕಾ?
ಅಲ್ಲ.
ನೋಸ್ಟಲ್ಲಿ ಹೋಗ್ಬೇಕಾ ಅವ್ರಿಗೆ?
Please, ma'am.
ಅಷ್ಟೇ, that is the point, only quantification.
That is the only quantity.
ಯಾ serial number ಯಾವ್ದು?
Serial number 39.
ಹಾ?
39.
ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ರೆಡಿ ಮಾಡ್ಕೊಂಡು ಬರ್ಬೇಕು.
Please. Please.
ಯಾವ್ದು ನೋಡಿ serial number?
39.
Next Thursday.
Serial number 20, my lord, next.
Yes, sir, Raju sir.
Tuesday, my lord. Thursday, I am not here in town.
ಯಾವ್ದು?
See, next matter, serial number 20.
20 na? You want it on Friday?
On either on Friday or on 17th. 19th, I am not, next Thursday, I am not in town.
You are not in town.
Next Thursday, ma.
All right. You want it on Friday?
Friday.
My lord, 39, my lord, 39 interim order is kindly extended.
Extended. Wherever there is interim order, you mention it to the court of.
52, your lordship.
ಅದು ಏನ್ ನೋಡಿ ಕೊಡ್ತಾರೆ? Better you take it. ಬಂಡಾರಿ ಸರ್?
52, your lordship.
Lordship.
ಏನು ಹಳೆ ಮ್ಯಾಟ್ರ?
2012.
ಆಯ್ತು, ನೀವು he will assign it. ಎಷ್ಟು ದಿವಸ ಈಗ ವರ್ಕಿಂಗ್ ಡೇ?
Early hearing.
Earlier ಇದೆ ನಂದು.
ಇನ್ನು 4 ಸಿಟ್ಟಿಂಗ್ ಅಪೀಲ್ಸ್ಗೆ ಆಗತ್ತಾ? ನೋಡಿ, ವಾಟ್ ಟು ಟೇಕ್ ಎ ಚಾನ್ಸ್? ಕೊಡಿ, ಬಂಡಾರಿಗೊಂಡು ಡೇಟ್ ಕೊಡಿ. ಅವ್ರದ್ದು ನಿಮ್ದು ಯಾವ ವರ್ಷ? ವಿಚ್ ಇಯರ್? 2011. We take a chance.
Your lordship, serial number 21, your lordship. Kindly have it post 20th, your lordship.
You are ready?
We're ready, your lordship.
We or you?
Number 34, my lord. So after 23.
Who is ready?
We engage the senior counsel, your
You are
lordship.
engaged the senior counsel.
Yes, your lordship, one more submission,
What's the year?
2007, your lordship.
7.
7, but there's another submission, your lordship. There's an IA for direction on the respondent to produce the documents before this court, which are the exhibits of the trial court, which they have taken from the trial court records via an application for return of documents. Despite a direction, they have not produced those documents. They are crucial.
All right, we'll see it. We'll examine it when the matter is listed for it.
Please.
Next Thursday.
Serial number.
Your lordship, kindly have it post 20th, your lordship, please. Grateful.
Yes, sir.
23.
Question.
Number 1.
ಯಾರ್ appellant ಗ?
20.
ಅದು 49 ಎಲ್ಲ ಅವ್ರ ಹೆಸರು ತೋರಿಸ್ತೀನಿ. Yes.
19.
My lordship, serial number 31.
20,
Don't-
20th. 19th is not here. 18, 19. that
My
is
lordship,
number 1.
serial number 31.
Yes.
You appear for appellant.
So one or 22.
ಆಯ್ತು, ಈಗ ನಾವು ನೋಟಿಸ್ ಮಾಡಿದೀವಿ ಎಲ್ಲರ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ. ಅಲ್ಲ, you appear for appellant or respondent?
19th, he will not be. 20th.
Allah, R1 has died. You appear for appellant. You can't take notice. Oh, he's already appeared. Adu notice anbedi. He has already allowed and tanbidti. Yesterday delay. Next week. All right. Next week.
Serial number 31. Serial number 31, my lordship.
ಯಾವ ಇಯರ್ ನಿಮ್ದು 9 ನೋಡಿ 2009 ಅಂತ
What up? 43 NL, sir.
Sir, 31 on the 2 weeks ಆದ್ಮೇಲೆ sir. Settlement.
Sir? 43 NL, sir.
Next week and sir.
That court officer. 20 ತಗೊಳ್ಳಿ.
Serial number 31.
Sir, 43 NL, sir. याद सर
31. Sir, serial number 31.
Sir, serial number 38. Sir.
20ಕ್ಕೆ ಬೇಡ ಸರ್ ಸಾಹೇಬ್ರೆ ಗುರುಗಳೇ
Ma'am, 20 can I take?
ಅದು 22
20.
19ಕ್ಕೆ ಹಾಕ್ಬಿಡಿ ಸರ್ 20ಕ್ಕೆ ಬೇಡ
No, I will. Just I am seeing if I will get.
ಅಲ್ಲ 20ಕ್ಕೆ ಬೇಡ ಅರೆ ನೆಕ್ಸ್ಟ್ ವೀಕಿಗೆ ಹಾಕಿಲ್ಲ
19th? Okay,
20ಕ್ಕೆ
19th, okay. 19th. Okay. 21st can't be done, no, it is Saturday. So, 7.
serial number 20
sir.
Okay, 19th I
Sir,
can take, no?
31. Serial number 31.
9. Yeah, 19th, I will take 19.
Sir, serial number 38, sir, on date kodi.
So, serial number 31.
43 NL, sir.
Court officer, sir.
34, sir. Serial number 31.
34 cyber credit.
ಐತೆ ಬರ್ತದೆ ರೈಟ್ ಸೈಡ್ ಶಾರ್ಟ್ ನಂಗೆ 19ಕ್ಕೆ ಹಾಕಿ
19
ನಿಮ್ದಲ್ಲ
ಅಯ್ಯೋ
25ಕ್ಕೆ ಹಾಕಿ 25
43 sir.
Sir, 38, sir.
24 ತಗೊಳ್ಳಿ.
Sir, 31.
Classification will depend.
Sir, 31.
34 on that.
17, 18 and 23, don't take.
18 ಆಗಿದೆ.
And 23, don't take any other date.
23 ಮಾಡೋದಿಲ್ಲ ಅವರು. RHS ಗುರುವಾರ ಶುಕ್ರವಾರ.
34?
Sir, 43.
Sir, 31.
34 ಹಾಕಿದ್ವಿ.
Sir, 31.
Sir, 43.
ಅಯ್ಯೋ
26 9.
Sir, 31.
34 ಎಷ್ಟು ಹಾಕೋದು?
ಅದು ಇಲ್ಲದ್ರೆ ಹಿಡಿದಿರುತ್ತೆ ಕಷ್ಟ ಆಗುತ್ತೆ
Sir, serial number 35, sir.
ಬರ್ತಾರೆ
34.
35.
ಯಾಕೆ ಸರ್?
Sir, 38, sir.
31. Sir, 31.
ಈಗ ಯಾವ ಡೇಟ್? 26 ಒಂದಾ?
35 ಯಾವತ್ತು sir?
ಯಾವ ಡೇಟ್ ಹಾಕಿರಿ ಸರ್?
26.
26 ಒಂದು.
Sir, 31. 31.
Sir, 35 ಯಾವತ್ತು?
Sir, 31.
Serial number 37.
Sir, 31. Sir, 26 ಬೇಡ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅದಾದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಬಂದು ಈಗ ಬಂದೆ
Sir, 31 ಅದಾದ್ಮೇಲೆ 31 60 26 9 ಬೇಡ ಸರ್. 31 26 ಮೇಲೆ ಕೊಡಿ ಸರ್.
ನಿಮ್ದಲ್ಲ
Sir, 31, 26 ಮೇಲ್ ಕೊಡಿ sir. Sir, 30. Sir, serial. Sir, serial number 31, 26 ಮೇಲ್ ಕೊಡಿ sir. ಅಲ್ಲ, ಅದ್ಮೇಲೆ, ಅದಾದ್ಮೇಲೆ. ಅಲ್ಲ, 30th ಮೇಲೆ. 27, 26, 26 9 ಅಲ್ಲ? Okay, thanks. 26.
ಸರ್ 32 serial number ಸರ್. ಸರ್ 32. 26 ಸರ್.
Serial number 37. Serial number 37.
ಆಕೆ ಆಯ್ತು ಇವ್ರು ಹೇಳಿದ್ರು ಪುನಃ ಇನ್ನೊಮ್ಮೆ ಕನ್ಫರ್ಮ್
Date ಇಲ್ಲ.
ಜೊತೆ ಮಾಡಿ ಸರ್ 41
ಸರ್ 38 ಕೊಡಿ ಸರ್.
41 ಸರ್ ಈಗ ಅವರೇ ಶೆಟ್ಟಿ 41 ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರು ಬರೋದು ಅಲ್ಲ ನೀವಿಲ್ಲ ಕಾಣುತ್ತೆ ಇವ್ರು ಇದ್ದಾರೆ ಆನ್ ರೆಕಾರ್ಡ್
ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಅಪಿಯರಿಂಗ್ along with me ಕೊಟ್ಟಿರೋದು.
So
ಅದು
serial
ಎಲ್ಲಿ
number
ಓದುತ್ತೆ
31.
ಎಲ್ಲ ಬಿದ್ದಿದೆ.
ಸರ್ 38 ಯಾವ ಡೇಟ್ ಕೊಟ್ರಿ ಸರ್? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್.
ಸರ್ 41 ನೆಕ್ಸ್ಟ್ ವೀಕಾ?
31 sir, 31.
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್
38. 38 ಕೇಳಿ ಸರ್.
ನೆಕ್ಸ್ಟ್ ವೀಕು
ಸರಿ.
Sir, 31 sir.
ಸರ್ ಸುಮ್ನೆ ನಗ್ತಾ ಇದ್ದೀರಾ ನೀವು?
ಹೇಳ್ಬಿಡಿ ಸರ್
Speak madam.
ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಓಕೆ ಸರಿ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಸಾಹೇಬ್ರ ಹೆಂಗ